Testing, but
Testing 1, 2. I was going to take it back over there.
What do I need to do to turn it on?
It's on. Ryan, Butler to 36, Butler to 8, Carter, Kaufman, Chazanov, Chisholm, DeBar, Delano, England, Fillingane, Frazier, Harkins, Hickman, Hill, Hobson, Horn, Jackson, Johnson, Jordan, Kirby, McCollum, McDaniel, McLendon, McMahon, Michelle, Moran, Norwood, Parker, Parks, Pope, Seymour, Simmons of the 12, Simmons of the 13, Sojourner, Spark, Suber, Tate, Thomas, Thompson, Turner, Ford, Whaley, Wiggins, Williams, Younger. Mr. President, a quorum is present.
Thank you, Mr. Clerk. Will the senators and the guests in the galleries please rise for the invocation given by Pastor Randolph Seals, Jr., the pastor of Greater New Kingdom Missionary Baptist Church in Cleveland, Mississippi. He's a guest of Senator Sarita Simmons. Senator Simmons will then give the Pledge of Allegiance. Pastor Seals.
O Lord, our Lord, how excellent is thy name in all the earth, who has set thy glory above the heavens. Even before the mountains were formed, thou art God. Lord, your children, the sheep of your pasture, we've gathered at this time in this sacred space you designated for service, God, standing as empty pictures in in front of a full running fountain, standing to give you thanks, give your name glory, for your word declares in all things we ought to give you thanks. For this is the will of God concerning us in Christ Jesus. Oh God, we thank you for your grace. We thank you for your love. We thank you for your mercy. We thank you for life, health, and the opportunity to serve. Praying, oh God, that you will get the glory out of our service, not serving for greed, not serving to push our own selfish agendas, but serving to be a blessing to this great state and her people. Lord, as we enter into this work day, God, we now remember your word as being a lamp unto our feet and a light unto our path. Lord, remind us that we are merely stewards, but you are God, and you're sovereign, and the government rests upon your shoulders. And as the Senate work together, call their minds that they are all children of God, and we are made in his image, or made in your likeness, oh God. Remind them that they are called to care for the less fortunate. Remind them that they are called to care for the sick. Remind them that they are called to make provisions for the children as well as the elderly. Oh God, for your word declares in Proverbs 29:2 that when the righteous increase, the people rejoice. But God, your word says when the wicked rule, the people groan. So God, we will not lean into our own understanding, but in all of our ways, we're going to acknowledge you. And your word will direct our path. God, your word also declares, blessed is the nation whose God is the Lord. And we trust you, and we trust your sovereignty, and we trust your word. God, bless and keep and sustain this state and her leadership. In Jesus' name, we do pray and count it done. Amen.
Amen.
Join me in prayer.
Thank you, Pastor Seals and Senator Simmons. Now the reading of the journal. Senator Polk, you're recognized.
Thank you, Mr. President. Move the Senate dispense with the reading of the journal.
Senator moves to dispense with the reading of the journal. All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Message and petitions, Mr. Clerk.
Mr. President, there are none.
Committee reports. Senator Polk, you're recognized.
Mr. President, move the Senate dispense with the reading of the committee reports.
Senator moves to dispense with the reading of the committee reports. All in favor signify by saying aye. Opposed, no. Now next to the reading of the titles of the bills and resolutions. Senator Polk, you're recognized.
Mr. President, move the Senate dispense with the reading of the titles of the bills and resolutions.
Senator moves to dispense with the reading of the titles of the bills and resolutions. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We'll go quickly to the introduction of guests. Introductions of guests. Senator Wiggins, you're recognized for introduction.
Thank you, Mr. President. As you can tell in the gallery, we have a lot of folks with us. Today, we welcome the family physicians, pediatricians, residents, and medical students from the Mississippi Academy of Family Physicians and the Mississippi chapter of American Academy of Pediatrics. If you would all please stand, and please remain standing. We also have with them, and before we clap, we have Miss Mississippi 2021 from Meridian, where's Senator Tate. She works with them as an ambassador for the Tar Wars program, and where she visits schools across the state educating students about being tobacco free. So thank you for being here. Please give them a round of applause.
Thank you. Senator Tate.
Thank you, Mr. President. Ladies and gentlemen of the Senate, if you'll direct your attention to the South Gallery, We have with us today, as already mentioned, Miss Mississippi, Miss Holly Brown. But on behalf of Senator McConn, Senator Younger, and Senator Hickman, I'd like to also introduce Miss Haley Frederickson. If you'll stand up, she is the Miss Rodeo 2022. And also Miss Lila Murphy, she is the Miss Dixie National 2022. If y'all will, please give them a round of applause.
You can come back down to the floor now, Senator. Senator Simmons.
Thank you, Mr. President. I would like to introduce a great friend of mine and a friend of my pastor, Randolph Sears. Monica Allen is sitting here in the North Gallery. Would you please stand up, Monica? And we welcome you to the Senate. Thank you.
Thank you. Senator Barnett, you're recognized for an announcement.
Thank you, Mr. President. Ladies and gentlemen of the Capitol, if you would direct your attention to the North Gallery. I would like for my brothers and sisters in arms at my the CWA local unions here in Mississippi to please stand. Let's make them welcome to our state capitol.
Thank you. Thank you, Senator. Welcome. We're glad you're here. Working people. Senator McMahon, you're recognized for announcement.
Yes, sir. I have two guests today, Mr. President. I'd ask the senators to look in the West Gallery. I would ask for Sydney Franks to stand from Saltillo, Mississippi. I would ask all the senators to make her feel welcome. I have a second one. Also, on behalf of Senator Sparks, Senator Parks, Senator Chisholm, Suber, Brian, and myself, and Senator Angela Turner Ford, we would like to welcome the Doctor of the Day from North Mississippi Medical System, Dr. Vernon Rayford, over at the smokers table. I would ask my colleagues to please give them both a warm Senate welcome.
Thank you, Senator. Senator England, you're recognized for an announcement.
Thank you, Mr. President. I'd like to ask my colleagues in the Senate to help me make welcome my brother-in-law who's visiting today, Timothy Brewer. Glad you're here, Tim.
Senator Sparks, you're recognized.
Thank you, Mr. President. In the West Gallery, I would ask Dr. Nathaniel Sparks to please stand. Proof there are smart Sparkses from Tishomingo County. Make him feel welcome. Thank you.
Thank you, Doctor. Thank you for coming. Senator Hobson, recognized for an announcement.
Thank you, Mr. President. I've got a few announcements. First of all, we've got two doctors from Warren County that I think are here in the gallery. In the West Gallery and also in the North Gallery, we have Dr. Carlos Latorre and Dr. Randy Easterling from Vicksburg, Warren County. I would ask that my Senate colleagues make them welcome here today. Additionally, Mr. President, we've got a good friend to Mississippi, somebody that used to work this floor for many years with Governor Bryant, Mick Bullock, and most of you have on your desk a proposal to come to the NCSL Summit in August of this year in Denver. And Mick is currently serving as the Director of Public Affairs for NCSL, and it's so good to see him back in Mississippi and helping our state with all the affairs related to NCSL. So let's give a big warm welcome back to Mississippi for Mick Bullock.
It's good to see you, Mick. Welcome home. Okay, any other announcements? Other announcements? Seeing none, we'll go on to the calendar. Start with appropriations. Number one, Chairman Hobson. Chairman Hobson passes on 1 and 2. Chairman Harkins on finance. Chairman Harkins is recognized. We'll go to number 3.
Thank you, Mr. President. I'd like to skip item 3, have it retain its place on the calendar, go to item 4, Senate Bill number 2831, and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2831, Sales and Use Taxes. Bring forward code sections for purpose of possible amendment.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed,
Aye.
no. The ayes have it. Please proceed.
Thank you, Mr. President. I'd like to recognize Senator Johnson to explain the bill.
Senator Johnson, you're recognized to explain the bill.
Actually, Mr. President, I move to adopt the committee sub and ask recognize Senator Johnson to explain the committee sub.
You're recognized to explain the committee substitute.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2831 is an attempt to modernize code for software legislation or for software taxation. Currently, or the way the practice has been, is that software that does not reside in the state of Mississippi is not subject to sales tax. Because software has changed so much over the years, it's important to codify it, to be clear on what those definitions are. The committee substitute actually put in a reverse repealer because different businesses in the state are working with DOR on exactly how those definitions should be. But in a nutshell, it's if the legislation, if the actual software does not reside in the state of Mississippi, it is not subject to sales tax. And that's an explanation of the committee sub.
Explanation. Any questions? Questions? Seeing none, we're ready for your motion on the
Move
committee.
adoption of the committee substitute.
Adoption has been requested for committee substitute. All in favor signify by saying aye. Opposed, no. The ayes have it.
Move final passage using the morning roll call.
Final passage has been requested for use of the morning roll call. Anyone object to the procedure? Mr. Card is voting no. Present. Seeing none, the bill passes. Thank you, Senator Johnson. Senator Harkins, item 3 remains as placed on the calendar on item 5.
I'd like to skip item 5 and have it retain its place on the calendar.
Retain its place on the calendar. We'll go to rules. Chairman Kirby. Chairman Kirby.
Thank you, Mr. President. I'd like to call up items 6 through 51 in block, if no objection, and ask the title to be read.
I got it. Okay, Chairman Kirby has requested items, does any senator want to set aside an item on the calendar and block? Anyone want to set aside the calendar in block, and it runs from 6 through 29?
51.
To, well, I'm still turning, to 51.
Thank you, Mr. President. Ask the title to be read.
Anyone want to withhold? Anyone? Okay. All in favor signify by saying aye. Opposed, no. The ayes have it. We're ready, ready for your motion to have it read, Chairman Kirby.
Thank you, Mr. President. On items 6 through 51, if you'd please read the titles.
Mr. Clerk, please read the titles.
Senate concurrent resolution number 512, remember legacy of former prisoner of war and retired Air Force Colonel Carlisle Smitty Harris at U.S. Post Office dedication in his honor. Senate concurrent resolution number 513, commend William Bill Bynum, CEO of Hope in Jackson, Mississippi, as recipient of 26 Heinz Award for the Economy. Senate concurrent resolution number 515, commend Mississippi Alabama Sea Grant Consortium on its 50th anniversary and recognize its achievement. Senate concurrent resolution number 516, recognize March 2022 as Kidney Disease Awareness Month. Senate concurrent resolution number 517, extend sympathy of legislature to surviving family of former mayor, attorney, and blues promoter Bill Luckett of Clarksdale. Senate concurrent resolution number 522, celebrating the legendary Mississippi basketball coach Lafayette Stribling and extending the sympathy of legislature. Senate concurrent resolution number 525, commend James A. Barber on the occasion of his retirement as Executive Director of PEER. Senate concurrent resolution number 530, celebrate life and commend military service of Bridget Rochelle Horn. Senate concurrent resolution number 532, commend University of Mississippi quarterback Matt Corral for leading team to best regular season in program history. Senate concurrent resolution number 535, recognize the Williams brothers as the recipient of the 2022 Governor's Arts Award for Lifetime Achievement in Music. Senate concurrent resolution number 536, recognize Larry Gordon as the recipient of the 2022 Governor's Arts Award for Lifetime Achievement in Motion Pictures Television. Senate concurrent resolution number 537, recognize Holly Lang as the recipient of the 2022 Governor's Arts Award, Governor's Choice. Senate concurrent resolution number 538, recognize Mary Lovelace O'Neill as the recipient of the 2022 Governor's Arts Award for Excellence in Visual Art. Senate concurrent resolution number 539, recognize Alcorn State University Jazz Festival as a recipient of the 2022 Governor's Arts Award for Arts and Community. Senate concurrent resolution number 540, recognize Myrna Colley Lee as a recipient of the 2022 Governor's Arts Award for Costume Design and Arts Patron. Senate concurrent resolution number 541, recognize January 2022 as Cervical Health Awareness Month in Mississippi. Senate concurrent resolution number 542, recognize the legacy of former Northern District Transportation Commissioner Jack Stewart. Senate concurrent resolution number 543, extend sympathy of the legislature on the passing of 3rd District Circuit Court Judge Robert Ken Coleman of New Albany, Mississippi. Senate concurrent resolution number 544, commend Olympian Corey McGee of Pass Christian for track and field accomplishments at 2020 Tokyo Olympics. Senate resolution number 3, commend Jackson Prep Patriots baseball team for winning MAIS 5A state baseball championship for 4th consecutive season. Senate resolution number 4, commend Mississippi Insurance Department employee Nancy Cross for 63 years of service. Senate resolution number 5, commend Brandon High School Lady Bulldogs volleyball team for winning 6A state championship. Senate resolution number 7, congratulate Nakobe Dean, offensive line for national champion Georgia Bulldogs football team from Horn Lake High School. Senate resolution number 8, commend Brookhaven High School Panthers boys cross country team for 3rd consecutive state championship. Senate resolution number 9, commend Pearl High School Pirates boys track team for winning MHSAA state 6A championship. Senate resolution number 10, recognize sports and civic legacy of Coach I.D. Reddy Sr. of Richmond, Mississippi. Senate resolution number 11, commend Brookhaven Academy Lady Cougar softball team for MAIS 5A state championship. Senate resolution number 12, commend Lloyd Star High School Hornets golf team for winning MHSAA Class 1 state championship. Senate resolution number 13, pay tribute to the civil rights legacy of Reverend Dr. Charles Johnson Sr. of Meridian, Mississippi, and extend the condolences of Senate. Senate resolution number 14, celebrate the life and commend civic service of Marvin Hogan of Jackson, Mississippi, and extend condolences. Senate resolution number 15, celebrate the life and commend civic and business leadership of Carol V. Hood of Hazelhurst, Mississippi, and extend condolences. Senate resolution number 19, mourn the passing and commend service of Randy Tate, Executive Director of Boys and Girls Club of Pike County. Senate resolution number 20, congratulate South Panola High School cheerleading team for 2nd consecutive national championship. Senate resolution number 21, congratulate Brandon High School cheerleading team for national championship. Senate resolution number 22, recognize Bishop James Edward Swanson Sr. on his tenure as resident bishop of the Mississippi Conference of the United Methodist Church. House concurrent resolution number 1, Gary Jude Harkins, commend life and legacy upon his passing. House concurrent resolution number 11, Lieutenant Toby Johnson, commend for service during Hurricane Ida. House concurrent resolution number 12, firefighter Lion Tucker, commend for meritorious service. House concurrent resolution number 13, Samuel Larry Ritchie, commend his life upon his passing. House concurrent resolution number 14, Vietnam War veterans, recognize and honor those exposed to Agent Orange. House concurrent resolution number 15, Mr. George Smith, commend his life and legacy upon his passing. House concurrent resolution number 17, Carol V. Hood, commend life and legacy upon his passing. House concurrent resolution number 33, James A. Barber, commend service as Executive Director of PEER upon his retirement. House concurrent resolution number 43, Scott Central High School football team, commend and congratulate upon winning Class 2A state championship. House concurrent resolution number 44, Ole Miss Rebels all-girl cheerleading team, commend and congratulate on winning 2022 UCA Division 1A Game Day National Championship. House concurrent resolution number 45, Ole Miss Rebels women's golf team, commend and congratulate upon winning 2021 NCAA Division I National Championship.
Thank you, Mr. Clerk. Senator Kirby.
Thank you, Mr. President. That's request the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Kirby.
Thank you, Mr. President. Ladies and gentlemen, Senate, as you can see, they all were or are very qualified to be recognized by the Senate. Resolution, if there are no questions asked, use this morning roll call. Final
Questions?
passage.
Any questions? Seeing none. Chairman has requested utilization of the morning roll call. Does anyone object to the procedure? Wish to be recorded as voting no. Present. Seeing none, thank you. Senator Kirby. We go to 52, Chairman Polk. Pass. 53. Pass. Chairman Barnett. Chairman Barnett on 54.
Thank you, Mr. President. I will ask that we table the motion to reconsider. I'm sorry, Mr. Chairman, if you call up item number 54 on today's calendar, Senate Bill 2275, and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2275, Pilot Work Release Program, Extend Repealer.
Thank you, Mr. President. Senator, make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. I ask that we table the motion to reconsider, and if you will also allow Senator Wiggins to speak on it.
Senator Wiggins, you're recognized to speak on.
Thank you, Mr. Chairman, Mr. President. I held the bill on a motion to reconsider. I support tabling the motion. It had Jackson County in this bill, Senator England, Senator Seymour, and myself. Interestingly, we're not aware of that, and for whatever reason, well, we weren't aware of it, so the chairman has told me that there's a reverse repealer in it, so that's good. We're going to send it on to the House. So vote to table the motion to reconsider.
Thank you. We're ready for your motion, Senator.
Thank you, Mr. President. I ask that passage up on the morning roll call.
No.
Just table the motion.
That's right. Moves to reconsider the vote by which the bill passed. All those in favor, I'm sorry, to table the motion.
God damn it.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Chairman Fillingham. Chairman Tate.
Thank you, Mr. President. I'd like to go to item number 56, Senate Bill 2606, and ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2606, Statewide Elections Management System, provide for voters' proof of citizenship.
I move that we table the motion to reconsider.
Moves to table the motion to reconsider. Questions? Seeing none, all in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Thank you, Senator Tate. Chairman Barr.
Thank you, Mr. President. Call up item 57, have the title read.
Clerk, please read the title.
Senate Bill number 2425, State Superintendent of Public Education, IHL Commissioner and Director of the Community College Board, set maximum salaries.
My motion is we table the motion to reconsider.
Motion to table the motion to reconsider. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Thank you, Senator Barr. Senator Wiggins, 58.
Thank you, Mr. President. I go to item 58, call that up, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2643, divorce, authorized where marriage is irretrievably broken.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. Ladies and gentlemen, this is, from a language perspective, this is a simple bill, but it's also a bill that's been asked for by many people in this state. This is coming to us from the task force that we voted for last year, the Domestic Law Task Force. And I wanted to, what the bill does is creates a 13th ground for divorce. Now, it's titled Irretrievably Broken. And I wanted to read to you, and you see it on the screen there, from the task force that studied this. And this task force that we set up had chancellors, lawyers, judges, Supreme Court, Court of Appeals judges, who looked at this, and as I've told you before, spent a lot of time on this task force. And this issue's come before this body and the legislature before, and I just want to read the reasonings from the task force that they gave us as to why this bill is necessary. The reasons for these recommendations are compelling, particularly to those who see firsthand the destruction caused to family units by Mississippi's restrictive divorce laws. The current system, perhaps originally designed to preserve marriage, does not accomplish that today. Instead, it damages individuals and families, eats up scarce state resources, and prevents parties from establishing personally and financially secure households. If you're a practitioner, like a chancellor or lawyer, you know what they're talking about. The word weaponized was used in describing our divorce laws. And so what this bill before you represents is the 13th ground for divorce, termed irretrievably broken. And in short, starting at line 108, upon application of either party, the court may grant a divorce when the court finds there's been an irretrievable breakdown of the marriage. To put it in a legal term, it's a very low standard and either party can file it. Now, there was just going into the task force, there was discussion about a no-fault divorce. This is not a pure no-fault divorce ground. In the task force report, they gave a recommendation as to a pure no-fault divorce. We are not coming forward with that. In Mississippi, marriage, we support, obviously it's a sacrament, the sanctity of marriage, but the reality is, as the task force says, the laws that we have today are hurting our families and really our children. And then the other issue in the bill is the other recommendation from the task force. If you could put the other page up there. The task force further finds that the language of the existing fault ground of desertion is too restrictive and should be amended to remove willful and obstinate. That will allow a non-deserting party to obtain a divorce from a clearly broken marriage after the continued desertion for the space of 1 year. So that's removing the willful and obstinate, which in legal terms, that's a very high standard. And, but the ground of desertion is still there, and that requires a 1 year absence, if you will. So with that, I'd be happy to answer any questions, Mr. President.
Thank you. We'll have questions. Senator Norwood, for what purpose do you seek recognition?
Question, Mr. President.
Will you yield, Senator?
Yes.
Please proceed, Senator Norwood.
Thank you, Mr. President. Thank you, Senator Wiggins. Senator Wiggins, so this, what we're recommending now makes it easier for individuals to get a divorce.
It does. It adds a 13th ground, and based on the legal standard, it is easier to get a divorce. If this becomes law, it can be pled into court like any of the other grounds, and it centers around the legal standard, and that's irretrievably broken. This language is modeled after Alabama, and the task force looked at many different states and felt that this language was best, and Alabama and Mississippi have a lot of similar things, so that's why we went with that.
And I listened at the individuals that participated on the task force. Were there any ministers or any marriage counselors involved in that process?
I don't know that that was the requirement. Some of them may have been in their own churches, but I don't, not specifically know.
I mean, but we're talking about marriage, we're in Mississippi, and we promote marriage and we promote family.
We do.
And now we're going to make it. Now we're going to make it easier. I mean, you know, 37 years. I know I've had some challenges, but it makes, you know, we don't need to make it easier for our folks, because we don't need to make it easier for folks to walk away without giving a marriage a chance. You would agree with that, right?
Senator Norwood, let me say this. I've been married to my wife for 22 years. I am proudly married. I encourage anybody to walk into a chancery court and see what goes on in chancery court and the destruction of our children that goes on with our divorce laws. And that's what our task force was saying. So I actually think that it is better that the children will be better. And I've actually seen many cases where the two parties actually get along better once separated. In fact, I can think quite a few. And so I guess the answer to your question is no. I think the task force looked at this, and you had people from all across the spectrum were looking at this, and the word weaponized, and you can come into court and you can see where literally for no other reason a person refuses to divorce because they want money. They want money or retirement. Not because, and the marriage could be completely gone, but they're not agreeing to a divorce because they want money. And no, I don't, in the eyes of God, as somebody who goes to church every Sunday, who's been married for 22 years, no, I don't think that that's right, and I think this is the better way to go about it.
So are you saying that in terms of children, the record basically, statistics would show that children are best served when there are two parents.
Correct.
Two-parent homes. And yes, I'm familiar with situations where parents of a child get along better outside of the marriage, but I just can't see how this is going to help the environment that we're in now with a single parent raising a child, or a shared parent raising a child.
I think to answer your question, Senator Norwood, there are marriages that are so destructive on the children that it is not best to have those two parties there. And I can go down a litany of cases that I personally have seen. I think any attorney who's a legislator can tell you that. And no, there are situations that it is not the best interest of the children. By the way, that's the standard. It's not the best interest of the children that those two parties, for whatever reason, remain simply under the laws of the state of Mississippi. And that is not what I think God wanted, and I'm happy to say that. And I think that just like the task force said, there may have been a time that was appropriate, but it's time that we caught up with that.
And I guess my concern is, do you have any reason why faith counselors or marriage counselors were not involved in the task force? I counsel young folks regarding marriage, but I see the same thing. I'm not a lawyer, not a judge, don't set out to be one, but I see the same thing in those environments that you all see in the courtroom. And my argument would be just the opposite. But anyway, that's not a question. Thank you, Senator Wiggins. Thank you, Mr. President.
Thank you.
Thank you, Senator Norwood. Senator Butler passes. Senator England. Senator England, for what purpose you seek recognition?
Question, Mr. President.
I yield. Please proceed, Senator England.
Senator Wiggins, the task force that I had a chance to listen to the report on, if I recall correctly, was this their number one recommendation of the task force that met over this past year?
Yes, it most definitely was. And they say that in their report.
And the task force was unanimous in their recommendation of this change to Mississippi law?
In fact, the very first sentence of the report, and by the way, there were at least four issues that they were tasked with looking at. They say one topic at the outset garnered the task force immediate and pointed interest, no fault divorce, and Mississippi's treatment of the same. The issue's complicated, and they go on to say, but the task force recommends immediate legislative amendments to provide relief to Mississippians who are faced with divorce.
Thank you, Senator Wiggins. Just one more quick question. I'm a co-sponsor of this bill, is that correct?
I hope so, yes. Yes, you are.
Okay, thank you. I just wanted to, as a co-sponsor, I wanted to make sure for anybody listening at home that I think this is a good bill, but I don't intend to use it. Thank you, Senator Wiggins.
Thank you. I bet your wife is happy about that.
Maybe not. And Senator Boyd.
For a question?
Yes,
Yield for a question. Please proceed, Senator.
Senator Wiggins, Senator Norwood brought up some points. I'm also, I think, a co-sponsor in this legislation, I believe. But the situation that he's talking about, when this would be contemplated, these families are at a very different point than really Senator Norwood is talking about. Isn't it true, and there was lots of testimony and there was lots of discussion by these chancellors who have dealt with this over the years, that this is at a situation where this is an irrevocable situation. These families are not going to get back together, but yet we use the laws that we have in place right now to actually hurt these families and further pull these families apart. So there's no healing that's done or anything like that. We continue to use the laws that we have as weapons to further pull these families apart, to further, many times it hurts them both financially and economically, sometimes really adversely to one particular party or another. And so families and children are further pulled apart when there can be no healing on these matters.
That's correct. And like you said, hopefully the spiritual guidance would have come way before this, and that's contemplated, and the courts can even allow that. And what is also needs to be recognized is this is, like I said, a standard, irretrievably broken. You still have to go into court, just like all the 12 other grounds, and the judge still has to find that it's irretrievably broken. If the judge doesn't find that, just like under the current laws, that if he finds that adultery didn't occur, he or she can't grant the divorce. So it's what I would call a number of backstops that are in there. But to your point, yes, the counseling and the guidance, this is way beyond past that, and in essence a last resort, as most of our divorce laws are.
Thank you, Senator Wiggins.
Thank you.
Okay, thank you, Senator. Senator Hickman, for what purpose you seek recognition?
Question, Mr. President.
Are you for question, Senator?
Yes, I do.
Please proceed, Senator.
Thank you, Mr. President. Thank you, Senator Wiggins. Just a couple of quick questions. This law does not make a divorce an automatic thing. It still leaves our chancellors as our gatekeepers, who we've always left as our gatekeepers for divorce in this state, correct?
That's correct.
And on top of that, this is not the most liberal standard that we could see across the nation. There are a lot more things we could do. This is pretty much just a half step that's going to help families, it's going to help people who are trapped in marriages, who I've had clients who've been separated for 16 years and can't get a marriage because of the laws. This will help situations like that.
It most definitely will. Where you're not California or New York, this law is based on Alabama, which is a sister state. And to your point, people 16 years and they can't get a divorce for the reasons that I've said. And it, as the task force said, it destroys families. And the reality is, what I'm sure you see and others have seen, is that there are some families that are actually a better family unit when those two parties are separated or divorced.
I'm a Mississippian, and I think this is a good law. I think it's going to help a lot of people. Thank you for the work that you've done on this.
Thank you.
Senator Carter, you have a question?
Yes, yes, Mr. President.
You yield, Senator Carter.
I do.
Senator Wiggins, as a single father with custody of my kids, this is a very, very good bill. And the question I have for you is the 60-day requirement still in effect?
So that was brought up. The short answer is this doesn't affect the irreconcilable differences standard, which is you have to have 60 days on that. This is an alternative ground. This is the task force recommended an alternative ground. So it doesn't affect that 60 days. But the standard is, so I would call it a very low standard, that the incentive is to work that out and get this done for the benefit of the children in particular and the family together.
I will tell you, it definitely affects the kids the longer that these things play out and the longer that these parents do not get along. So I appreciate your work on this bill.
Thank you, Senator Carter. Appreciate your support.
Senator Fillingham, do you have a question?
Yes, Mr. President, I do.
Do you yield to Senator Fillingham?
I do.
Senator Fillingham.
Thank you, Mr. President. Thank you, Mr. Chairman. Just a practitioner type question. So on this particular ground, are y'all saying this is more along the lines of the fault ground where just one party can file this as a basis for the divorce, and then the chancellor still has to go through and do the property settlement division of everything? So this is not, I guess I'm trying to understand that procedure. So this is not like an alternative to the no-fault divorce where the parties would have to work that out ahead of time. This is more akin to a fault-based divorce where one party alleges that the marriage is irretrievably broken, and then the chancellor would still have to go through all of the Ferguson factors or whatever and figure out who gets this and who pays what. Is that right?
That's correct. The law in Mississippi is you are not finally divorced until there's a ground that's been certified and the property has been divided. This does not affect the property. You still have to go through that. And in fact, in the language of the bill, line 108, it listed as a 13th ground. If you remember, well, it doesn't affect that, correct?
So no fault is going to be left alone, and you still have that option if the two parties want to work out a property settlement agreement that they would submit to the chancellor together. This merely says in the cases where that is not possible because one party or the other isn't willing to negotiate in good faith, then one party will not be held to ransom in this process and can force the divorce piece, and then the chancellor will hear the evidence and testimony required for the property and child custody and all that division.
Yes, from a practitioner standpoint, when you went into court, if once this becomes law, you would simply plead that as an alternative ground, and then for the reasons that you're talking about, you could go forward on this ground, and as the language states, the judge would have to find there's been an irretrievable breakdown of the marriage and that further attempts at reconciliation are impractical or futile and not in the best interest of the parties or the families. And that goes to, I guess, Senator Boyd's point, is that we're at it's that point where there's no other situation and they're being held hostage in the marriage.
Right. Okay, and so that is an evidentiary-based situation where the chancellor, if the other party wants to come into court and contest that that's not the case, they still are able to come in and make their case to the chancellor to say that it's not irretrievably broken, that there still is an opportunity to reconcile and to counsel and these sorts of things, correct?
That's correct.
All right. And then on the abandonment portion, the only thing you're changing on that, currently the law says the one who did the abandoning can't use that ground, only the one who was abandoned. And what you're suggesting is that either party, the one who did the leaving or the one who got left, can plead the abandonment after they've been separated for a year or more.
That's correct. The current law is in addition to the abandonment for a year, you have to prove willful and obstinate. That language is, but that's that's the higher standard. And I would actually argue that maybe if you've abandoned for a year, it is willful, but that's not how it's being applied. So that's why the task force recommended those things be taken out.
And did that take into consideration constructive abandonment as well, where the parties are still under the same roof, but one's on one end of the house and the other's on the other? You can still use the abandonment ground, as it were, for either party in this change to the law.
Sounds like you're a good practitioner. I think that...
well, I'm not married, so...
right, I'm not... I would have to go to the case law on that, but I think that would be correct, yes.
Okay, thank you, Mr. Chairman.
Okay. Senator Parker, for what purpose you seek recognition?
Question, Mr. President.
Yes, Senator.
Yes.
Senator Parker is recognized.
Thank you, Mr. Chairman, for your work on this. always get confused when all the attorneys stand up and they have all these questions.
That means it's a good bill.
So I like to kind of put it into words that are easier for me to understand. I have gotten some emails over the concern of marriage on this. I want to mention a specific example that I know of and get your opinion on if it would help that. Many years ago, I had a good friend of mine who went separated from his wife. They were not divorced for 11 years. They went through the process for 11 years. During that 11 years, they couldn't reach any settlement. They both moved on. They had another person come into their life. They had new families that were started. So each of them were living totally separate lives with a new family. And that created some confusion for the families, because the new families going on wondered, why is our new family not a marriage family? In two instances like this. And the original marriage was over, but the grant of the judgment was never issued. And so I've gotten a lot of emails kind of asking me if we're doing something to destroy marriage. But in that example, are we in some ways doing things to actually preserve or restore marriage in that scenario? So could you comment on that too?
Senator Parker, my answer is 100% yes to your question. In fact, the scenario that you've given, I think, is sadly somewhat common. And what you described, that means there's no ground. There's not been adultery. There's not been cruel and inhuman treatment. It's just broke. It just doesn't happen. And that is the situation. And so I would argue that your scenario, that person could say it's irretrievably broken, and I would say if they've gone on with their lives and they've done that and it's causing problems within the kids, then yeah, it's irretrievably broken, and they can move on and they can actually probably have a, quote, a better life on that. So yes, I think that 100% fits that. And it's sad that it goes on for 11 years and the law prevents that from them going on.
Right, and to one of your original points you made on this in the scenario I just outlined, the reason for that was 100% financial. This was two people who had, nice separate businesses, man and woman, and they couldn't get they couldn't get to a point where they could, come up with a solution there. So this is a difficult issue. If you look at it just immediately, you kind of want to follow one side of the issue. If you look at it in the long term, you want to follow on the other side of the issue. So I appreciate you bringing these instances up. I appreciate Senator Carter's comments on it because this does affect a lot more people than we realize. So thank you, Mr. Chairman.
Thank you, Senator Parker. And I've had a constituent who called me and explained exactly the same situation, and they're frustrated, and just like Senator Carter said, it affects the whole family. And I would not stand up here and present a bill to this body that I didn't think was pro-family. And certainly, I think in some ways maybe we're recognizing some of the issues and we're catching the law up to where people are. But I think it's actually a very pro-family bill based on the scenario that you've given. And I have no qualm standing up here honestly, as somebody who's been married for 22 years and presenting this, because I think it's about the family and in particular the kids, and they're the ones who we must think about first. Thank you.
Thank you. Any further questions? Any further questions? Seeing none, Senator, we're ready for your motion.
Move passage on the morning roll call, Mr. President.
Move for passage on the morning roll call. Anyone object to the procedure? Wish to be recorded as voting no? Chisholm, McDaniel, Polk, Williams, Michelle, Norwood, McClendon, Hill, Tate, Seymour. Anyone else? DeBar. Where? Branning. Sparks, present. McMahon? No. Anyone else? Anyone else? Frazier, present. Anyone else present? Anyone else? Okay. I'm sorry, Barnett? Present. Jordan? No. Jordan, no. Anyone else? Anyone else? Okay. Mr. Clerk, would you add those up for me, please? Chairman Bryan. Chairman Bryan, you're recognized. Chairman Bryan? Passes. Chairman Fillingham, we're on 60.
Mayor.
Chairman Fillingham.
Thank you, Mr. President. I'd like to go to item number 60, call it up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2231, DNA samples collected from person arrested for any felony and provide for destruction of samples only upon expungement requests.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
If you'll recognize Senator Wiggins for the handling of this bill.
Senator Wiggins, you're recognized. Senator Branning? For what purpose?
I wanted to speak to the vote on the previous bill. I didn't hear the names called. I wanted to be sure that I'm down for present, for having voted present on that bill.
One moment. She is. You are, Senator. Thank you. Present from Branning. Okay, Senator Wiggins.
Thank you, Mr. Chairman, Mr. President. Simple bill. The current law in the state of Mississippi is DNA is collected on violent offenses that is put into the database that is used to determine crimes and also exoneration of individuals. What this bill does is simply extends the current law to non-violent offenses. So those in 9732, they don't apply. This doesn't apply to misdemeanors. That's what the bill does. So happy to answer any questions.
Questions on the bill? Questions on the bill? Senator Simmons, D. For what purpose you seek recognition?
Question, Mr. President.
Are you for a question, Senator?
Yes.
Please proceed, Senator Simmons.
Thank you, Mr. President. Thank you, Senator, for yielding. Didn't we pass a law a few years ago that would allow DNA collections on violent felonies?
On what?
On violent arrests?
Yes, on violent arrests. Yes,
Okay.
that was Katie's law, and that's what the current law is.
And so the current law is that upon an arrest of a person who's been accused of a violent crime, the DNA is collected.
Correct. And this law, that current law is in 30-something states, and that law has been upheld by the U.S. Supreme Court about 4 or 5 years ago.
And so the proposal before us, Chairman Wiggins, will expand Katie's law, correct?
Correct. It will expand it to the nonviolent offenses. That's correct.
And so what we would essentially do upon any felony arrest, DNA would be collected.
Yes, it would. But as many of you have heard, the benefits of the DNA is, one, it helps locate folks who may have been involved in a crime under the constitutional standards that we have. Second, it also exonerates people who may be charged with a crime. And I'm talking years later. So it actually, if you support improving the criminal justice system, which I certainly do, then you support this bill because DNA is becoming, I guess, the gold standard in the criminal justice system. The Innocence Projects use DNA all the time. I say all the time. They use DNA to, I guess, correct wrongs from previous instances. So it's a way that can improve our criminal justice system.
Do we know the costs associated with maintaining DNA for all arrests in all 82 counties in the state of Mississippi?
No, but it's already done, and the federal, it goes into the CODIS database, and I'll be honest, there's quite a few laws from the federal side, and this mirrors a federal law too, that requires agencies to do that anyway, to keep the database. And in terms of the actual cost, there's not much cost. Remember, we're just talking about a swab that gets sent to the crime lab, which they're already doing.
And one last question. So a person who may have a drug problem, who commits a non-violent property offense because he or she is suffering from a drug addiction, and may very well end up going to one of our drug intervention courts. When that person is arrested, his or her DNA will be collected.
Your question is, will it be collected?
Based off
If it's a felony, but as many of you heard from the ladies, and it was Katie's mom who was here, who this law's been named after, it was a nonviolent offense that DNA was collected and led to, actually it was Ms. Spence's crime, where she had been raped. And if that, as it was said then, California surprisingly has this law, and they've been able to get to the bottom of the crimes and solve those cases that we wouldn't here in Mississippi.
And Chairman Wiggins, we're not trying to change the existing law as it relates to violent offenses. So what we did with Katie's law regarding murder, regarding rape, aggravated assault, violent felonies, that's already in the law, and that went through this deliberate body several years ago. But the proposal before us, as I understand it, will, if it becomes law, on all felony arrests, which will include non-violent arrests, we will be collecting DNA. That's the only concern.
We are not changing anything dealing with violent offenses. All it is about the DNA collection on the arrests.
On all felonies.
On all felonies, that's correct. Does not include misdemeanors.
Thank you. Thank you, Mr. President.
And I should say that if it's collected and it turns out fine, then there's a procedure that you can, it gets expunged, not only expunged, but deleted and gone away, and there's no identifying information.
Well, one question in response to your last answer. But you have to actually file a petition to get your DNA out of the system, correct?
Yeah, just like any other defense attorney or anything that you have, motion to quash the indictment, motion to do that, that's correct.
So essentially, what could possibly happen, a person could have been accused of a non-violent crime, his or her DNA will be collected, and they never could be possibly convicted, and they could be found not guilty or acquitted of the charge. But based off this bill, they will have to get a lawyer, file a petition just to get their DNA out of the system.
No, you got it, and you know this, that before you even get to that point, there's the legal standards. So there has to be probable cause as set out by the 14th Amendment and that applies to the states. There has to be probable cause for even an arrest, okay? And then it has to go to a grand jury, where at the grand jury it's no build. And then you have a right, all the various constitutional protections to do that. So no, I disagree with how you're describing it, because those things are in place. They're in place already.
But at the point a person is accused and a felony affidavit is sworn by an officer, and a judge approves that felony affidavit, it's still an accusation until that person goes to trial, correct?
Well, that's how the system works now, and as I said, this improves the system. So, you know, in a sense, like I said, it's used to exonerate people. I mean, it's throughout the country.
I just want to make sure it's clear that if a person DNA is collected after being accused of any felony, if he or she is later acquitted or found not guilty, according to the language in the bill, they will have to petition to get their DNA out of the system, correct?
That procedure is in place, yes. But there's no identifying, as you heard in committee, through the ladies that came in, there is literally no identifying information in DNA, and I'm not even going to pretend to be a DNA expert, but not one person can understand what is in that DNA profile at all. And there are federal protections that have been put in place for many years that protects the identity, so nobody knows what it is. And there are federal laws that dictate this as well.
Thank you, Senator Wiggins. Thank you, Mr. President.
Thank you. Senator McDaniel, for what purpose? Do you seek recognition?
A question, Mr. President.
You, Senator Wiggins?
Yes.
Senator McDaniel, you're recognized for a question.
Thank you, Mr. President. Mr. Chairman, I only have a question or two as it relates to the, in my mind, very strong privacy concerns and the Fourth Amendment concerns of what we're doing here. And I think Senator Simmons may have answered this question with a comment he made, but I want to be clear. So these tests are taken upon arrest, right? Not upon conviction. When a person's arrested, they'll be swabbed.
That's already the law, yes.
Right, it is. And the courts have ruled that that's permissible, even though I would disagree with that. But, you know, I'm not a Supreme Court justice.
The U.S.
but they
Supreme
have
Court has
right.
ruled that, and as you know, Senator McDaniel, people collect, it's like similar to collecting fingerprints. The U.S. Supreme Court for years has ruled that there's no right to privacy, or certainly no reasonable right to privacy in your fingerprints.
That's true.
There's also a procedure for collecting your blood, and the Supreme Court has ruled that this is very akin, if I'm remembering the case right, to your fingerprints that law enforcement uses when they're investigating cases.
Right, and the distinction the courts have made and the arguments that have been made, fingerprints are objective. In other words, if I touch this, I leave a print. It's objectively seen, it can be discerned and discovered. DNA is not.
Well, actually, when you actually have a DNA, when it goes before the jury, what they don't say, this is the DNA, what they say is there's a 1 in whatever billion chance that it's not this person, and it's up to the jury to make the decision about whether that was that person. So it's not saying that this is the DNA of that person. What it's saying is there's a 1 in a billion
No, I get
chance.
that. I think we're off on a tangent. I'm not suggesting that. I'm suggesting from the purposes of the Fourth Amendment violation, the privacy implication involved. Also, if you walk down that path, if a person is going to be exonerated, then naturally a defense lawyer is going to want to put that DNA evidence in. So that makes sense to me.
Right.
The timing of it is what's suspicious. I mean, why wouldn't we take the DNA sample after the conviction and then log it into a database?
Well, that has, like I said, this is, Mississippi's one of 30-something states now that has this. And actually, to answer from that perspective, because if you do it now, you can prevent a miscarriage of injustice. Because you know, as well as I do, that sadly it takes probably 3 years before a case gets to trial. And that person is either sitting in jail or that person is waiting. But if you collect it at arrest, and so conviction, so basically you've been arrested for 3 years before you get to take the DNA. So now if you take DNA at arrest, that goes into the database. I don't know, maybe probably within weeks, you can find out if it's that person or not, and you're exonerated and cleared. So it actually, that's what I mean by it improves our criminal justice system.
I get that, but there's another path to exoneration. The defense lawyer could always raise that issue. My concern is still the moment of collection and why the state would, in my mind, allow such an invasive procedure when a person could very well be innocent. And I know we're not going to agree on that, and that's fine, because bright minds across the country.
I'm all about innocent until proven guilty.
Right.
It's a
I understand.
bulwark of our.
It just, you know how it is, the power of the state, there's so much power and there's so much conviction and money behind prosecutors. I just want to be sure defendants have a fighting chance as well.
Sure.
Now, with that said, I'm still trying to understand a couple of more things, and I'm sorry.
I got you off. There you go.
A little bit.
Yeah.
It's a complicated issue. Here's my other issue. So if we log this information, which is very personal information, right, and a person later is found to be not guilty, there is a process, I think, by which that can be removed from the database, right?
Correct.
Okay.
Even though
Which is a good
there's
thing.
no identifying information in the database, and I understand about the privacy concerns, I get it, but as, if you remember, Ms. Sepich, who was here, whose daughter this law is named after, she provided you her card that had her DNA profile on it. Nowhere on there would you know that that was her.
Right. I guess my question is, would there be a way, and this would something I'd like to see worked on perhaps, instead of putting the burden on the petitioner to have the DNA evidence stricken or expunged, why couldn't they be made a part of the court's order? In other words, when the court rules and the jury adjudicates a finding of not guilty, why couldn't the judge in this order, just at that stage, order that information be?
I think your question is a good question. Two answers. One, that law was the same. That's what the law currently is. And this debate, when this body, when I say the body, the House and the Senate, and Governor Bryant signed the bill, that was there. Number two, as much as I respect our judges, the experience is that orders just don't get communicated, or if you're relying on whatever it is, 19 judges or in court systems across the state to do that, I think there's too many holes in the situation, both from the state and the defense side of it.
I get that. What about just legislative enactment that strikes it upon a finding of not guilty?
Well, we have two chambers. That's why we got two chambers. It's going to the House, and we'll see what they come up with. And I think they may have some questions as well, but I think it's a good bill where we are, and it makes things better for everybody.
Yes, sir. Thank you. I appreciate it.
Thank you. Senator Hill, for what purpose you seek recognition? Senator Hill. Senator Hill. What purpose you seek?
I think he answered the question about that the person has to get their own DNA out of the database even if they're proven innocent. I think he already answered my question.
Thank you. Senator Sparks, for what purpose you seek recognition?
Question, Mr.
You for a
President.
question, Senator.
Yes.
Senator Sparks is recognized.
Thank you, Mr. Chairman. Thank you, Chairman. You referred to the Supreme Court has affirmed this process. What's that case?
I think it's called the King case. I don't have the exact site in front of me.
Maryland v. King,
Yeah, that's it.
2013. Have you read that case?
I did. It's been a while, but yes, I read it.
Okay. With this bill, is there a fiscal note?
No, there's not. This bill isn't changing really anything. We passed it before, and the crime lab has money that they can handle, and I handle their DPS budget, and so I'm happy to address any of the funding side of this. And there's also federal grants that come along with this.
Do you know the cost of running a DNA sample at the crime lab?
I don't know the exact cost, but I personally have worked for many, many years to get the increased funding for the crime lab. And let me just say, I know it's always, if you want to try to oppose a bill, you talk about how much it costs. I'm happy to stand up here and try to improve our criminal justice system. They're already doing the tests now. They do it already. Crime lab has, when you do fingerprints, when you do ballistics, so it's not a bad cost, no.
Well, you refer to opposing a bill. I got other grounds to oppose the bill. I'm not done. But the question is, if you run more tests at the crime lab, does it cost more money?
You'd have to talk to the crime lab folks about that.
Okay. Is the crime lab going to take the swab at the county jail upon arrest?
That is done by your locals who have procedures in place that do that. They do that already. And it's different procedures depending on where you go.
I understand that they do it, but if you take samples from every felony arrestee, that would increase the number of samples taken. Would you agree?
Well, sure, just on a straight number. But you have to look at, again, the exoneration and how it's bringing to the system to make it a better system.
And I'll get to the system, but financially, the increased cost on the counties to administer the swab and the increased cost of the crime lab running the increased number of swabs, we don't have any knowledge of that amount.
We don't, but it's very minimal.
All right. In the Maryland case, do you remember that the law said a serious offense in Maryland?
I don't. Again, it's been a couple years since I read it.
Our law currently allows the taking of DNA at arrest of any crime that's 9732, which is crime of violence. Is that correct?
Yes, crime of violence.
Okay.
That's correct.
And the Maryland law, I would submit to you, was for a serious offense, is the language they had used. Do you recall that in the Maryland case that they could not use DNA, they could not even test it until arraignment?
Until what?
Until arraignment. In other words,
I don't recall that, no.
All right.
But like I said, California, 15 other states have this law in place.
Well, but I'm talking about the Maryland v. King case that talked about serious offenses, and that if a qualifying serious offense was not arraigned, the sample was destroyed. It was never tested. That's what Maryland v. King purported to do. But our system says on any arrest, even if not serious, if it's a felony, we're going to take your DNA and we're going to test it and we're going to put it into CODIS no matter what you're ultimately arraigned for.
But Senator Sparks, that's already the case on 9732 violent offenses, and that's already the case in 30-something other states.
For serious offense, and I agree with you, the law that says for serious offense, and I'm not arguing we should change that.
And Senator Sparks, you sat down, you personally sat down with Ms. Ashley Spence, who gave her testimony in committee, and who was brutally raped. And she said, if not for that law, where your DNA is collected on a nonviolent offense, her attacker would never have been caught. And that guy is sitting in prison for 130 years, and she was brutally raped. So, yes, if you're talking about justice, then I think it is fair that you collect DNA with all the protections that we have in this, that you can prove that and lead to somebody for justice like Ms. Spence, who was brutally raped and really left for dead. And that has been solved. And she came up here and she met with many of the people and she testified in front of the committee. And I, for one, think that that is getting justice for the system and for the victims.
And I too met with them and listened. My question is, do the ends justify the means?
And I just
you believe they do?
I do with the protections that are in here.
Okay. I would ask to speak on the bill at the proper time.
Thank you, Senator. Senator Sojourner, for what purpose do you seek recognition?
Question, Mr.
Would you
President.
yield for a question, Senator Wiggins?
Yes.
Senator Sojourner, you're
Thank you. Thank you, Senator Wiggins. I have similar concerns that some of my colleagues do about privacy, but I think we've already addressed all those. My bigger concern is and I'm messaging with my sheriff as we speak. In Adams County, we have several cases against violence to women. Some were rapes, some were rapes that led to death. And some of these cases have been pending for years because the crime lab is so backed up and we cannot get results to prove some of these cases. And so my concern is that when I repeatedly hear on these violent crimes that the crime lab is backed up and we can't get results, are we not adding additional burden to them on other felonies that aren't violent crimes when we can't even get the results on those violent crimes? So I'm concerned if there's no fiscal note or additional funding, aren't we just further backing up the system and making it more difficult to prove the violent crimes?
So fair question. I think that's a separate issue. What's the phrase? Justice delayed is justice denied. I think that would be justice denied for those victims that you talk about. Now, the point that you make, I think, is an extremely great argument for funding the crime lab to the highest levels. I personally have worked to do that. I hope Chairman Hobson is listening to that. Commissioner Tyndall and I have worked closely to increase the funding for the crime lab. I've sat down with the crime lab. I'm all about doing that. And so if this bill and that reason that you're bringing up leads to increased funding for the crime lab, then sign me up because I'll be doing it. But I do think, to your point, using that would end up being justice denied for those people who have been brutally raped and who are victims of the crimes.
I appreciate that, and I appreciate your concern for the crime lab. I just feel like we're kind of getting the cart in front of the horse before we've actually got the horse leaving the gate, so to speak. Thank you.
Thank you.
Senator Younger, for what purpose do you seek recognition?
Question and introduction out of order at the proper time.
Okay. Question, Senator Wiggins, will you yield for question?
Yes.
Senator Younger, your request.
And thank you, Mr. President. Thank you, Mr. Chairman. How will they destroy the DNA again? Did you say that, or I might have missed it?
Yeah, there's a procedure that it gets destroyed and deleted through the CODIS. CODIS there's a DNA national database of DNA, just like CODIS is, I think, the fingerprint database. And so you get the order, and it's ordered that it's to be deleted, just like if you get a conviction and you file for expungement, then you go to the court, you get expunged, and they clear all your records
Thank you. And Mr. President, we're lucky to have Senator Michelle's better half at the smokers table, Beth Michelle. Y'all give her a warm welcome, please.
Yeah. Nice to have you here, Beth. Thank you for coming. Senator McMahon, you're recognized for a question. Senator McMahon. Let's go. Senator McMahon, you're recognized for a question. For what purpose? Senator McMahon passes. Senator Harkins.
For a question.
Are you here for a question, Senator?
Yes.
Please proceed, Senator Harkins.
Thank you. What assurances or how would, if somebody is found innocent and requests that their DNA be destroyed or removed, what assurances or what procedure is in place to make sure that is carried out, and how will they be certain that their DNA has been removed?
Well, the procedures are already in place. When this law was passed and signed by Governor Bryant, that was already in place, and that was done. And so this is simply continuing that procedure. And to answer your question, in this bill, you file a motion and you get it done. In terms of, it's just like if you are convicted, let's say of DUI, first offense, and you're eligible for non-adjudication, then you can file for non-adjudication, and then that order, when the judge signs the order, that order goes to the clerks, that order goes to everybody involved and says you are hereby ordered to delete and seal that up. Same thing would happen on your DNA. In this case, same thing happens on CODIS and all that.
Okay. Is there a notice that is given back to the person saying that this has been done?
You know, I don't know. Okay. I don't know about that part of it.
Okay. So, and my understanding is if you're arrested for a felony, you get your DNA recorded. Is if you plead down to a misdemeanor, is it entered into the CODIS or is it not entered? Does it stay in there?
Yeah, that's a good question. It would be deleted. Because then you're convicted. Well, it's arrest, so it does get arrested, but then you could certainly, can get it deleted, yes.
So if you are arrested for a felony and you plead to a misdemeanor, you have the right to have your DNA removed from CODIS?
Yes.
You have to be arrested and charged and convicted of a felony for it to stay in there?
But understand that procedure's already under current law that we've had for 5 years, because as Senator Sparks says, it's violent offenses, or what we call violent offenses, and I can pretty much guarantee you that in a number of those cases, they've been pled down to a misdemeanor. So we're not changing the law on any of that. It's current law.
I'm just trying to get an understanding of what, my father-in-law owned a DNA lab. He swabbed DNA on people, helped convict people of numerous horrendous acts. So I get it, I understand. I'm just trying to wonder, is there a way that people are going to circumvent, if you get arrested for a felony and somehow you have a DA that lets them plead down, or they cop a plea to a misdemeanor, and it's a felony offense, is it going to stay in CODIS or does that get removed?
From what I understand about DNA, and I'm happy to talk to your father-in-law, that gets removed.
Okay, thank you.
Thank you, Senator. Senator Bryan, for what purpose you seek recognition?
A question, please.
Yes, Senator?
Yes.
Senator Bryan, you're recognized for a question.
I just was listening and heard some discussion of the crime lab. I've never understood why it is we just don't send whatever amount of money the crime lab needs, hire whoever we need to hire, and get whatever equipment they need to.
I agree with you,
do that.
Senator
That's
Bryan.
one of the most basic functions of government is to protect people from crime, and both the guilty and the innocent are made more obvious by the results of the crime lab. In other words, the crime lab in some instances can prove someone is innocent, and in other instances can prove, or at least lead you to believe someone's guilty. The evidence is just physical evidence that just is the function of truth, not pro or anti-prosecution. Can you tell me why the crime lab has been in this shape for just decades?
I cannot, Senator Bryan. I know I can answer that I've tried my best. When I first got here, the crime lab on the coast was not staffed, and we were actually paying for expenses and working with, at the time, Senator Tindall, working with the appropriations chairman, we were able to get that there. It's been a gradual process, but I 100% agree with you. I think if we want to make our system the best it can be, then we fund the crime lab. And to Senator Sojourner's point, if this bill is the impetus for us doing that, sign me up, because I think it needs to happen.
Well, thank you. I just, for years, have been wondering why on earth we don't fund the crime lab.
And I think that's what, to your point, there's exoneration that goes on for, I can't begin to tell you how many cases that, quote, get no billed at the grand jury stage for lack of evidence. And the crime lab, if we funded it at the highest level, could aid in exoneration and limitation of some of the issues that people are asking about. It could be handled in that way.
I mean, again, it's not exclusively, I'm trying to phrase this and I'm not doing a very good job of it. The crime lab is not exclusively a prosecutorial advantage, it's a truth advantage. It provides evidence not only of people's guilt, it also provides evidence of their innocence. I just don't understand why we're not, anyway.
Thank you.
Thank you, Senator. Senator Hickman, for what purpose you seek recognition?
Question, Mr. President.
Are you for a question, Senator?
Yes.
Please proceed.
Thank you, Mr. President, and thank you, Chairman. Just a couple of questions. I certainly vacillated with this bill, and I understand both sides of the coin. My question is, outside of the crimes that we are already automatically collecting DNA for, what are some of the crimes that this would extend this law to?
So the best way I can say it is, under current law, it's violent offenses, and under Mississippi law, that's defined as those that are in 9732 as those violent offenses. Okay, so that's that, and this isn't changing any what is added to that list or not, but it's simply, like was talked about, if it's a quote non-violent offense as defined by 9732, or is it in that statute, then it would cover that.
Okay. Now, bear with me. I'm an attorney, but I don't practice criminal law. I was a prosecutor, but we only did misdemeanors. So, in looking at the law that we're expanding now, most of the crimes that are nonviolent, I think you talk about like how this helps someone be exonerated, but in most of those crimes, there's typically not a DNA element to these nonviolent offenses.
You'd have to ask, I guess, the law enforcement that does that. I'm not sure, and they have different procedures, right, but I'm not sure.
So we're not sure if the person whose DNA we're taking, this has the option to help exonerate them from the particular crime that they're being accused of.
We know it can exonerate them, and it's not being done now, so that's why I say if you're in favor of, just like Senator Bryan was saying, if you're about, I guess, exoneration and making the system fair, then you would do it.
Now, when is the DNA actually placed into CODIS?
Okay, my understanding is when it's collected, that's when it goes.
It goes straight to CODIS?
Just like any other time.
So there wasn't an option, and I'm gonna tell you my real difficulty with this bill, which has come up a couple of times. There wasn't an option that the DNA is held and maybe upon conviction, unless it was tested for this particular prosecution or for this particular case, there isn't an instance or a situation or way that we could have held the DNA until that person is either convicted or exonerated, and then automatically dispose of DNA if this person is not convicted of the crime that they have been accused of.
If you're asking if that's in the current law, I don't know that that's the case, but also that's driven by how fast the cases move through the DA's office, how fast the law enforcement. I mean, I certainly know if you're dealing on a murder case, they want it as fast as possible. So I think that's dictated by all of those issues.
And I'll tell you this, I am pretty much a true crime fanatic, so I mean, I'm into this stuff, but my biggest difficulty with this bill is that once a person, if they are not convicted of the offense that they've been accused of, the onus is then on them to have their DNA removed from the system, and that's where this bill catches me. So thank you for your time and work on this bill.
Sure.
Thank you, Senator Turner. For what purpose you seek recognition?
Question.
Are you for a question, Senator?
Yes.
Senator Turner, you're recognized for a question.
Thank you, Mr. President. Thank you, Mr. Chairman. Mr. Chairman, my question is about how CODIS operates or functions.
I'm sorry.
I'm curious about how the system operates. If the sample is collected when the person is arrested, and it's as soon as the sample is received by the crime lab, it goes into CODIS. Is that the process?
When it's collected, yes, then it goes into the database. And I should say, I keep saying, thank you, I keep saying CODIS, but I think that's the fingerprint stuff. There's a DNA database.
So is there, one of the examples, well, one of the, I guess the proponents of the bill appeared in committee, and the example that she gave was that she was the victim of a rape, and someone was arrested in another state or another location, and the sample was collected, and that's how the person was apprehended. And so my question is, when is it constantly running a system check? You know, how is the DNA collected linked to a crime or an incident?
You're asking me to get into how they do all that stuff. I would defer to them, but it goes into so my amateur knowledge is that, and first of all, you have to have something to match it up on that. And that's why it's even the case that it's only affects if it's been in there before. And in her case, the guy that they caught had already had a criminal record, okay? It's not talking about the innocent. So he had a criminal record. He had a criminal record that was already in the database, and when they collected that, they matched it up against him. But if you have no criminal record or no nothing, they don't have anything to match it. DNA is about a match. You have to match it.
One reason I'm asking the question is because I looked at the code. I looked at that section of the code, and there is only one code section that appears under this chapter. And that's what's before us. So part of my question, or part of what I want to know is, what type of guidance or laws do we have in place that govern these samples as it relates to what goes on here in the state of Mississippi?
Those are governed by the federal government and by the federal database and the federal Department of Justice and all of them. Because it's a federal database that all your defense and your prosecution, that's how they use it.
And so if part of the example that you gave earlier was that this could potentially help in exonerating individuals at the grand jury stage of the proceedings, how does law enforcement access it? What information can they have in order to apply this to any case?
If I understand your question, the arrest is made, they take the sample, and then they put it into the database, and then they get I guess they would call it a hit. And by the way, I was reminded it's not your DNA profile. They pick what's called like 12 markers or 16 markers. So you can't even determine who you are based on what they collect. It's only 16 markers that they look at. And so when they collect it, it comes back and they say, oh, we got a hit on DNA. Did that answer your question?
It does. I'm just trying to figure out how it's helpful and when someone is arrested versus what's in the system and some other offense that's been committed. Thank you.
Thank you, Senator Turner. Senator England, for what purpose you seek recognition?
Question, Mr. President.
Are you for a question, Senator?
Yes.
Please proceed, Senator England.
Thank you. Senator Wiggins, I've listened to all the concerns in here today. I think there have been some great concerns raised with the bill. I think you've done a great job answering them. I just wanted to ask on this bill, and I think you've answered it, I just want to be clear on it. If we have a a serial rapist loose in Mississippi, and they're picked up on a burglary charge, and their DNA is swabbed, this would help get that person off of our streets in Mississippi. Is that correct?
Well, I don't want to go that, but there's a lot of procedures and protections that are in place before that. But yes, like the lady that testified or that came before the committee, yes, because it was a nonviolent offense and the DNA was collected, that person was a match because he was in the system and they matched it and he pled guilty. That's the other thing is it's not always a trial. When people are faced that they have a DNA match, then they end up pleading guilty, which saves victims and the state and others the issues. So yes, from that standpoint, yes.
So that person that's picked up and the DNA matches, they still have the due process that's available to them and you know, they're innocent until proven guilty and all that good stuff that our Constitution affords them as citizens, correct?
Correct.
Okay, and another question I have, and I think that's a good part of this bill. I think that if there's folks that are out there, and I've read that DNA is, you know, it's now the gold standard. We've had a long time to look at it, and scientists that are a lot smarter than I am have looked at it and know how to use it in trials. But one thing that interests me, I read a book recently, and I've got a question, but I've got to tell this part about. There were two young men in Lowndes County that were accused of murdering and raping two girls, and they were sentenced. That's correct. They were sentenced and spent time in jail until the actual perpetrator was caught and confessed to the crime. If we pass this bill and that person had been arrested again for, say, burglary or something of that matter, and his DNA were swabbed, at that time, this would have exonerated those individuals and helped them get out of jail a lot sooner. Is that correct?
I don't know all the particulars about that, but that Curtis Flowers case is the one that went to the Supreme Court 7 different times, and that the U.S. Supreme Court ruled that it had another trial, and then the Attorney General said we're not going to prosecute it. Yes, I think that with all of that could have been avoided if he had something like this because of DNA, and that's what, like you said, the gold standard.
Okay, so what we have here, we have a bill that could potentially help us get dangerous criminals off of our streets in Mississippi and also get innocent people exonerated and out of our prisons. Is that what this bill could help do?
Yes.
Okay, thank you, Senator Wiggins.
Thank you, Senator Engel. Any other questions? Any other questions?
I have an amendment. Mr. President, I have an amendment at the table.
Okay. Place on the screen, please.
This is your friend and my friend, the reverse repealer. I appreciate the debate. I think it's raised the issues. I would ask you to vote in favor of the reverse repealer and the amendment. We'll put it in there. And we all know what that does. But I think the debate is good and the issue, it was not my intent that this went on all day. But it's worth it. And I hope that I think the reverse repealer will address Senator Sparks' issues. We certainly have time to address it. I will tell you that this will allow me time to speak to Chairwoman Cockerham, and we'll address it from that point. So that's my amendment.
Questions on the amendment? Make your motion, Senator.
I move to adopt the amendment, Mr. President.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it, Senator. We're back on the bill. Senator Sparks, you're recognized to speak on the bill.
Thank you, Mr. President. Thank you, Chairman Wiggins, for your work on this bill. And I understand we could recount story after story of the ends justifying the means. There's two issues going on with this bill. The first is there's additional cost saddled upon our counties and upon our crime lab. This bill should have gone to appropriations. It would change the vote percentage. But the biggest issue is that Maryland v. King decided in 2013 dealt with a Maryland law that said serious offense. Our law, as it currently stands for violent offenses, I believe would stand up to the scrutiny in Maryland v. King. Maryland v. King was a 5-4 decision. The concern I have with this bill is because it is being used for general law enforcement purposes. All of these arguments about identification And we compare it to fingerprints. Fingerprints ID you. DNA would be redundancy and a waste of cost if it were truly for ID. The issue is general law enforcement. And when this country was founded, one of the issues was general warrants issued by the British government. General warrants. And that was not in our Constitution. It was in some of the early state constitutions, and it was brought up, and that's why it is in the Fourth Amendment. It is in the Bill of Rights that you are secure from a search of your body, the most prized possession you have on this earth. And there's a small category of permissible searches. If you're really bored and want to go read Maryland v. King, I have a copy. But this is not within those remedies. It's at arrest, not conviction. All 50 states take DNA upon conviction of a felony offense. We already take it on a crime of violence. It's a general law enforcement purpose. In my opinion, it's in violation of the Fourth Amendment. And I'm going to read you the dissent, the final paragraph from Maryland v. King. I wish these were my words. Today's judgment will, to be sure, have the beneficial effect of solving more crimes. That's the argument here today, that we'll solve a crime. Then again, listen to this carefully. So would the taking of DNA samples from anyone who flies an airplane. The Transportation Security Administration surely needs to know the identity of everyone flying on an airplane, or applies for a driver's license, or attends public school. Perhaps the construction of such a genetic, and these are one of those words that's used by the late Justice Antonin Scalia, who wrote this dissent, that I can't even pronounce it so good. Panopticon, I'll have to look it up later, is wise. He said if we took DNA from everybody, we could solve more crimes. But I doubt the proud men who wrote the Charter of our Liberties would have been so eager to open their mouths for this royal inspection. I submit to you, I appreciate an introduction of a reverse repealer. I submit to you the law as it stands is the only thing that would pass Maryland v. King, and I believe this is a violation of the Fourth Amendment. I would yield. Any questions if there are any, Mr. President?
Senator Wiggins, you're recognized to close. I'm sorry, Senator McDaniel, do you have, for what purpose you seek recognition?
Question, Mr. President.
Question, will you yield, Senator?
I yield.
Proceed, Senator McDaniel.
Mr. President, I was thinking about speaking on this, but you did an outstanding job. I think I'll just follow with a few questions and try to hammer home my understanding of what you said. You used Justice Scalia.
He wrote the dissent.
He did. Something else about that, he actually read that dissent from the bench. That's incredibly rare. It only happens when a justice is showing huge displeasure with a majority position, right?
That is correct.
That got my attention. Scalia very seldom did that, and his concern was not simply the power of the state to solve crimes. He was more concerned about the individual's right to preserve his integrity, right?
That's correct.
That Fourth Amendment that protects us all, correct?
That is correct.
And I love that quote you used at the end because it's exactly right. The premise behind this bill is to solve more crimes, right?
I believe that's the premise behind the bill, which is violation of the Fourth Amendment on its face.
Absolutely, that's the point. But to your point in Scalia's dissent, we can also, I guess, take a DNA sample of every child in public school. That would likewise solve more crimes, wouldn't it?
He mentioned that in his closing paragraph.
You could take a DNA sample of every person that gets on an airplane. That would likewise solve more crimes, wouldn't it?
It would.
But in our system of government, we would all agree that's too much government power. That's an incursion of the state into our personal lives, the privacy protected by the Fourth Amendment, right?
I agree.
So I think we're on the same page here. And I appreciate your dissent in this bill as well. One more concern I've got. When it is a violent crime, kind of makes sense. That's what the court said, the majority opinion. It was a serious offense, right?
That's correct. And that's a clear distinction. Maryland v. King, the law in Maryland was a serious offense, which I would say is analogous to our crimes of violence. So the Supreme Court does not support felony arrest of a nonviolent nature in a decision that I have before me.
I think you're exactly right. They emphasize several times only on serious offenses. And the more serious the offense, I guess the argument is, the less likely, or to the court's opinion, that these constitutional protections would apply. But misdemeanors, less serious crimes, clearly there's a distinction to be made there, and subsequent courts will probably come down on our side in that request, won't they?
That's correct.
Thank you, sir. I appreciate that very much.
Thank you, Senator McDaniel. Any other questions? Senator Wiggins, you're recognized to close.
Thank you, Mr. President. I'm actually glad for the pages here because they've been seeing excellent constitutional debate, and these are tremendous issues, and believe me, that doesn't go lost on me, and that's why we are in this body. But I will say this, when you've sat in front of a victim like I have, and like a number of you have, and they've been a victim of a crime, they want justice. Just like we talked about the Curtis Flowers situation. This bill makes it better, makes our system better. It also helps victims, and I'm proud to stand with victims on this. That being said, we have a reverse repealer in it. I would ask you to vote for the bill with the reverse repealer. Let's send it to the House. I'm happy, obviously, to talk to the chairwoman over there. I think the issues that have been raised by Senator McDaniel and Senator Sparks are very good, but we also had that debate when this bill became law originally, whenever that was 5 years ago. So I would ask that you would vote for the bill. It has a reverse repealer in it. Thank you very much.
Thank you, Senator Wiggins. Ready for your motion, Senator.
Move passage on the morning roll call, Mr. President.
Anyone object to the procedure? Senator Simmons.
Mr. President, I ask for roll call.
Roll call. Mr. Clerk, please call the roll.
Barrett. Blackman. Blackwell. Blunt. Boyd. Branning. Bryan. Butler to 36. Butler to 38. Carter. Kaufman. Chazanall. Chisholm. DeBar. Delano. England. Fillingane. Frazier. Harkins. Hickman. Hill. Hobson. Horn. Jackson. Johnson. Jordan. Kirby. McCon. McDaniel. McClendon. McMahon. Michelle. Moran. Norwood. Parker. Parks. Pope. Seymour. Simmons of the 12th. Simmons of the 13th. Sojourner. Sparks. Suber. Tate. Thomas. Thompson. Turner Ford. Whaley. Wiggins. Williams. Younger. Boyd. Branning. Kaufman. Chazanall. Johnson. McMahon. Whaley. Voting yes or yay. Blackwell, Boyd, Carter, Kaufman, Delano, England, Fillingane, Harkins, Hobson, Kirby, McCon, McMahon, Michelle, Moran, Parker, Parks, Pope, Wiggins, Williams, Younger. Voting no or nay. Barnett, Barrett, Blackman, Blunt, Branning, Bryan, Butler to 36, Butler to 38, Chisholm, DeBar, Frazier, Hickman, Hill, Horn, Jackson, Jordan, McDaniel, McLendon, Norwood, Seymour, Simmons of the 12th, Simmons of the 13th, Sojourner, Sparks, Super, Tate, Thomas, Thompson, Turner Ford, and Whaley.
Bill fails, 20 yeas, 30 nays. Senator Polk, you're recognized.
Thank you, Mr. President. I move the Senate stand in recess until 1:30 this afternoon.
In recess till 1:30. All in favor, say aye. Aye. Senator Younger, I'm sorry.
Catfish at the farmer's market for the Senate.
Thank you very much. All in favor signify by saying aye. Opposed, no. The ayes have it. We stand in recess till 1:30. recognized. We're on 62, please.
Thank you, Mr. President. I'd like to ask 62 to retain its place on the calendar and go to item 63.
Item 63. 62 retains its place on the calendar. Mr. Clerk, please read the bill.
Senate Bill number 2658, Medicaid, delete language of required rates of reimbursement to not be changed unless amended by legislature.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
I'd like to be recognized to present the committee sub.
You're recognized to explain the committee sub.
Thank you, Mr. President. This bill is the bill also known as the tech bill that we did last session. And in the language of the bill, Medicaid said that we basically, you may recall some of this, that we had a chokehold language put in so that they could not increase reimbursement to providers. So what this bill does is it fixes that. And I want to go through a few things on the committee sub. Line 372, we did add some language here to ensure the division reimburses DME suppliers for home use ventilator products and services on a continuously monthly basis for the duration of a patient's medical needs. On line 407, it requires the division to establish an upper payment limit program for emergency ambulance transportation. Line 489 is just conforming language for the ambulance UPL language I just told you about. Line 897, this removes, those lines remove the chokehold language that the department found offensive. Line 913 is the new language that we're putting in place to require Medicaid to let both the House and the Senate Medicaid chairman know 30 days prior to any notice to providers of any reimbursement decrease. And then line 1190 requires Medicaid to do a study to explore single-use vendor to administer dental benefits. And that's an explanation of the committee sub, and Mr. President, I have an amendment at the proper time.
Questions, please. Questions on the committee substitute? Okay, we're ready for a motion on the committee substitute, then we'll go to the amendment.
Move adoption of the committee sub.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We're on the amendment.
Thank you, Mr. President. This amendment, I think it's up there, is basically we got with Medicaid and worked with them on cleaning up some of the language. So the majority of this takes care of that. With the exception of line item 25, this is new language that we're adding that says a Border City University affiliated pediatric teaching hospital. And what we're doing is we're requesting that the department apply for a UPL program for a hospital, for a teaching hospital on our border state, on one of our border states. And that's an explanation of that, the amendment.
Questions on the amendment? Senator Hobson, you're recognized for what purpose?
Question, Mr.
You
President.
yield, Senator?
Yes, I yield.
You're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. Does Medicaid support this amendment concerning the border hospital?
I know we worked with them on the language of it, so to that, and I think they do support it.
You think they do support it?
Yes.
Do you know if our state-supported hospitals in Mississippi support this?
If our state, I know they don't oppose it.
They don't oppose it? Would
At least that's what I was told.
Oh, okay. Well, that's different than what I was told. Do you know if Tennessee offers Mississippi the same benefit that we're prepared to offer this hospital in Tennessee?
Not to my knowledge, but Tennessee does pay Mississippi hospitals, and sort of like we pay the other hospitals out of state. What this would do would allow for them to receive some additional reimbursement through that upper payment limit program.
Does Tennessee pay at the same rate that Mississippi would pay a Tennessee hospital for this benefit?
I don't know that.
They don't?
I don't have the answer to that, but what they reimburse.
Well, if I was told a couple of days ago they do not, would you disagree with that?
That they
Would
do?
you disagree with the premise that Tennessee would not afford Mississippi the same payment rate that Mississippi would provide under this proposal?
I don't have the information to answer that either way.
Okay. What does it cost for this hospital? What do you contend that it costs for this hospital to treat Mississippi patients?
I don't have their cost, but they lose about $25 million a year taking care of Mississippi children. And I think there was over 32,000 visits last year of Mississippi to this specialty hospital.
Does Mississippi provide this service? Do Mississippi hospitals provide this service?
There may be, UMMC might be able to provide some of these services, but this facility we're talking about is Le Bonheur. They're one of the top 10 hospitals, children's hospitals in the country.
Would that group be willing to locate in Mississippi, put a facility in Mississippi so they could get the Mississippi rate?
Well, I think you and I kind of had this discussion before. I don't think that's feasible. They do have a facility, Methodist in Olive Branch, and one of the provisions of this, we have a 2-year limit in this, basically so that we can get with CMS and find a way in which they can participate in the UPL without Mississippi having to foot that bill.
I'm sorry, I didn't catch the last part. What was that?
We have a 2-year limitation on this, and the reason being is so that we can go to CMS and hopefully find a way in which they can participate in the UPL program without us having to foot the bill for that.
Is there a House bill currently pending right now that would have this language in concerning the attempts to get to Le Bonheur?
No, sir.
There's no other bill pending?
No, sir.
You're sure of that?
Nothing with the Le Bonheur language that I'm aware of.
Pardon?
Nothing that I'm aware of.
Have you talked to that group about locating a facility in Mississippi? If they're losing $25 million a year, they could probably build a pretty nice facility they could pay off in short order.
I don't know. I've been the CEO of a hospital. I don't know if you have, but it's a little more challenging than to say, let's go build a hospital.
Have you talked to Tennessee Medicaid Department to see if they pay Mississippi the same rates that we would pay them under this proposal?
I have not.
Has anybody spoken with the Tennessee Medicaid Division to discuss that?
Not that I'm aware of.
Thank you, Senator Blackwell.
Welcome.
Senator McClendon, for what purpose you seek recognition?
Question, please. Mr. President.
For a question?
I'll yield.
Please proceed, Senator McClendon.
Thank you, Senator Blackwell. Senator Blackwell, were you aware that my 2 sons had to go to Le Bonheur at one time in their life?
I did not.
My youngest, Sadler, he was 8 years old, got bit by a black widow spider. We went to Baptist DeSoto, and they said it'd be a 2-hour wait. They suggested that we go to Le Bonheur Hospital. Immediately when we went in the door, they saw the line that Baptist had drawn on his arm, and by the time we had gotten to Le Bonheur, his arm had swollen up the size of his leg, and Le Bonheur took him in right away. They said they needed to do immediate. My other son, Hunter, came back from church camp Friday night. On a Saturday morning, he's complained all night long his head hurt. We go across the street to our family physician, Dr. Wadsworth, who immediately suggested we carry him to the hospital. He calls Baptist Hospital. Baptist DeSoto says, well, if we think what he has, he needs to go straight to Le Bonheur. We carried him straight to Le Bonheur. They took him in immediately with the emergency room full. I wasn't in government. All I was an average Joe, just like I am now. They put him in a tent for 3 days, and he had meningitis. Baptist DeSoto couldn't see him. It was Le Bonheur. every child that is in some kind of dire need in DeSoto, Marshall, Tunica, Tate, all around our area, they go to Le Bonheur. And I don't know why the underprivileged that are on Medicare doesn't deserve the same service. Thank you, sir.
Other questions on the bill? Other questions on the bill? We're on the amendment.
Move for adoption of the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
Move for final passage by the use of the morning roll call.
The morning roll call has been requested. Anyone object to the procedure? Wish to be recorded as voting no? Present? Present Hobson. Present Hill. Anyone else?
Barrett.
Barrett, present. McDaniel, present. Boyd, present. Sojourner, present. Present Tate, present Chin. And Chin. Suber. McCon. Seymour. Moran. Anyone else? Anyone else? Seeing none, the bill passes. Thank you, Senator. We'll go back on the calendar, please. Chairman Tate.
Thank you, Mr. President. I'd like to go to item number 64, Senate Bill 2358, and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2358, candidate filing fees, authorized parties to determine.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
Yes, sir. I'd like to call on Senator Fillingham to explain.
Senator Fillingham, you're recognized to explain the bill.
Thank you, Mr. President. Procedurally, I would like to go to the committee substitute and then ask that it be voted down. The committee substitute.
Committee substitute.
Yes, sir.
We got it.
I would like to adopt the committee substitute. I would be I think the motion, and then I'm going to ask the body to vote no on adopting the committee substitute. The reason being that in the committee substitute, it treats independent candidates a certain way, and we want to take them out of that, which is what the strike all will do. So the difference between the committee substitute and the strike all amendment that I would like to get to is that the committee substitute and the strike all treat independent candidates differently, and we don't want to treat them as we would treat the party primary type candidates. So that is the reasoning for my rather odd request to call it the committee substitute and then ask that you vote no on the committee substitute.
On the committee substitute, motion, Senator's made a motion. Any questions? Any questions? Seeing none, all in favor signify by saying aye. All opposed, no.
No.
It is defeated.
Now I have a strike all amendment that I would like to have permission to explain the strike all, Mr. President.
Is the strike all up, please? Mr. Clerk, one moment, please, sir. Okay, we're ready on the strike all. You're recognized to explain.
Thank you, Mr. President. All right, Senate Bill strike all 2358 authorizes the state executive committee of each political party to determine the filing fees for party nominations for certain political candidates. Under this strike all bill, the political parties, that being the Republican Party of Mississippi and the Democratic Party of Mississippi, would set the filing fee for the governor, all statewide elected officials, all the legislators, senators and representatives, the United States Senator and the United States representatives. The filing fee would remain the same as was provided for all other political, like county candidates. The filing fee would be set by the executive committee of the parties, and not more than once every 2 years would that be changed. The state executive committee of political parties shall set the entry fee for those candidates. The entry fee shall not exceed the average of the southeastern United States, the other states in our area. The political party shall report that fee to the Secretary of State at least 90 days before the qualifying deadline, and the Secretary of State shall publish those fees at least 45 days before the deadline. The Senate bill authorizes the State Executive Committee to use those presidential primary fees for the party's regular and necessary expenses. That is what this bill does. I'll be happy to answer any questions.
Okay, questions. Senator Butler, for what purpose you seek recognition?
Question, Mr. President.
Senator?
Certainly.
Thank you, Mr. President. Thank you, Senator Fillingham.
Yes, sir.
What are we doing here? I mean, why are we trying to let the parties decide on what our qualifying fees would be?
Exactly, great question, and I think the best, simplest, and direct answer is that the state ought not to be involved in the primaries. The primaries are a function of the political party. So back home, when you go to the political primary to vote for whatever the office is, you know, the county doesn't run those elections unless the party asks them to. It's a function of the Democratic Party to run the Democratic primaries. It's a function of the state Republican Party to run the Republican primaries. And so what you have now is the state, all of us, setting all those fees for the Democratic candidates and the Republican candidates as well as independents. What this would do is say the state really has no business being involved in the decisions regarding the primary elections, since that's a function of the state parties, both the Democrat and Republican parties. So this bill would simply shift that decision on whatever the filing fee would be, and it may be zero. I mean, the state party may decide, you know, we want, you know, everybody to be able to run and there be no fee whatsoever. Or the party may say, we've got a bunch of folks running that really are making a mockery of this process and just, you know, running for the heck of it and not really being a serious candidate, and they may want to set the filing fee higher. So the bottom line is we're not taking a position on what it should or shouldn't be. We're just saying we ought not to be in the business of making decisions that affect the political primary elections. That ought to be a function of the respective political parties.
Wasn't the fees just raised a few years ago by the state?
They were, yes, sir.
And how long were they? Well, I know for a long time it was $15 just for us to run for the state senate, correct?
Yes, sir. I mean, they were really low.
Really, really low.
For a long time. And of course, you can make the argument that maybe that was great. You know, it's provided for more opportunity for more people to run. You can also argue that when there's little or no cost to running for an office and putting your name on the ballot, that it creates the opportunity for a lot of mischief, a lot of people that just want to make fun of the system and just be sort of, you know, not serious about running for office, that would put their name on the ballot. And of course, it would cause all those who are serious about running for office, you know, problems. I think we had a situation not too long ago where maybe a truck driver put his name on the ballot, didn't campaign, didn't really run. He was running his 18-wheeler truck, ended up winning a major party primary for a major office in Mississippi. And I think you could argue that that was a direct result of having extremely low filing fees in that particular race. So this is kind of what this bill is doing. To answer your question again, I don't want to be obtuse or long-winded in my answer, but yes, the simple answer to your very straightforward question is that if you believe that the legislature in the state of Mississippi ought not to be involved in party politics in the primaries, then you would be for this to get us out of that and say that decision belongs to the state Democrat Party and the state Republican Party.
Okay, so who was the author of this bill?
Not me. I think it was possibly Senator Chastinall.
And the state just went up to $250 a few years ago, right?
Yes, sir.
And
I think that was back in 2016, maybe.
2016.
So it's been a few years back.
Okay, who gets the money, the qualified fee? Who gets that money?
The parties.
The party themselves.
Now, unless it's an independent. I think if it's an independent candidate, those monies go to the state of Mississippi. The Secretary of State handles that. And that would remain the same under the Strike All Amendment. We're not trying to affect any change for independent candidates that aren't affiliating with one party or the other. They would still continue to run under those fees that we passed back in 2016.
So would you say that in just your opinion, do you think the fees will go down or go up?
You know, in looking at some of our neighboring states and comparing ours to theirs, the answer is yes. The answer is in some states, they have zero.
Great answer, Senator.
I mean, they have zero. I think in Tennessee, for instance, the Democrat primaries in Tennessee, they charge zero filing fees. And I guess, again, they would argue that they want to remove any barriers to people being able to run for office and participate in the political process, so that's the route they chose. In other states, it would be higher than what ours is right now.
Thank you. Thank you, Mr. President. Thank you, Senator.
Thank you, Senator Butler. Senator Jordan, you're recognized for a question.
Thank you, Mr. President. Mr. Chairman,
yes, sir.
Along those same lines, for reasons, a fee of, let's say, $50 would be, in your opinion, would be reasonable. I would like to see both parties have the same amount. Not that I'm a foot stomping, back slapping Democrat.
Yes, sir.
But I would like to, for the regulation, I would like to see maybe $50 for both parties. Let's come to some consensus there, because I remember the truck driver. And all that shenanigan. Right. We don't need that. But I want it to be reasonable, and I'd like to see, since we have a two-party system, that something like $50 should be reasonable for a person to qualify.
You know,
just an opinion.
I'm sorry.
Just an opinion, that's all. I just want to know, what are your views on that?
Well, you know, Senator Jordan, I have great respect for you individually. You have been here an alliant of the state Senate for many, many years, so I certainly defer to your wisdom on a lot of these issues. I will say it gets tricky when you start asking any one person what their opinion or their analysis of what is reasonable or not. It's sort of like the U.S. Supreme Court many years ago said about pornography. It's in the eye of the beholder. What is pornography and what is not? What is reasonable in the term of a filing fee is really in the eye of the beholder. For you and I might agree that $50 is a reasonable fee, but somebody else may say that's way too high or way too low. So it just it begs the question, though: should we be in the business of doing that setting of fees in the first place?
Well, I have no doubt that we could come, but I don't want. I just think it would be consistent, and Democrat Party will set reasonable rules. I'm not worried about that.
Yes, sir.
But I'd just like to see it congruent before both parties pretty well have the same amount. I think that would speak well for the state as a whole, regardless of which party. I don't want a Democrat to say, well, the Republicans charge $200, we should charge $200. I just want it to be kind of reasonable in both parties. I think we can reach an agreement. I'm hopeful we can reach those kind of agreements. Thank you, that's all.
Thank you. As always, I respect you and your questions, and you're welcome to the State Republican Party anytime you get ready to join us.
Thank you, Senator. Senator Simmons D. You recognized for what purpose?
Question, Mr. President.
Question, Senator?
Yes, sir.
You're used for question. Senator Simmons, recognized.
Thank you, Mr. President. Thank you, Senator, for yielding. Senator Jordan's last comment wasn't over the microphone, so what he said was, you all may put the jelly too high and he may not be able to reach it. So my question pertains to whether or not the jelly is too low in either party, whereas the jelly may be too high in either party and there's no uniformity. What do you say, Mr. Chairman, about the fact that we are a representative democracy, and in this body, like we did a few years ago, by raising the actual qualifying fee, we did it as Democrats and Republicans, and the state is uniform. I mean, it's basically the same fee regardless whether you are running as a Democrat or Republican for that particular office. What do you say about that?
Well, it's a great question, and what I would say is that, I voted for that bill, if I recall correctly. I think the real question, though, is whether we're asking the right question. The questions so far, and quite correctly, have been focused on the level. Is it too high? Is it too low? Is it like a Goldilocks argument, just right in the middle? I think the question this bill asks is, should we be in that decision-making process in the first place? And with regard to political party primaries, the gist of this bill is to say, we as elected senators and on the other end the representatives, should we be deciding that? Should that not be better determined at the state party, since they could collect the money, they spend the money, they qualify the candidates, they run the actual primary elections on election day? Now, it's true that some counties, the party asks the election commissioners. I know in Forest County, for instance, which I have a piece of, the parties go to the election commissioners, but that's their decision, and say, hey, we would prefer you all to run this for us, and they don't actually run it themselves, they just oversee the running of it. In Lamar County, where I live, we actually run the actual primary elections. I know my mom and other volunteers on our side, and their volunteers on the other side, they call all the poll workers and get them to sign up and assign them to certain polling places, and they do all that work because it's a function of the party. It's not a function of county government or a state government. So you ask a great question, and we could dicker all day over whether something's too high or too low. I think the question that this bill raises is whether you think this is better determined at the party level, or if you still think that we should set that fee ourselves. And if you feel that way, then you want to vote against this bill.
Well, I guess before we even get to the vote, Mr. Chairman, is it something that has happened that the members of this body don't know about as to why we have the proposal before us to move the state out of setting the qualifying fee?
Well, I think some other states have done what we're talking about doing, which is they turn that question over to the political parties, and then the political parties handle it, of course, only at the primary level. Now, at the general election level, that's a whole different ballgame, but as far as qualifying for a party primary, and in this bill we don't mess with, that's the reason we didn't want the committee substitute versus the strike all before us. We didn't feel like it was right if they're independent candidates, or in a special election, for instance, where candidates are running sort of in a jungle primary in a special election as independent candidates. We shouldn't, mess with that, because that's really not a function of the parties. But this is purely saying for party primaries, the parties, the Democrat and Republican parties ought to be able to decide that themselves and not the legislature.
And my last question or comment, aside from what other states are doing,
sure,
is there a push from either party in this state that we need to get out of the business of setting qualifying fees, and it needs to be determined?
I'm sorry.
Okay, and it needs to be determined by the parties.
Yeah, I can tell you, I've been reached out to by the state Republican Party, and they feel like this is better left to their decision making, not the legislative decision making, to set the fees that their candidates have to pay, since they're the ones who collect the fee, they spend the fee. They qualify or not. If you don't meet the qualifications of living in a certain area, that's a function decided by the state parties.
Would it be a friendly amendment that we keep, for uniformity purposes, the filing fee to be determined at the state level, but if a party in the state decides to charge a additional fee, it has the ability to do that over and above the fee that was set by us, the state?
I mean, if you were going to do that, I would think you would just be against this bill and allow the state to continue setting the fee like we have done in the past. So I would think that would be, a wonderful amendment, but I don't think it would have the effect of doing anything but, making this bill irrelevant.
Thank you, Mr. Chairman.
But you're a smart attorney, so thank you.
Thank you, Senator Simmons. Senator Hick.
Question, Mr.
Senator
President.
Hickman.
Yes, sir.
Thank you, Mr. President, and thank you, Mr. Chairman. Just a couple of questions here. I heard you mention the truck driver as one of your examples. Do you think that by us passing this bill, it could have stopped this individual from running for office?
I don't know if it would have or not. It would have been up to the Democratic Party to have set that fee if this bill were the law at that time. And I don't know. I don't presume to know what the Democratic Party would have decided the filing fee ought to have been.
Let me rephrase my question. Do you think that a certain dollar amount would guarantee certain candidates to not be able to get an election, or?
You know, I'm sure if you set a fee high enough, you're going to certainly exclude certain people from being able to run. That is why we're saying that the state ought not to be in that business. And maybe we've already set the fee too high for certain people to run in the list that we passed in 2016. So by taking us out of that process and returning that over to the state parties, if that is an issue, you can take that up with the state executive committee of the Democrat Party or the state executive committee of the Republican Party and say, look, you're pricing people out of the process. You need to lower that fee.
So is the fee the only thing we regulate when it comes to primary elections?
In the primary elections, I know the parties collect the fees. The parties are the ones you go fill out the paperwork and turn in. They qualify you or determine if you are qualified or not qualified, and they run the election. So I'm not really sure what other fingers we would have in the pie of the political primaries.
But I'm saying, don't party primaries have to run a certain way according to law? They can't just do what they want to as far as the way that they run those elections, and we make the rules that they have to run their election by, correct?
If you're saying that, do those campaigns and elections, are they governed by election law? For sure, the federal as well as the state.
So in essence, we wouldn't be getting out of the business of regulating primaries completely just by not setting the fee.
I think setting the fee is certainly the entry. That's like the gateway. I know we use that phrase in a lot of things, with drugs and all this, the gateway. So the filing fee is the gateway into the political process at the primary level. So I think it would be a huge step in extricating us as much as the law, federal law, would allow us to extricate ourselves from.
So do you know how many states have moved to this type of model in allowing parties to regulate their primary elections?
I don't have the full number. I know it's multiple states that do that.
Okay. And
including Alabama, I think.
I think this may be an old statistic, but I think there are only 3. And out of those states, do you know the state with the highest party, the highest fee to become a candidate?
No, sir, I don't.
Would it surprise you that fee was somewhere around $7,500 to get on the ballot in the state of Arkansas?
For every race?
No, well, for our race, for a Senate or a state representative.
No, I haven't checked into Arkansas's filing fees.
And do you think that a fee like that is somewhat incumbency protection? Do you think the people back home should be worried that we're setting up a law that allows us to take, in a sense, a coward way and allow the party to raise the fee without us raising the fee to protect incumbency in some way?
I'm glad you raised that issue because I think that's one of the most forceful arguments for this bill, because by us coming in like we did in 2016 and setting these fees, us, not the party, but you and I and the other elected representatives and senators, we got a lot of blowback. I was here then, and a lot of people came and said, y'all are raising it $250? That's a lot of money for me. I can't afford that. You're trying to protect yourselves from getting any other opponents coming and running against you and qualifying against you. So I think that begs the question, regardless if you think 250 is too high or too low, should we be making that decision? What this bill says is this is not our place. The place to make that decision is at the party level, and you active in your state party and me as an active member of my state party, I can campaign and lobby and stress the importance of having a higher or lower rate to my party. But when we come in here and do it, it does smack of incumbency protection. And when we raise these fees, we price people out of the game.
I totally agree with you there, but I think that from the small research I've done, states who have gone to this model have raised their fees substantially higher or substantially lower. They bottom them out or they've raised them substantially high. And so one way or the other, it's a mess, and I think this is a bad bill. Thank you.
I recognize your concern, and I would just say if there are those concerns, the place to argue that best is at the state party. At least if they are trying to keep people in or out, the other people can go to the other party and run if they want to. If we're doing it here as elected members of the legislature, it really can look very bad that we are trying to protect ourselves and keep us from having other opponents.
Okay, anyone else? Senator Hill, for what purpose you seek recognition?
Question, please.
Please proceed.
Thank you. I got a copy of the strike all, and what it does is it allows the statewide and state elected candidates' filing fees to be set by the party, but for the local candidates who are also running partisan, like district attorney, sheriff, chancery clerk, circuit clerk, tax assessor, it leaves those fees set in statute. So those are also primary elections. So the only ones we're giving over are the bigger elections to the party. So I guess my question is, what were the prior fees for district attorney? Now it says $250. What were the prior fees for district attorney and the sheriff, chancery clerk, and those are set at $100 in this strike all. Coroner set at $100, justice court judge set at $100. So what were the previous fees for those? Are we changing them?
No, ma'am, we're not.
Okay,
They're the same. And
so we're leaving the county fees alone, and
Yes.
the parties run those primaries. They're running in primaries as well, these partisan races. But we're basically giving the legislative authority over to the parties to set these qualifying fees, correct?
For our level
For our
and above,
levels.
because
Now,
that's where we are, if I can answer the question.
Yesterday, we had...
If I could answer your first question before
sure.
we continue to the second one. The thought was, you're talking about county level elections and below, and so, I mean, if you want to have an amendment to say, to be completely consistent all the way down to, you know, the justice court and the constable and all that, certainly, I'm happy for you to offer that amendment, but I think the thinking was that we're here at this level, and anything at our level and above, we're saying we ought not to be in the process of engaging in the fee setting. Anything below us, it was left alone. As you said, we haven't messed with any of those fees. All those fees that are set out, even though they're underlined, and I know that can be confusing, they're underlined, but they're the same fee that haven't been changed from 2016.
Okay. Yesterday, were we not talking about a bill that would have reined in the salary of the state superintendent of education that's been set by the Board of Education?
Yes, and I voted for that.
So we've been dealing with an extremely high salary for a long time that's been perpetuated by a board that we relinquished our authority to set that statute and salary to some years ago, correct?
It was not a political primary board, if that's the distinction you're trying to make.
Well, I'm just saying, when we're relinquishing our legislative authority to another entity, and we're taking our authority and giving it to another entity, then we're going to be at the mercy of talking to that entity if those filing fees get so high that, you know, to me, I think anybody that wants to run for office ought to be able to run for office, and I don't think they ought to be priced out of it. I don't care what their reason for running for office is. If they want to run for office, it shouldn't be financially prohibitive for them to go and sign up to run. I've had some people run against me, and that's fine, you know, but my concern is what we might get as far as using a primary fee for fundraising, and I'm really concerned about that. Really concerned about that.
Well, you're my good friend. I have a tremendous amount of respect for you, but I would say that we have to be careful when we say it's easier when we control everything. You know, Vladimir Putin thinks it's easier for him to control everything in Russia right now, too. You know, democracy can be a very, you know, messy and cumbersome thing, but we feel like it's probably the better model than an autocracy or a,
But
one-person rule.
the people have some redress of their grievances whenever things are handed by an elected official. They can throw us out if they want to. But the more we delegate to some of these pretty much hard to deal with and hard to get to the bottom of entities, and we delegate responsibilities that we once had to some of these other bureaucratic boards, commissions, executive committees, or whomever, that's just something that has typically gotten us in problems before, and that would be my concern. And the people put us in charge, and if they don't like what we're doing, they can throw us out. That's just my opinion.
I agree with you, and also, I've never been involved in the Democratic Party politics, but I know in the Republican Party that I'm fairly active in my local level, we have caucus elections every 4 years, and we elect those members, and if we don't like the way they're running things, we don't elect them the next time, so I agree with you on that point.
Senator McClendon, for what purpose?
Question, please, Mr.
You for a
President.
question, Senator?
Yes, sir.
Thank you, Mr. President. Thank you, Mr. Chairman. I have one small question.
Sure.
If a person's running independent, who sets that?
It's already been set, and we don't change that.
And that is?
The legislature already has that in statute, what those fees are, and we don't mess with that in this bill.
Thank you.
Because they're not affiliated with the party one way or the other.
Senator Sojourner? I'm sorry, go ahead, Senator.
If that price, if they have a problem with the price, then if it's higher, they could go to this lower.
I'm sorry?
If they had a problem with the price in one of the parties, they could
Right.
go independent.
Oh, absolutely, sure.
Thank you.
Thank you, Senator McClendon. Senator Sojourner, for what purpose?
A question, Mr. President.
Yes, sir.
Yes, sir.
Thank you, Senator Fillingane. Just real quick, because I know we swapped from the committee sub back to the, is there a reverse repealer in this bill?
I don't believe so, but let me look real quick. No, on the strike all line 351 and 352, this, if passed, will take effect on July the 1st of 2022. So no reverse repealer in this version.
Okay, I'd like to make an amendment at the appropriate time.
Thank you, Senator. If you approach with your amendment, please, if you could get it typed, that would be helpful. Senator let's see, no, you were not next. Senator Blunt. Senator Blunt?
I just had one more question, Mr. President.
Yes, sir. I do.
Please proceed.
Thank you, Mr. President. Thank you, Senator Fillingane. Is this an attempt to raise money, Fillingane, Senator Fillingane?
It's not an attempt by me to raise any money. Now, if the parties, like we were discussing earlier, if they want to set the fee at zero, they would have every right to do that, and of course, they would be taking in $0. If they want to set it at a really high fee, they could, but I would certainly, if I were them, I would fear doing that, because the higher you raise that fee, you're going to drive people to the other party to run, in my opinion.
Well, you know and I know it's probably not going down.
Exactly. Taxes and insurance and all these wonderful things. As I'm doing closings in my office, I always share with people, watch those fees. They might go up.
All right, anyone else? Senator McMahon? For what purpose, sir?
Introduction out of order, Mr.
Please
President.
proceed. Senator Blunt, we're going to call on you next. Please proceed, Senator McMahon.
In the North Gallery, I would like to ask Mary Parker to stand. Mary is the Guntown City Clerk. She's here today as my guest, visiting her Mississippi State Senate. I would ask that you make her feel very welcome.
Welcome. Senator Michelle.
An introduction also, please, Mr. President.
Please proceed.
Thank you, Mr. President. In our South Gallery, we have a group of insurance executives I'd like to welcome to our state capitol, members of the Mississippi Association of Health Underwriters, and also members of the Mississippi Association of Self-Insured, and their executive director, Wendy Powell. Would y'all stand so we can welcome you to the state senate, please?
Thank you and welcome. Senator Seymour, for what purpose?
Introduction of a resolution out of order.
Please proceed. Senator Blunt.
For an amendment, Mr. President.
Please proceed to the front. All right, ready to, we need to, Senator Fillingane, we need to adopt yours so we can have it amended. Or not. So, we're ready to adopt yours? And then he has an amendment. Okay, we're ready on your motion, Senator.
Thank you, Mr. President. My motion will be to adopt the strike all amendment so that then there can be amendments made to that. amendment.
Motion is to adopt a strike all. All in favor signify by saying aye.
Aye.
Opposed? Ayes have it. Okay, we're on amendment number 1. Senator Blunt.
Thank you, Mr. President. Thank you, Senator Fillingane. This bill, the origin of this bill, the reason this bill is before you is to raise funds for political parties. It has nothing to do with democracy, the right to run for office and put yourself before the voters. The reason this bill is before you is to raise funds for political parties. I talked to the chairman of the party who inspired this bill, and he told me that. So make no mistake, the purpose of this bill is to raise funds for political parties, and that includes the office that you stand for. And it's a bad look, folks. I voted for Senator Jordan's bill yesterday, and now we're dealing with this bill today. It's a bad look. A few years ago, we took the qualifying fee to run for this office from $15 and raised it to $250. I personally think that's reasonable. I think we ought to leave it alone. Since we last ran for office, the qualifying deadline to run was March 1st. Now it's February 1st. What do people think about that? It's beginning to look like we're in the incumbency protection business up here. That's not a good look. This bill is before us for one reason, and that is to raise fees to go to political parties. Now, Senator Fillingane is right as far as he goes in saying that political parties run the primaries. That's right. But the way you get elected is on the general election ballot. And it's been probably as long as I've been alive since we've had a member of this body who was elected on that general election ballot that didn't have a D or an R after his or her name. If you're going to be elected, and most of us are proud of our political party that we belong to, if you're going to be elected, you're going to have to pay that fee to that party. Because when you are ultimately elected in that general election, which is what sends you here, you want that D or that R by your name because you're proud of the party you belong to. This bill is going to be about raising that fee. And don't kid yourself that you say, well, I just let the party executive committee handle that. I didn't have anything to do with that. They did that. That's what this bill does. That's what it's designed to do. Now, we did an extensive study last term, as I mentioned, that raised qualifying fees. And I voted for that bill because it's a balancing act, quite frankly. It's a balancing act between access to the ballot and having a qualifying fee that's $1. Of course, if you vote for this bill, you can allow your executive committee to set that qualifying fee at $1. Your executive committee may feel pressure from their people and the members of their party to set the qualifying fee for the state senate for $1. And they'll have that authority to do that if you pass this bill into law. What I think we did a few years ago is exactly what we should have done. We balanced access to the ballot with what is a reasonable fee for the office, and that's what we did. And we don't need to go break it. So, the amendment that is before you does two simple things. It takes all the state offices out. For governor, all the way on down, including this legislature, county offices, everything else stays the same amount of money, money goes to the same place. The fee for president, to run for United States president, is increased. It is currently $2,500. It costs $10,000 to run for president under the amendment. I think if you can't raise $10,000, you might not ought to be president. It raises the fee to run for United States Senate.
The numbers maybe not on the strike all when you're writing the numbers there. It's not coordinating with.
Excuse me. This is the amendment.
Right, you're amending the strike all now that we just did this amendment. We haven't adopted the strike all. Yeah, we just did.
Well, we did adopt the strike all.
So we're not, I don't think his numbers, I'm
Do
not
they
trying to get in your
correspond?
business, I just don't think some of those, like
Do
105 and
the numbers
106.
correspond to the committee side?
They correspond to the strike.
Let me continue. The amendment raises the qualifying fee for president. It raises the qualifying fee for United States Senate. It raises the qualifying fee for United States Congressman. It leaves everybody else alone. No change to state office, no change to the legislature, no change to the governor. Those fees will continue to be paid in the same amount to the same parties that they are currently. Raises the fee for president, raises the fee for United States Senate, raises the fee for Congress. That's what the amendment does. I'll be happy to yield for any questions.
Questions on the amendment? Senator Jordan, you're recognized for a question.
Thank you, Mr. President. And Senator Blunt, so in your opinion, there's no need to do anything about that? It's no need to change anything?
No, sir, I am proposing that we do change the fee for president, U.S. Senator, U.S. Congressman, but no other changes.
As far as the legislature, Senate or House, there's no change there?
I say, look, we've changed the fee last term, we've changed the qualifying deadline, I say we leave it alone.
Thank you, sir.
Thank you, Senator Jordan. Any other questions on the amendment? Any other questions? Seeing none, we're ready for your motion, Senator.
Move adoption of the amendment.
Senator moves for adoption of the amendment. All in favor signify. Whoop. I'm sorry, Senator Fillingane wants to respond. I apologize. Senator, you're recognized.
Thank you, Mr. President. I would oppose the amendment. I mean, if you don't want to do what we're doing in the bill, the thing to do is just to vote against the bill. And what he's trying to do is rewrite the language, and it's just, I think, not accomplishing really anything. So I'd ask that you oppose the amendment.
Okay. Senator?
Move adoption.
Senator moves adoption. All in favor signify by saying aye. Aye. All opposed, no. No. The noes have it. Let's go. Amendment number 2.
Thank you, Mr. President. Amendment 2 takes the legislature out of it. Only change from what's proposed by Senator Fillingane's amendment is the legislature stays the same. No other changes. Happy to yield for any questions. There are no questions.
Any questions? Any questions? All right, Senator Fillingane. Recognize, Senator.
Thank you, Mr. President. I would oppose this amendment as well. If you're wanting to talk about incumbency protection by taking us out and treating us differently than everybody else in the bill, I think we would be begging for some serious scrutiny. So I would ask you to oppose this as well.
Okay. Senator?
This fee that I think many of us voted for last time is a reasonable fee. And if you turn this fee over to the political parties and they raise it, you're going to be criticized. You're going to be criticized for that. And you should be criticized for that if you vote for this bill, and I ask you to vote for the amendment.
Okay. On the motion, all in favor signify by saying aye. Aye. Opposed, no. No. The noes have it. On the bill, Senator. Senator Fillingane, you're recognized back on the bill. I think it's actually, is it committee sub?
We've adopted the strike all, so now we're just ready to move adoption based on the morning roll call.
Senator moves for adoption based on the morning roll call. Anyone object to the procedure? Senator Bryan.
I'd like to speak on the bill.
Please proceed.
I was told that the instigation of this bill was based on the desire of the Republican Party to raise money, which seemed odd to me. I'd always thought the Republican Party had more money than most small nations. But apparently they're hard up, out with a tin can trying to raise money. So then asked to pass the bill. I didn't realize for certain that this bill had this partisan background until I started hearing the term Democrat Party. I don't know what leads some people to use improper grammar and syntax. I'm guessing, if I had to guess, that years ago there was a focus group, and the term Democratic Party polled better than the term Democrat Party, and the word went out to everyone, start saying Democrat Party every time you can. I don't know. But it's tempting to point out that Democrat comes from the word democracy, which basically means the people rule. Then you have the term Republican, which basically means the publicans again. But having said all of that, it's just a terrible idea to have political parties setting the fee to run for office. There is a real danger in having fees too low. If a voter is trying to cast a vote, in this state, that voter's got more offices than Carter has little pills. They've got all these offices to deal with. Then, if you get to the office that you're voting for, if there are a dozen or so candidates, many of them fringe candidates, that's an injustice to the voter. And it's not that unusual to have a fringe candidate whose last name is similar to a major party, a major candidate, run just for purposes of creating confusion. And maybe y'all are too young to remember in 1971 when they got Andrew Sullivan to run against Charlie Sullivan, but I remember that. And so if you're running for governor and you can't come up with a couple $1,000s for a filing fee, the problem you're going to have getting elected governor is not the amount of the filing fee. So there needs to be a reasonable fee to filter out non-serious candidates and to make sure that you have on the ballot choices that a voter can intelligently make. But that's a different issue than what's before us. Because what's before us is an attempt just to turn it all over to political parties. And regardless of the amount of the fee, which I think is a debatable proposition, I can't imagine why we would want political parties setting the qualifying fees to run for public office. We are long past the days when a political party was thought to be a private group that could just do anything it wanted to. Political parties are now a regulated part of our political system in this country. And it's just a terrible idea to have the qualifying fees set here, yonder, and there by political parties. And finally, returning to the partisan nature of this bill. This bill has the potential to put more money into the pockets of state political parties. And there are two parties in the state of Mississippi that are doing everything they can to elect Republicans. The Mississippi Republican Party and the Mississippi Democratic Party. And I'm against the bill.
Senator Fillingane.
Thank you, Mr. President. In closing, I'll just try to be very brief. The premise behind this is that we as elected legislators ought not to be in the business of determining what goes on with the political primaries. And if you trust the party that you're affiliated with, if you're a Democrat in here, you trust the Democrat Party, you ought not to have a problem with this bill. If you're a Republican like me in here and you trust the state Republican Party, you really ought not to have a problem with this bill. The only problem that I could foresee anyone having is if you don't trust your own party to set fees at the right rate. And I think maybe some of us do have those issues, but regardless, if someone determines to use this as a fundraising mechanism, shame on them. I think that party will soon suffer by having fewer and fewer candidates, and the other party will benefit by having more and more candidates if that's what ultimately ends up happening. I don't think that's the purpose behind this at all. So with that, again, I would move adoption based on the morning roll call.
Senators move for utilization of the morning roll call. Anyone object to the procedure? Wish to be recorded as voting no. Mr. Clerk, Chisholm, Hickman, Sojourner, Hill, Suber, Frazier, Butler K, Blunt, McDaniel. McDaniel present, Mr. Clerk. Branning present, Mr. Clerk. Thomas, no. Simmons, no. S. Simmons, no. Seymour, no. Present. Seymour is present. Bryant, no. Turner, no. Butler, no. Jackson, no. Norwood, no. Barnett, no. Jordan, no. Blackman, no. Anyone else? Anyone else? Seeing none, Mr. Clerk. Do introductions. One more, please. With 18 noes, it passes. Senator England, for what purpose?
I have two introductions out of order, Mr. President.
Please proceed.
Thank you. Ladies and gentlemen of the Senate, I'd like you to please help me make welcome here our father for our junior page, Olivia Barton, Mr. Josh Barton, who is Executive Director of the Home of Grace, which is an awesome faith-based recovery program down in Jackson County. Josh, we're happy to have you here today. And Mr. President, we also have in the South Gallery Mr. Julian Rankin, who is Executive Director of the awesome Walter Anderson Museum of Art down in Ocean Springs. Glad to have you here, Julian.
Thank you.
Thank you.
Thank you very much, Home of Grace. It's a very special place. Senator Frazier.
Introduction out of order, please.
Please proceed.
I would like the Senate to make welcome the widow of my predecessor, Doug Anderson, Mrs. Josephine Anderson, who's also a former election commissioner, and she's joined by her daughter Jackie and her little granddaughter, little Miss Woods. Please make them welcome.
Thank you. Thank you, Senator Harkins, for announcement.
Introduction out of order.
Please proceed.
Ladies and gentlemen, in the South Gallery, I've got a good friend of mine and the chief of the Reservoir Fire Department, Scott Berry, is up here. If you would please give him a warm welcome.
Thanks, Scott. Okay, Mr. Clerk, please read the title.
Senate concurrent resolution extending the deepest sympathy of the legislature to the bereaved family of former Senator and Secretary of the Senate George P. Smith of Wiggins, Harrison County, Mississippi, and paying tribute to his career of public and charitable service.
Thank you, Senator Seymour. We're back on the calendar 65, Senator Tate.
Yes, sir. I ask that we skip number 65 and 66 and have let them remain on the calendar.
Remain on the calendar. Senator Branning. Thank you, Senator Tate. Senator Branning. Passed. Senator Branning passes. 67 and 68 retain their place on the calendar. Chairman Moran. Chairman Moran. Chairman Moran passes. 69 retains his place. Senator Fillingane. Senator Fillingane, we're on 70.
Thank you, Mr. President. I'd like to skip item 70 and have it retain its place on the calendar and go to item 71, call up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2543, Department of Public Safety, revised provision related to.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. Aye. Opposed, no. The ayes have it. I'm sorry. Go ahead.
I move that we go to the committee substitute in lieu of the original bill and ask that you recognize Senator England to explain.
Senator England, you're recognized to explain the committee substitute.
Thank you, Mr. President. Thank you, Chairman Phillingain. Ladies and gentlemen, this SB 2543, and specifically this committee substitute, has been requested by our Commissioner of the Department of Public Safety to make some changes to the code here. And I'm going to go through these section by section so you can keep up if you've got it pulled up with you on your computer. Section 1 is just kind of doing a few housekeeping things there. It cleans up the language in lines 45, I believe it's 45 to 47 here. What? Sorry. Lines 45 to 47 cleans up the language to reflect the proper names of the Office of Forensic Laboratories and Mississippi Forensics Laboratory and the Office of the State Medical Examiner. And it also adds the Driver Service Bureau and the Commercial Transportation Enforcement Division as separate offices under DPS. If you'll remember, we moved MDOT and or the CTED was moved from MDOT and MHP was removed from DSB last year. So we just put those in as their divisions there under the DPS code. If you'll go to Section 2, Section 2 simply sets the same job protection standards for employees of the Mississippi Bureau of Narcotics as are currently held by the troopers with the Mississippi Highway Patrol Department. And it removes unnecessary language regarding Mississippi Bureau of Narcotics transfer of pins, which was done when they moved to DPS back in 2004. So that's just some old language that comes out and is deleted at lines 195 to 212. Section 3, what this section does, it allows for the office that employs the state medical examiner, physician, or pathologist to charge hourly fees for expert testimony from the employee when they go from when they're called to go testify as a medical examiner, physician, or pathologist. The section specifically allows for the expert witness fee to be set by the director of the Office of the State Medical Examiner, and there is a requirement that the fee be reasonable. On Section 4, I do have an amendment here to some language that came up, and so what I would like to do, instead of presenting what we have in front of you, I want to go ahead and move to adopt this amendment to the committee sub. Do you have this? Oh, I'm sorry, we do. We need to adopt the committee sub first. So if we can do that, I would ask, my motion is that we adopt the committee sub.
Motion's been made to adopt the committee sub. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator England.
Thank you, Mr. President. At this time, I would move that I would like to present an amendment to the committee sub.
Would you please present the amendment to the clerk?
Okay, and that's on the screen. Thank you.
Okay.
So this portion of the bill had some very good questions raised during committee. So we've gone back and worked on that. What this section does is it allows for the folks in the Department of Public Safety to testify remotely in certain cases, and we've come in and we've added language that requires that notice be given to the party, to the defendant. The notice has to be at least 90 days, and the defendant can then provide, if the defendant does not provide a written objection within 14 days, then the judge can then allow, at their discretion, the individual medical examiner or whoever from DPS to testify remotely. So that allows for a process for that to happen, which makes things more convenient and will be a cost-saving measure. But after some very good questions on that, we did put that in. We had that language addressed. And I would mention that there was some work that was done with the state the state public defender on this as well. So this was run by, and we were able to come up with some good language that I think everybody was okay with to allow for the DPS to save some money where they can for that. And it also helps avoid backlogs and certain things when they can.
All right, Senator Simmons, for what purpose you seek recognition?
Question on the amendment.
You're for questions, Senator.
I do, yes.
Senator Simmons, you're recognized.
Thank you, Mr. President. Thank you, Senator, for yielding. I know that you said you've worked with a number of senators in the committee as well as the state public defender regarding this amendment. I guess my concern, Senator England, as you know, is should we be even touching this or even trying to put this in statute as this is something that should be done by the court as a separation of powers issue?
Yeah, and Senator Simmons, I think that's a good question, but I think that what the courts are looking for and what attorneys were looking for was some guidance on that to have this where it was specifically allowed. So whereas now a judge doesn't have any direction of that they can do that in a statute, this is providing them with that language.
And I guess my concern, Senator England, is just the confrontation issue. I know that was raised in committee. And what should happen regarding a witness testifying in a court of law? Should it be determined by the gatekeeper, which would be the judge? And of course, if there's an objection by the defendant and or his or her attorney, then the judge would be able to consider that objection and make the necessary rulings. But by putting this in statute, I guess, are we potentially violating separation of powers as set forth in case law?
Yeah, and Senator Simmons, that's exactly the question that we had in committee. And if you'll look at what we've done with this amendment versus what came out of committee with the committee sub, we have allowed a process by which the defendant has to be given 90 days notice that this is something that they would like to testify remotely, the expert in that case, and then if they file a written objection within 14 days. So we did add a process for them to look at and to give them the option to object to that. And I do believe that we're still, we still have this with the discretion of the judge. So we're not really taking away the gatekeeper duties, so to speak. We're just making this an allowable thing. We put forth a process by which, a timeline that they have to present that they want to, they would like to testify remotely, and if you object to it, they can object to it. They just have to do so within 14 days prior to the testimony.
And let me get your comment regarding this. Mm-hmm. In 2017, the Supreme Court had a study committee over a few years, mm-hmm. and the Mississippi Rules of Criminal Procedures actually were in fact adopted, and they were put in effect. And Rule 1 of the Mississippi Rules of Criminal Procedure that deals with the scope of the rules. And I'm just going to read here, and I just want to get your comment regarding that. And these are the rules of criminal procedures as set by the Mississippi Supreme Court. These are the Mississippi Rules of Criminal Procedure and shall govern the procedure in all criminal proceedings from arrest through post-trial motions in all trial courts within the state of Mississippi. And in the comment of Rule 1.1 that deals with the scope, this is the comment that is set forth by the Mississippi Supreme Court in the Mississippi Rules of Criminal Procedure. It is now well established that the constitutional concept of separation of powers dictates that it is within the inherent power of this court to promulgate procedural rules to govern judicial matters. Thus, when a statute conflicts with this court rules regarding matters of judicial procedure or our rules control. And that was the State versus Delano case in 2011. And I guess my concern is anything, Senator England, that deals with witnesses, how they should be notified, whether or not they should testify electronically or in person. I just believe it's a function of the court. But your opinion regarding that?
Yes, Senator, I think that was a very good, you read that very well. I think it's a very good statement. And that was the State versus who now? What was the case?
State versus Delaney.
Oh, okay, I thought you said Delano. I thought we were...
No, certainly not Delano.
I was going to explore that a little further. All right, well, I would just point out that on line 7, it says, this is allowed. So this simply gives the Department of Public Safety the option to do it. It allows the judge to still, so we still have the separation of powers, but again, it gives some direction in this area. And I think a lot of things may be headed this way where we're having remote testimony in certain instances. When we saw that, we've got courts that are backlogged right now still because of unable to have court due to COVID issues and whatnot. But this just allows the Department of Public Safety the option to do it, and then it allows the judge the option to do it. So we're not requiring it.
But thank you for your work, Senator England. But as this bill moves through the process, I really will ask you to reconsider this portion of the bill. Thank you.
Okay, thank you. And, I'm glad you mentioned...
Thank you, Senator Simmons. Senator, did you have anything else on that?
Mr. President, I did. Well, I didn't want, especially if he's leaving, I wanted to mention that we do have on this amendment, we're also removing the reverse repealer with this new language in. I didn't explain that earlier, and I wanted to make sure that I was clear with you on your questions, Senator Simmons.
Thank you, Senator England. Senator Thompson, for what purpose?
Introduction out of order, Mr. President.
Please proceed.
Ladies and gentlemen of the Senate, if you will, please help welcome the Coast Episcopal 4th grade class with Miss Kelly Duffy in the West Gallery. Guys, stand up and welcome to your state capitol.
Senator Barrett.
Thank you, Mr. President. Question?
For you for a question, Senator England.
I do yield, yes.
Senator Barrett, you're recognized.
Thank you, Mr. President. Senator England, thank you for your work on this. I just want to be crystal clear that this in no way usurps any power from circuit court judges in setting fees or determining how witnesses and cases will be handled, correct?
That's correct.
Okay, thank you.
You're very welcome.
Thank you, Senator. Any other questions? Any questions? Seeing none, we're ready for the motion, Senator.
I move that we adopt the amendment.
Motion is to adopt the amendment. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
Thank you, Mr. President. Okay, well, now that we've got that amendment in, I'm going to keep rolling down through the committee sub that has just been amendment. We're going to go to section 5 now, if you'll follow me to section 5. The purpose of this section is to allow employees of the crime lab, the employees of the crime lab, they have a very specific skill set, and what DPS would like to do is be able to set the salaries of these to keep up with different hospitals and universities and neighboring states. So if you look at lines, lines are going to be changed, but this provides the Commissioner of Public Safety with the discretion in hiring and setting salaries of the employees of the crime lab and the medical examiner's office. Of course, they would still have to do so within their budget, but this just does give the discretion to the Department of Public Safety to do that, to hire these very professional and skilled employees. Section 6 and Section 7, I'm actually going to explain at the same time because they essentially do the same thing. Section 6 deals with your firefighters and law officers, law enforcement officers, whereas Section 7 just kind of does the same thing for your local emergency management folks. What this does is it allows for the Commissioner of Public Safety a little more discretion when the legislature appropriates money to determine that there was an in the line of duty death, like we've had with COVID. We had that. You'll look on the underlined portions there under those sections. You'll see that the Department of Public Safety may pay certain claims for death benefits that it finds to be the result of unforeseen or unprecedented circumstances. So that would allow just a little more discretion for determining if there's inline duties. And of course, if you look again, it says upon specific appropriation at the top there. So that would come directly from the legislature. Another thing that this does, and that's again, so let me say that's a $100,000 death benefit that is paid to the family members of the officer that died in the line of duty. If you'll look next, you'll see kind of what we're going to set up. It says a person who is a beneficiary of a life insurance policy under subsection 5 of this section shall be ineligible from payment of those $100,000 funds. And if you look under section 5, that's going to be new, or subparagraph 5, that's going to be new language here that allows the Commissioner of the Department of Public Safety to consider purchasing life insurance policies for officers. And that would be in the amount of $100,000, and it would not matter if it was an in-line of duty death. So if you had an officer, we had the very brave gentleman, I believe, who was from DeSoto County, that was a rescue swimmer that went out on vacation and swam out and rescued some children and ended up passing away. Well, unfortunately, that was not in the line of duty. He was off duty at the time. We have the same thing with a very brave firefighter down in Jackson County that found out he had cancer and died very quickly thereafter. If the Department of Public Safety Commissioner was able to purchase these $100,000 life insurance policies, those individuals would have still been paid the $100,000. And again, this also, I know we've had, at all levels of our government here in Mississippi, we've been looking to recruit the best and the brightest first responders. This is a recruiting tool as well. If you can tell folks to come into Mississippi and they'll have a $100,000 life insurance policy, regardless of cause of death, that's a very good recruiting tool that we can use here to help keep people here in Mississippi. And the benefits would just be tremendous for our state, for the for the commissioner to be able to do that. Section 8, this is very easy. This is just an old law that nobody uses anymore. It repeals Mississippi Code Annotated 973527 that requires that convicted felons register with the chief of police or sheriff of the jurisdiction in which they reside. And I would note that this does not affect sex offender registry. No. This is it. Section 9, the last portion of the bill, provides the effective date of July 1st, 2022 for the terms and statutory changes outlined in the bill. So very quickly, I know that was very quick and brief, but that is what this bill does. We have adopted the committee substitute. My motion now is I move for final passage of this bill by use of the morning roll call, if there are no questions, Mr. President.
Questions? Seeing none, Senator move for final passage by use of the morning roll call. Anyone object to the procedure? Senator Hill?
Question.
All right, we'll yield for a question before the motion.
Just one question.
One question. Did you work with the Department of Public Safety on this bill, or where did it come from?
I did. I worked directly with Commissioner Tyndall, and I know there were other individuals involved with this bill. And I didn't author the bill. This is, I believe Senator Fillingane also worked with, I know he worked with them as well. But I've had several early morning meetings with.
So they're good with the provisions in this bill?
They are. They've requested them and have worked very closely
thank you.
with us. Yes, thank you.
Thank you, Senator Hill. Any other questions? Other questions? Seeing none, we're ready for your motion now. Senator England.
Yes, motion is for final passage by use of the morning roll call.
Morning roll call has been requested. No objective procedure. Wish to be recorded as voting no. Present. Seeing none, the bill passes. Thank you, Senator England. We're on Chairman Wiggins. We're on 72.
Thank you, Mr. President. I go to item number 72. Call that up, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2451, Mississippi Equal Pay Act, enact.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Thank you, Mr. President. Mr. President, we have an amendment at the desk. I'd like to call that up.
It's on the screen.
Can't say I don't learn. This is a reverse repealer, and I would like to ask if Senator Simmons could speak on the amendment. And this amendment is, if Senator Simmons could speak on the amendment.
Please proceed, Senator Simmons.
Thank you, Mr. President. Members of the Senate, this amendment, of course, puts the reverse repealer in a very important piece of legislation that is important to all of us. Equal pay, I know Senator Boyd has been sponsoring legislation regarding equal pay for a number of years. And certainly our colleague, Senator Tammy Witherspoon, was doing the same. And after Senator Witherspoon left, Senator Turner Ford picked up the baton and also sponsored legislation regarding equal pay. As you all know, Mississippi is the last state in the union not to have equal pay legislation. We all care about equal pay. I think that this bill needs work. I know I've spoken with Senator McDaniel and he also believes that this bill needs work. So as this bill moves through the process, I'm just asking you all to support this amendment because we all want to have an equal pay bill in the state of Mississippi. Now, of course, my position is the best equal pay bill is an equal pay bill in the state of Mississippi that mirrors the federal protections that we have. Of course, some of my colleagues in this chamber believe that equal pay in the state of Mississippi should look a little different than what we have under the federal law. But whatever comes back from conference, I will say that by supporting this amendment, it certainly means that you care about equal pay for women, and women deserve equal pay for equal work. And so I ask you to support the amendment.
Speak on the amendment, Senator Wiggins.
Thank you, Senator Simmons. I will also say I appreciate Senator McDaniel. He's brought forward some good amendments. As Senator Simmons says, there's work. We've heard that. I appreciate the committee's work on it. We are the last state, and I think this amendment does a good job getting us through the process. I think, again, Senator McDaniel's amendments have a good place, and we just want to get it in the right place so that we can bring this back to this body and have a full vote on this and no longer be the last state. But it needs to be done in the right way, and Senator McDaniel brought up some good points in committee that I think are warranted to be considered, and I appreciate that. So I would ask you to adopt the amendment, and I would ask that we move adoption of the amendment, Mr. President.
Adoption of the amendment. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We're on the bill. Senator Wiggins.
Oh, you have a question?
Any questions on the bill?
Yeah.
Senator Boyd, do you have a question on the bill?
At the appropriate time to speak on the bill.
Okay, it's appropriate time. We see no other questions. Senator Boyd's recognized to speak on the bill.
My motion, Mr. President, I'm sorry, would be to, that we pass this bill on the morning roll call.
Okay, Senator, you're recognized. Senator Boyd's recognized.
I think this body has shown now, I believe on 2 or 3 occasions, that this is something that we want to see. And we see all the parties trying to come together to look for a bill. But I think sometimes we miss in the process of getting the technicalities of it this way and that way. We kind of are missing the forest for the trees sometimes on this issue. I had a very interesting conversation this fall. I invited young law students, men, women, Republican, Democrat, white, black, to my home. And I started discussing issues with them on why they were leaving the state. Why is there a brain drain? Why are so many of those young, bright Mississippians going to leave our state and go to another place? I have to tell you, every one of them brought up this issue. Now, for many of you, you say, well, there's a federal law, and we can go, those students, if they feel like there's injustice, that they're not getting equal pay, that they can go to the federal law. One student put it a student actually who's paged in this chamber, put it very succinctly. She said, because it shows my state values my work as a woman. And with a state law, they're going to make sure that if I'm doing an equal job as a man, that state law is going to protect me. When she said that, the young men in the room applauded her because they said they wanted the same protections for their wives, for their daughters, for their mothers, and their sisters. So in the process of us working through this law, let's get a good law. It's not going to be perfect, but don't let perfection be the enemy of good here. And let's send the signal to these young women who are leaving our state that this state protects them and make sure that they are going to get fair treatment under this law. Thank you.
Senator Wiggins, we're ready for you. Senator McClendon, did you have a question?
Question for Senator Boyd.
Question, Senator Boyd, will you yield?
Friendly question. Thank you, Mr. President.
Yes, Mr. President.
Please
Thank you,
proceed.
Senator Boyd. Senator Boyd, did you know that my wife Vicki's been in the aviation industry since she was 21 years old, and she has fought this fight since then. I spoke about my two sons, so I might as well speak about my wife. I'll just make it a trifecta. She worked her first job as a flight engineer. She made 33 cents a passenger in New York City, flying out of LaGuardia. She went on an aviation interview for the world's largest package delivery company, and one of the questions that was asked of her was, "Are you through having babies?" It's been that way her entire career. She got hired by a Fortune 100 company. She just left that table to go fly the CEO of that Fortune 100 company who makes $25 million a year, who entrusted her, who moved from the north, where there's nothing but unions up there. I'm not saying anything against unions, but I know Mississippi has fought a long time to keep unions out. Do you think if we don't do something, is this a way that unions could possibly come barreling into our workforce? Thank you.
Senator McClendon, I wouldn't guess to make statements in regards to that. What I will state is, this is a symbol, just like we have fought so hard to make changes to the symbols that represent our state. When we're the only state in the country that doesn't have state protections for women, that is not the message that we need to send. If you're an international company and you're a female CEO, do you really want to open a company here when you see that this state doesn't have those protections for women? It is a message that is no longer appropriate that we send. Let's make this change. Let's get this bill done. It has been before this legislature far too many times, and let's get this bill done this year.
Thank you, Senator Sojourner. Do you have a question?
A question for Senator Boyd.
Senator Boyd, will you yield for a question, please? You're recognized, Senator.
Yes, Mr. President.
Thank you, Mr. President. Thank you, Senator Boyd. I know this is an issue that you are extremely passionate about, as I am as well. We just happen to be on opposite sides of this bill. I rose in opposition last year to speak against it. I'm not going to do this this year. However, you mentioned a point where you said that you wanted the legislature to validate women's work in this state by passing the bill. That was the comment that you discussed when you brought the young people into your home. I think that you are a very strong and capable woman, and I don't think you need any government body to validate your work. And I certainly know I don't. I've spent my entire life working in a male-dominated industry, and if I think I'm being untreated fairly, don't I have the right to leave? Don't I have the right to not put up with being treated unfairly currently?
You absolutely do.
Okay, so I want it to be known that as women, I don't want to be pandered to. I appreciate what you're trying to do, but I also respect the business community and their ability to make these decisions. We do have a federal law. I'm not going to rise and speak against it, but I do know we're on opposite sides of this.
Thank you, Senator Sojourner. Absolutely. And we want to make sure, this is why we're working through this process here. We want to make sure that this bill is very fair to the business community as well, but we also want to make it fair to the employees. Because in this day and age, a woman shouldn't have to quit her job to make a statement that she's not being paid an equal pay as the man. This has been going on for far too long, and there is subtle discrimination in many instances, and you should be very blessed that you never had to experience this as a woman. So,
I have, trust me, I have, but I have that right as an individual to defend myself. I don't need the state to do it.
thank you.
For what purpose, ma'am?
I have a question or two.
For Senator Boyd. Senator Boyd, will you?
Either Senator Boyd or
Senator
or the
Boyd,
chair.
you're for a question. Senator Wiggins. Please proceed, madam.
Thank you, Mr. President. Thank you, Mr. Chairman. I understand that a reverse repealer has just been added to the bill.
Correct.
My question is, what, if any, opportunity have committee members had to present amendments regarding the issue of pleading with particularity?
I'm not sure if I understand your question. I mean,
Has there been an effort to amend this bill since it's been before the Senate?
well,
In committee?
in committee, there were no amendments that were made. And so we're here today on this. We now have a reverse repealer. And the reverse repeal, there were issues that were brought up in committee. And that's why we're doing the reverse repealer. So as Senator Boyd said, we can get a good bill for the state of Mississippi.
And will there be opportunities going forward to address that issue of pleading with particularity?
Well, that's, as you know, with the reverse repealer, that ends up in a conference committee. And there is a House bill that has been sent over. So there are at least a couple vehicles to do that. And I have not personally read through all of the House bill, but I have heard that the Senate bill is actually is a stronger bill than, and when I say stronger, I mean a better bill for women, if you will, than the House bill. So, but that's why we got a reverse repealer, and we'll go through the process in the conference committee.
And will there also be opportunities to discuss whether wage history will be considered regarding a potential applicant or someone who's on a job and receiving wages?
Well, if we, assuming it goes to conference, which it has to with the reverse repealer, then those are certainly issues that can be addressed.
Thank you.
Thank you, Senator Turner. Anyone else? Senator Pope.
Question, Mr. President.
Are you for a question, Senator?
Yes.
Please proceed, Senator Pope.
Thank you, Mr. President. Senator, I've sat here and listened, and I need to have everybody look at this from a business point of view. I hope that when y'all go into the conference that we'll probably end up in, that you maybe consider small businesses like the one that my family owns and my daughter, who is CEO, runs. Because here's what happens. If you don't write the law to where it is as difficult to sue in Mississippi as it is the federal government, I'm going to get sued twice sometimes. Now, you say, well, you should win the case. We normally and most often do. But you know what? When we win the case, it costs my company as much as $10,000. And you know why? Because I have to hire attorneys to defend that I'm right. What my suggestion to you and my question to you is this bill going to be an anti-business bill by opening up to many, many lawsuits that right now we're already open up to the federal government?
100% no. This bill that's before you is modeled after Alabama, which passed it in, I think, 2019, supported by their business community. My understanding, I will defer to Senator Boyd on this, that their BIPEC has been discussed. Attorney General Lynn Fitch has had those, her office has had those conversations. The business community is fully aware of it. Also, that's the issue that Senator McDaniel brought up in committee, which I think was a good issue. And that's why we're putting the reverse repealer in that. So that issue as well can be determined as we go forward, and certainly in conference.
All right, thank you for mentioning the Attorney General's office. Would it surprise you to know that I was talking to one of her high-ranking attorneys about this bill. We were discussing it at length, and I expressed to her my problem with how we have to defend, I'm going to call it frivolous lawsuits many times. And I asked her, I said, you're an attorney, do this for me. Send me a letter that says, my company, if you should lose an equal pay lawsuit, that you, the attorney, will reimburse me if I win. If I win the lawsuit, instead of me paying the attorney, her pay the attorney.
The Attorney General?
The Attorney General's assistant. One of her chief legal people. I am still waiting for that letter.
I would suggest that the Attorney General herself, along with that person, meet with you and discuss that issue. Or send you the letter. That's all they need to do, so.
Thank you, Senator. Senator Horn, for what purpose?
Introduction out of order.
Please proceed.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I'd like to direct your attention to the South Gallery. We have members of a long-standing group that's been involved in voter education and voter participation for several decades. I'd like to ask the members of the A. Philip Randolph Institute if they would stand and have the Senate make them welcome.
Thank you, Senator Branning. Senator Branning.
Question, please.
Were you for a question, Senator?
Yes.
Please proceed, Senator Branning.
Thank you, Mr. Chairman, for your work on this. I think we've had the conversation, and you know that I own my own law office, as well as multiple other businesses back home. I've run these businesses for years and years. And like Senator Sojourner, I certainly don't need the government to defend me. I think I do a pretty good job of that myself. I'm concerned about the double recovery portion in the bill, and I appreciate again seeing you all work together. So I'm asking if you will take that into consideration as you do move into conference, and please know that that is a major concern that I have from a business perspective.
Most definitely. Let me say this again, that's Senator McDaniel, what we're working on. In the current bill, you cannot double recover. But what, Senator, we've been having discussions about is because you have a federal and a state, and, you know, going back to Senator Polk's question about how many times you can go to the well, we want to minimize that. So, yes, you have my word that we'll work on that. It's a reverse appeal. With that, I would ask that we do vote for it so that we can send this on. I think we're at a place where we're trying to get to these issues.
Thank you for your work.
Thank you.
Mr. President, I'd ask that Senator McDaniel be allowed to say a few words.
Speak on the bill.
Thank you, Mr. Chairman. Mr. President, I won't be, but just a moment. I want to start with a general proposition first and try to express my wishes from that. I think everyone agrees that there should be no discrimination in the workforce. That's a given. Equality, the rejection of collectivism, whether it's race or gender, has to be a preeminent consideration for this chamber. In other words, in everything that we do, we empower the individual. Whether that be economically or socially or culturally, we empower individuals. But sometimes we lose track of that in the prisms of collectives, whether they be race or gender. So to start the conversation, I'm very clear, I want to see equality. Sometimes the state isn't the best way to do that. Sometimes it is. It just depends on the issue. The danger here is that sometimes when a bill is as politically sensitive as this one, because you know how it works, if one of us were to vote against this bill based on some bad policy we foresee or some technicality we think is problematic, it will be demagogued that somehow we are against equal pay. That's not the case at all. We're just trying to get there as best we know how together with a bill that's clean and makes good policy. To Senator Polk's point earlier, the bill as it originally looks does provide a petitioner or a plaintiff with the ability to file 2 lawsuits. Now, Senator Polk, that might be good for attorneys because I spent my life defending those lawsuits, and that would pretty much double my fee at any given moment with the corporations that I represent. But it's not good for the economy, and it's not good for the corporations. Here's the way it would work. You would have 2 bites at the apple, one in federal court, one in state court. And then the plaintiff would be allowed to choose and pick the higher of the two verdicts. That would force us to try the case twice, raising legal fees and raising the settlement value of the claim, thus encouraging more frivolous litigation. That's one of the parts of the bill we want to fix. And there are other components I think can be improved. I am curious as to the concept of equality, because I think when we talk about equality, that would also include preferential treatment. And if we're going to be equal across the board, this might be a good time for us to look at ourselves in the mirror and recognize that equality means perfect equality. No hiring preferences, no promotion preferences, but equality. And these are things we have to search for as a body to make good public policy. Now, this bill isn't quite there, in my opinion. But I would tell you this, Senator Wiggins, wherever he is, has done a really good job trying to get different thoughts. And Senator Simmons as well has been really, really helpful in this regard. And though we may disagree ultimately on the final outcome, moving it forward for further consideration makes an awful lot of sense. Those are my thoughts on that. And again, I'm not sure how I'll ultimately come down on this bill, depending on how the language is ultimately drafted. But I want to be clear that we all support the common goal of equality in pay and every other part of the allocation of resources. Thank you.
Thank you, Senator McDaniel. Senator Turner,
Request for permission to speak on the bill.
please proceed.
Equal pay for equal work. Equal pay for equal work. This is a problem that many citizens have faced, not just here in the state of Mississippi, but throughout the nation. And up until 2019, there were only 2 states that did not have equal pay laws: Alabama and Mississippi. Alabama, to some extent, rectified their problem. We have not. Part of the issue is that the law that Alabama passed basically tracks what we're attempting to do here today. I have an issue in particular with this language that calls for pleading with particularity. For those practitioners of the law that are here, that is not the standard that we typically deal with when we file lawsuits. We're required to file a short and plain statement that provides basic information about the type of lawsuit that we're attempting to file. The standard that's delineated in this bill basically requires a litigant, someone who's complaining about the pay that they're receiving, to express from the start to the finish how they believe they've been discriminated against. And I'm conflicted, because at this point I'm not sure that I can support this bill. I understand there's a reverse repealer, but this bill has been before us time and time again, and I have not supported it up until now. I have expressed my discontent. There are other issues. And so I don't want to give the impression that I'm in agreement with what we're doing. This bill does need work. I don't think that this bill puts us in a position where we need to do away with other protections that have been allowed for, provided in the law. This is about leveling the playing field. This is about making sure that people who line up on a job that are doing the same amount of work are receiving the same amount of pay. That's fair. And that's something if you own a business, if you're going to somebody's business, that shouldn't be a tall leap or a tall burden to give that consideration to the people that keep you employed and keeping you providing services to the community. Studies show that women make up 51% of the population of the state of Mississippi. That's nearly half of its workforce. And those women are the primary breadwinners for our family. And I'm just asking for latitude as this bill goes forward. Let's just do what's right for the people who are out there struggling, getting up every morning or going in every night, just trying to gain wages, earn wages, and to provide for their families. So I I don't know. I'll decide how I'll vote as I walk to my seat. But I think that this matter is important, and there are people who are suffering and they need our help. Thank you.
Senator Wiggins, you're recognized. Close.
Thank you, Mr. President. That's why we have a reverse repealer in it. Well said from all sides, and I would ask you to vote for the bill with it in there so that we can send this on and hopefully get to a point where we're no longer the last state. So my motion would be passage on the morning roll call, Mr. President.
Senators, request utilization of the morning roll call. Anyone object to the procedure? Anyone wish to record as voting no? No. Blackman. Anyone else? Turner, no. Present. McDaniel, present. Sojourner, present. Branning, present. Polk, present. Frazier, present. Tate, present. Anyone else? Present. Younger, present. Anyone else? Chisholm, present. Anyone else? Anyone else? Thank you. The bill passes. Chairman Polk, you're recognized.
Thank you, Mr. President. Go to item, like to pass go to item 73, ask the title be read.
Mr. Clerk, please read the title.
10, state employees provide terms and conditions for state employees to engage in telework.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Polk.
Mr. President, I'd like to consider the committee sub in lieu of the original bill.
You're
Ask that
recognized.
you recognize Senator Blackwell to explain.
Senator Blackwell, you're recognized to explain the committee substitute.
Thank you, Mr. President, Mr. Chairman. This is part of the peer package, one of their bills. I think most of us recall back in March of 2020 when we had a little incident with COVID, and during the pandemic, Governor Reeves issued executive orders that enabled agencies to initiate telework. Well, that was all good, but there were very few of the agencies had any policies. For instance, state agencies, only 28 had telework policies, while 62 had no policies. Of our universities, 4 had policies, 5 did not have policies. Community colleges, 4 had policies, 11 did not have policies. So what this bill does is it establishes in statute conditions under which state employees may engage in telework. Lines 38 through 55 talk about when telework may be authorized. Lines 56 through 75, some of the requirements placed on the agencies. That's an explanation of the committee sub. I'll yield for questions.
Questions? Seeing none, we're ready for your motion, Senator.
Move adoption of the committee sub.
Motion to adopt the committee substitute. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator, we're ready
Move for final passage on the use of the morning roll call.
Any questions? Any questions? Final passage by use of morning roll call has been requested. Anyone object to the procedure? Wish to be recorded as voting no? Present? Seeing none, the bill passes. Thank you, Senator. Senator Polk, you're recognized for 74, sir.
I'd like to pass number 74 and 75 and let them allow them to take their place on the calendar.
74 and 75 retain their place upon the calendar. Chairman DeBar. Chairman DeBar passes. 76 and 77 retain their place on the calendar. Chairman McDaniel. Chairman McDaniel, you're recognized. We're on 78 on the calendar.
Thank you, Mr. President. I'd like to go to item number 78, Senate Bill 2499. Ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2499, solid waste disposal law defined advanced plastic recycling.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Senator McDaniel, you're recognized.
Mr. President, I move to bring up the committee substitute in lieu of the original bill and be asked to explain.
You're recognized to explain the bill, Senator McDaniel.
A few days ago, Senator Carter did an outstanding job explaining his love of recycling from the well. And believe it or not, this is the exact same bill. We passed it unanimously, nothing terribly controversial. The only subtle difference is this. There were some technical amendments that the department, MDEQ, wanted to the bill. Those amendments did not go through Senator, the Energy Committee for whatever reason. I'm not sure why. It probably was just they're so busy. But because the Environmental Protection Committee had so much free time, we decided to go ahead and make those amendments. So all it does is satisfy MDEQ. That's the explanation of the bill.
Questions on the bill? Senator Carter, you're recognized for what
Don't you
purpose?
dare.
Question.
We yield for question, Senator.
Senator McDaniel, do you consider yourself as passionate about recycling as well?
Almost as much as you, sir.
Thank you.
All right.
Thank you, Senator Carter. Other questions? Other questions? Okay, Senator, we're ready for your motion.
I'd like to move passage by use of the morning roll call.
Senator moves by passage for, I'm sorry, are we on the committee sub? We got to adopt the committee
Move to
sub.
adopt
Senator.
committee sub.
All in favor signify by saying aye. Opposed, no. The
And
ayes
no.
have it. Now we're ready, Senator.
Yes, sir. Now move passage by use of the morning roll call.
Use of the morning roll call has been requested. Any more object to the procedure? Wish to be recorded as voting no. Present. Seeing none, but the bill passes. Chairman Polk.
Mr. President, I'd like to pass number 79, ask it retain its place on the calendar, and ask the title be read on number 80.
79 retains its place on the calendar. Read the title, Mr. Clerk.
Senate Bill number 2066, District Attorneys, increase annual salaries of. Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Polk.
I'd like to consider the committee sub in lieu of the original bill and be allowed to explain.
Committee substitute, Senator Polk, you're recognized to explain the committee substitute.
Thank you, Mr. President. This is a very simple bill. It raises the pay for district attorneys from $125,900 to $134,000, and it increases the pay of the criminal investigators in the DA office from $59,500 to $63,000. No questions. Use of the morning. Ask for passage of committee sub.
Okay, any questions? Any questions? Seeing none, all in favor signify by saying aye. Opposed, nay. The ayes have it, Senator. We're ready on the bill.
Passage use of the morning roll call.
Use of morning roll call has been requested. Anyone object to procedure? Wish to be, of course, voting no. Bryan, Chisholm, McDaniel, Sojourner, Hill, Seymour. Hill, Seymour, Mr. Clerk. Anyone else? Anyone else? Seeing none, the bill passes. Senator, Polk will recognize you on 81.
Mr. President, I'd like to ask that 81 and 82 be passed and hold their place on the calendar.
They're held up place on the calendar. Senator Fillingane. We'll move to 83. We anticipate finishing the calendar today or night.
Thank you, Mr. President. I'd like to go to item 83, called up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2536, Public Funds Offender Registry, create.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
And I move that we go to the committee substitute in lieu of the original bill and that you recognize Senator England to explain.
Senator England, you're recognized to explain the committee substitute.
Thank you, Mr. President. Thank you, Chairman Fillingane. Colleagues, this is a bill that I've worked on for the last several years. Feels like it's been a long time since we've been here. It's been only 3 years, I guess. I feel like I've been here for 10. But what this bill does, it's been carved down a lot from previous bills that I have introduced. I'm going to go through section by section here, and I will be quicker than I was on my last bill. This is a little bit shorter of a bill. Before I go into anything, I want to let everybody know that when I mention department in this bill, or when the bill mentions department, it does mean the Department of Public Safety. What this bill essentially does is it creates a registry of folks that have been convicted of certain crimes, particularly those crimes involving theft or embezzlement of state funds, or defrauding the state, or bribery. And if anyone that is convicted of those crimes will appear on this registry. The registry, again, will be kept with the Department of Public Safety. which is where we keep our sex offender list, so there's already a platform ready to keep up with registry. Now, speaking of the sex offender list, that is a permanent appearance on that list. This will not be. In this bill, you will only be on the list I've got in the bill currently for 5 years from the date of conviction or from the time that you finish your sentence. I do have an amendment, or I don't have an amendment. Senator Barnett here has an amendment after we adopt the committee sub that is going to also add to that requirement. If you have not paid your fines or your restitution or your penalties back to the state or to the municipality that you stole from, then you cannot come off the list until you've made your payments, which I think is a very good amendment, and I appreciate Senator Barnett for working on that. That is essentially what the bill does. I will mention, just for those that are interested, that the list will not include an offender's social security number, driver's license number. It will include the full legal name, the alias by which the offender is known. And again, look, the intent of this is to prevent people from stealing from the state coffers, to prevent people from stealing from their cities and their municipalities, from taxpayers and from ratepayers. And if they do that, if they appear on that list, this is in this bill, they cannot work for a municipality or a county or the state or a state agency in any office of accounting, a registrar's office, or anything dealing with finances. These folks that appear on this registry have proven that they aren't to be trusted with state funds, and this will keep them off there. If you do, if folks that end up on this registry, if the offenders that end up on the registry, if they do pay back all of their fines and the restitution and complete their sentences, they can petition the Department of Public Safety to come off the list immediately. So there's an incentive for these folks to pay the money back and get it back into our school districts or back into our counties where they can be used because these are the people's funds. That is what the bill does. I'm going to ask, well, I know we do have to adopt the committee sub before we move to the amendment, so I will move that we adopt the committee sub.
Questions? Okay, Senator Suber. For what purpose you seek recognition? Senator Suber. Pass. Anyone else? Anyone else? Okay. We have a motion to adopt the committee substitute. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator Barnett, you're recognized. Explain the amendment.
Thank you, Mr. President. Thank you, Senator England. I think Senator England has already explained the amendment, and so I just moved to adopt the amendment.
Questions on the amendment? Questions? Seeing none, motion's been made. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Back on the bill.
Thank you, Mr. President. If there are no other questions, I do move for final passage by use of the morning roll call.
Use of the morning roll call has been requested. Anyone object to procedure? We should be, of course, voting no. Present? Seeing none, the bill passes. Thank you, Senator England. Chairman Bryan. Chairman Bryan. We're on Chairman Bryan. We're on 84, sir.
I'm assuming we're at item 84.
Yes, sir, we're at 84.
I ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2725, medical records require health care providers to provide within 30 days of patient's request.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Bryan.
Strangely enough, the bill does exactly what the short title says. It simply says that if you make a written request within 30 days, the medical facility has to provide you with your records. I talked to some hospitals, other providers. Basically, they said we don't have any objection to this. We certainly ought to be doing that as a matter of course anyway. So if there are no questions, I suggest use of the morning roll call.
Questions on the bill? Seeing none, the Senator has requested utilization of the morning roll call. Anyone object to the procedure? Wish to record as voting no? Present? Seeing none, the bill passes. We're on 85, Chairman Wiggins. Chairman Wiggins passes on 85. Next page. Chairman Tate. Chairman Tate. Chairman Tate passes on 86. 87, Chairman Blackwell. Chairman Blackwell, 87.
Thank you, Mr. President. I'd like to skip 87, ask it to keep its place on the calendar and go to 88. Have the title read.
Mr. Clerk, please read the title. 87 retains its place upon the calendar.
Senate Bill number 2664, Medicaid services require Medicaid to reimburse licensed birthing centers and to seek necessary waivers.
As Senator Bryan just said, the short title pretty much says it all in this bill.
Need the usual motion, Senator. Senator makes the
I'm sorry,
usual
make the
motion.
usual
All
motion.
all in favor signify by saying aye. Opposed,
Aye.
no. The ayes have it. Now we're ready.
All right, thank you. The short title, as in the last bill, kind of sums everything up. Medicaid pays for about the half of the cost of births in the U.S. That's extremely high. The use of birthing centers, although we don't currently have any here in Mississippi, can help save approximately $1,000 a birth. And so basically what we're doing is asking the division to apply for the necessary waivers and to reimburse for these services once a facility is established. That's an explanation of the bill. I'll yield for questions.
Questions on the bill? Seeing none, we're ready for your motion, Senator.
Move for passage by the use of the morning roll call.
Senators request the utilization of the morning roll call. Anyone object to the procedure? Wish to be recorded as voting no? Present? Hill?
Present.
Present. Anyone else? Anyone else? Seeing none, bill passes. Thank you, Senator. Senator Kaufman. Pass. 89 retains its place on the calendar. Number 90, Senator Carter. Senator Carter is recognized on number 90.
Thank you, Mr. President. I ask that you, I call up item 90 on today's calendar, have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2282, carbon dioxide geologic sequestration, revised laws regarding.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Carter.
I move we adopt the committee sub in lieu of the original bill.
You're recognized to explain the committee substitute.
Okay, this is the CO2, I can't ever pronounce this word, sequestration bill. Basically, we're capturing CO2. We passed a bill last year, and what this does is it sets additional guidelines for the Oil and Gas Board to set rules for this program. This is something that we're probably going to be working on for the next couple of years. But there's only 3 major pipelines in the U.S. One of them happens to be in Mississippi. Mississippi's set up to capture the CO2. And like I said, all this does is helps the Oil and Gas Board continue to set rules. I'll be happy to answer any questions.
Questions on the bill? Questions on it. Senator McDaniel, for what purpose?
Question, Mr.
You
President.
yield, Senator Carter.
I do.
Senator McDaniel, you're recognized.
Thank you, Mr. President. Mr. Chairman, just a couple of questions. The first of which, I'm trying to determine whether your love for recycling is equal to your love for CO2, or is this?
I don't drink much soft drinks, so I don't think I'm a big CO2 fan. But.
All right, not a serious question. Is there, does this enlarge or somehow expand any eminent domain powers the state has?
It doesn't expand it, but it addresses it when you, in respect to mineral rights. And so there's language in here that says basically there'll be a process for a good faith effort that whenever they're trying to establish these pipelines to make sure that there's a process to deal with these mineral right owners in good faith and make sure they're taken care of.
I understand. I think that's probably my primary concern. Is it if the mineral right owners refuse access and then they're made an offer in the private market and they say no to the offer in the private market, then the state would have the power under this bill to then claim those mineral rights?
Right.
Okay. Okay. Good deal. Thank you, sir.
Thank you very much, Senator McDaniel. Senator Hill, for what purpose you seek recognition?
Question.
Were you for a question, Senator?
I do.
Please proceed, Senator Hill.
Can you explain this to me? Because I did not really understand your answer to Senator McDaniel. If you're looking at the short title on lines 18, actually 17 and 18, it says to revise the eminent domain law for pipelines. Please quit moving it. For pipelines and appliances to grant the right of eminent domain to entities for the purpose of transporting or conveying carbon dioxide and other gaseous substances in connection with the geologic sequestration of carbon dioxide and other gaseous substances and any associated carbon capture and geologic sequestration projects. So I go back to line 17. To grant the right of eminent domain to entities for the purpose of transporting. So it apparently is granting a new right of eminent domain, or the short title's wrong, one or the other. Maybe.
It's granting the right, I'm trying to find the language right here. It's where so we had an issue, that's why we have a committee sub between two different companies in respect to this issue right here. Right here, yeah. Ask me that question one more time.
Okay, I think you answered Senator McDaniel that this is not granting the right of eminent domain, but line 17 says, provide laws for pipelines and appliances to grant the right of eminent domain to entities for the purpose of transporting or conveying carbon dioxide and other gaseous substances in connection with the geologic sequestration of CO2 and other gaseous substances and any associated carbon capture and geologic sequestration facility projects. Now, my concern is we have an eminent domain initiative that we passed. It basically says eminent domain would not be granted for any private individual or private company, that it would have to be something in the public domain. I don't see this as being public. It looks private to me. It looks to me like that would benefit whatever company's contracting to sequester the carbon dioxide. Am I correct?
Correct.
So this would be in conflict with the resolution with the amendment that we passed, maybe?
I can't answer that question. I wasn't here when y'all did that, so I'm not familiar
I
with
mean,
that.
Farm Bureau had all the drive to have that passed several years ago, but it looks like to me this would be expanding eminent domain for a private company that would get the contract for carbon dioxide sequestration to be able to go over or under somebody's property for private gain or private enrichment. It's what it looks to me like. I mean, somebody else might can read it and come up with something different, but that's kind of what I come up with. I just wondered if you could confirm that.
Well, it's for the transport of CO2.
And that's not the government transporting CO2, that's private company, right?
It is.
Thank you.
Senator Sojourner, for what purpose you seek recognition?
A question.
Will you yield, Senator?
I do.
Senator Sojourner, recognized.
Thank you, Senator Carter. I think Senator Hill hit on the last part, finally got to the question that I really had. But just to clarify, because it's a lot of words and a lot of language, the bill does grant the use to use eminent domain to gain access to the pipeline, correct?
Correct.
Okay, and to be clear, when we use eminent domain, we are using the force of the government to take what may be my property. And even if I don't want to give it away, the government can still compel me to do so, correct?
Correct.
Okay. And just to clarify one more time, I think this is what Senator Hill hit on, this pipeline is not owned by the state of Mississippi. It is owned by private companies. So the bill would grant them the ability to take my property if they so choose, if I didn't want them to.
this part does.
Okay, thank you.
CO2 capture is a huge opportunity for the state of Mississippi. It's part of the Biden administration's initiatives, and we'd be missing out on a big opportunity if we not continue to set rules for this, for the state.
Okay. Any other questions? Any other questions? Senator McDaniel, for what purpose?
Question, Mr. President.
You for a question, Senator Carter.
I do.
Please proceed, Senator.
Thank you, Mr. President. Mr. Chairman, any chance, is there a reverse repealer in here? Do you have one?
There's not currently a reverse repealer in the bill.
Would you be adverse to one if we offered it just so we could try to figure out what these powers are granted and to whom they're granted? Would that be okay?
I think that will be just fine.
Okay, thank you. This, Mr. President, I have an amendment at the proper time. Chairman has no objection.
Thank you, Senator. If you provide your amendment to the Secretary of the Senate, and we'll ask for other questions. Other questions? Seeing none, we'll wait for just a moment on the amendment.
I move to adopt the committee sub.
Senator Horn, for what purpose?
Question.
Please, who are you for a question, Senator Carter?
I do.
Senator Horn, please proceed.
Thank you, Mr. President. Thank you, Senator Carter. Senator Carter, isn't it true that private utilities already have a right of eminent domain?
They do.
And what we're doing is putting the carbon dioxide sequestration as another eligible item under eminent domain. Is that correct?
Correct. Look, what we're dealing with here is mineral rights was what it all comes down to. I mean, you know, in the state of Mississippi, mineral rights can be conveyed, can be passed on from generations and generations. It's very hard to find out who the owner of mineral rights. I sell real estate for a living. A lot of time, you doing title work, you can't even find out who owns the minerals, so they don't convey. And this is just the language of the eminent domain that they're concerned about. We're just trying to, in good faith, find out who the mineral right owners are. If we can't, use eminent domain to continue the pipeline to where we can take advantage of the CO2 capture.
And would you agree that this bill will help in terms of job creation and economic development?
100%.
Thank you, Mr. Chairman. Thank you, Mr. President.
Thank you. I think we're on the committee. Senator Hill, for what purpose?
I just have one more question.
One question, Senator Carter.
Thank you. I understand when we're dealing with oil and gas, we're talking about mineral rights, but we're not talking about oil and gas. We're talking about piping CO2 down into the ground. So I really don't even see where mineral rights would come into play with this. This would have to be surface rights or just right to run a pipe through somebody's property or underground, because we're not really dealing with minerals. We're dealing with sequestering carbon dioxide out of the air.
I stand corrected. I meant to say surface rights.
Okay, thank you.
Thank you, Senator Hill. Okay, we're ready for a motion on the committee substitutes. Senator Carter.
I move we adopt the committee sub.
Motion to adopt the committee substitute. All in favor signify by saying aye. Opposed, no. The ayes have it. And now we're ready on the amendment. Senator McDaniel, you're recognized to explain your amendment.
I know Senator Carter's worked hard on this, and we are not trying to frustrate his efforts, just trying to understand the ramifications of it. We already have pipelines. We already have various entities that utilize the power of eminent domain, but for whatever reason, we're expanding that power here. It's not clear yet to whom or exactly why, although it appears to be private actors. And if it is a private actor, that's perhaps impermissible, but it should at the very least be highly questionable. Since there are some unanswered questions, and Senator Hill addressed those as well, and thankfully the senator doesn't have any objections to this, I would just offer a reverse repealer.
Thank you. Senator Carter, you're recognized to speak. On the amendment, Senator Carter.
I'm not opposed to the amendment. I'd support it.
Thank you. You want to make the motion, please?
Move to adopt the amendment.
All in favor signify by saying aye. Opposed, no. The ayes have it. We're on the bill, Senator.
I move passage on the morning roll call.
Senator's requested utilization of the morning roll call. Anyone object to the procedure? Wish to be recorded as voting no. McDaniel, Williams, Tate, McClendon, Johnson, McMahon, Kaufman, Whaley, Branning, Fillingane, England, Hill, Suber, Barrett, McCon, Thompson, Sojourner, Boyd, Parker, Moran, Simmons D, Butler K, Blackwell, DeBar, Harkins, no. Seymour, Frazier, Thomas, Norwood, Barnett, Kirby, Butler A, Sparks, Chisholm, Hickman. Anyone else? Jordan. Anyone else, Mr. Clerk? Am I missing anybody? Seeing none. One moment, please. Delano.
Sir.
Senator Delano, was that a no? Pass. Okay. One moment, please. Senator Simmons?
Parliamentary inquiry, Mr. President. Was this the amendment or was this the bill?
This was the bill.
To the vote.
All right.
I changed my vote from no to aye.
Aye.
Here.
Thank you. To the vote.
I'll change my vote to aye.
Aye. Butler.
Mr. President, I changed my vote to aye.
Thomas.
President, I changed my vote from no to aye.
Norwood.
Mr. President, I changed my vote from no to aye, and I'm gonna stay in my seat.
Anyone else desire to change their vote? Anyone else? Barnett. Barnett, no to aye. Butler, no to aye. Jordan, no to aye. Anyone else? Anyone else? Okay, Mr. Blue. One moment, please.
Hey, is there one of y'all's folks that wants to be?
With 28 noes, the bill fails. Senator Delano passed. Senator Delano passes on 91 and 92. Senator Simmons,
Mr. President, I'd like to hold that bill on the motion reconsider.
motion to reconsider on 90, Senate Bill 2282 to the chairman. 93, Mr. Seymour. Senator Seymour. Senator Seymour passes. 94, Senator Whaley. We're on 94, please.
I'd like to skip item number 94 and go to item 95, call it up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2503, Executive Director of the Mississippi Department of Wildlife, Fisheries, and Parks, set terms of office.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. We're on the bill, Senator. Committee sub first, sir.
I'd like to adopt the committee sub.
You're recognized to explain the committee substitute, Senator Whaley.
We have an amendment that goes with it, and I'd like to adopt the amendment and then explain the committee sub if that's...
Please proceed.
I'd like to recognize Senator Sparks to explain the amendment.
Thank you, Mr. President. Thank you, Mr. Chairman. The amendment should be on the screen, simply adds the words striking appointment and inserting submission of the appointment to the Senate. We felt like there was a little bit of confusion over what the time frame would be, and this will clear that up, particularly when the committee sub is explained. I would yield any questions.
Okay. Seeing no questions, we're going to adopt the committee substitute first, Senator Whaley, and then we'll adopt the amendment. So you're recognized to adopt the committee substitute is by just a motion. All in favor motion. It's a motion to adopt the committee substitute.
Move to adopt the committee sub.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. We're on the amendment. Now, Senator, we're ready for your motion on the amendment.
Move to adopt the amendment.
Motion to adopt the amendment. All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Okay, we're back on the bill, Senator.
Thank you, Mr. President. Ladies and gentlemen, what we have before us today, Senate Bill 2503, which would create an executive director of parks within the Department of Wildlife, Fisheries, and Parks. Over the last few years, we have made a commitment to work on our state parks, to give them a focus point. There's no denying it that our parks are in a dilapidated state, and we feel like this is going to be the right direction to get these parks going in the right direction. And basically, as I said, we will create an executive director within the Department of Wildlife, Fisheries, and Parks, which would go through the advise and consent status just as the other executive director does. And they would be limited to terms to where they would have to come back in for reappointment and re-advise and consent. And that is a basic explanation of the bill. And I'll yield for any questions.
Questions on the bill. Senator Norwood, for what purpose?
Question, Mr. President.
For you for a question, Senator Whaley?
Yes, sir.
Senator Norwood, you're recognized.
Thank you, Mr. President. Thank you, Senator Whaley. Now, so what would happen to the Department of Wildlife Fisheries? Would they have an executive director as well?
Yes, sir. There would be an executive director over the law enforcement and the biology side, and then this executive director that we are creating now, their focal point would be parks.
There was a lateral position, would there be an executive director or a super executive director? Or?
They are both executive directors. One is not the boss of the other.
So it'd be the department within the department?
Yes, sir.
Okay. Thank you, Mr. President.
Thank you, Senator Norwood. Senator Horn, for what purpose?
Question.
For you for a question, Senator?
Of course.
Please proceed, Senator Horn.
Thank you, Mr. President. Thank you, Chairman Whaley. Now, as I understand it, they would be executive director of parks, but they still will fall under the overall authority of the Commissioner of Wildlife, Fisheries, and Parks. Is that correct?
No, sir. They would fall up. Now, are you meaning the executive director of Wildlife, Fisheries, and Parks, or are you talking about the 5-board commission?
No, I'm speaking of the executive director of Wildlife, Fisheries, and Parks.
No, sir. No, sir.
So they would be separated into a separate agency. Is that right?
No.
Senator Horn, I'm going to have to apologize to you and the body. The two bills that we're going to be bringing up today are very similar in nature, and I looks like I've got the thumb for the first time more than likely, but
Senator Simmons would be glad to avail you of the finger.
and I will accept it. But I'm gonna ask if I can kind of start over, if I may.
We're on the committee substitute, Senator.
Ladies and gentlemen, Senate Bill 2503 would set the terms of office for the Executive Director of the Mississippi Wildlife, Fisheries, and Parks Executive Director. And this is basically to where they would come up for reappointment by the Wildlife Commission and advising consent of the Senate with every 4-year term. And that is a basic explanation of the bill. And I will yield for any questions.
Okay, now we got it. Thank you.
Is there a second thumb we can share with you?
Thank you, Senator Horn. Senator Norwood, you're recognized for what purpose, sir?
Question, Mr.
You
President.
yield, Senator?
Yes, sir.
Senator Norwood.
Okay, help me now. So you still will have 2 heads?
Well, under this bill, yes, sir, you would. You would still have 2.
And they both will come for advising consent?
Yes, sir.
Okay. Thank you, Mr. President.
Thank you,
Thanks,
Senator
Mr.
Norwood. Senator Polk. Senator Polk passes. Senator Butler, A. What question?
Question, Mr.
You
President.
for a question, Senator?
Yes, sir.
Please proceed, Senator Butler.
Yes, Mr. Chairman. Would you explain to me now about the director? Are you saying that the only thing will happen is that the period of time will change?
Yes, sir. So currently, when the executive director is appointed and they go through an advising consent, as long as they are reappointed, they don't go through an advising consent. And we're just going to bring that to where they would come before an advising consent with every 4-year term is what we're going to do.
That means every 4 years, they have to be advising consent.
Yes, sir.
Thanks,
Thank
sir.
you. Thank you, Senator.
President, what is it now?
Now, if they go through it one time, as long as they're reappointed, they don't go through the advising consent. We're just making it to where they come before us.
Thanks, sir.
Yes, sir.
Thank you, Senator Butler. Senator Kirby, you're recognized for what purpose, sir?
A question, Mr.
You for a
President.
question, Senator Wayne?
Yeah,
Yes, sir.
you
Senator
keep saying the executive director. Are you talking about the commissioner, not the commission, but the commissioner? You're
Yes,
calling the
sir.
executive director?
Yes, sir.
And then they'll just come up every 4 years for reappointment?
Yes, sir, that's correct.
Thank you.
Thank you, Senator Kirby. Senator Blunt. Senator Blunt, for what purpose?
Question.
You for a question, Senator Whaley?
Yes, sir.
Okay, Senator Blunt, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. I support the bill as it's explained to us, but I want to make sure that I'm reading this correctly. I think what I hear you say is when there's a new governor, let's say in this case, Governor Reeves takes office in January, he chooses who he wants to be the executive director of the Department of Wildlife, Fisheries, and Parks. 30 days before sine die, January 2020, he chooses a name from 3 submitted to him by the commission. That person comes before us to be confirmed, and that person serves for the remainder of his first term as governor. Have I explained that correctly?
Yes, sir.
So now I'm reading and I support all that, but I just want to make sure we get this right as you continue to work on this. So if a person, let's see if I'm reading this here. When a vacancy occurs, then it has to be submitted to us. What I'm trying to protect against is, let's say for whatever reason this becomes law and a governor appoints somebody in the 3rd or in the 4th year of his term, and he or she maybe one day is not reelected. Has that person been confirmed in the final year of the term and somebody else gets elected governor in November? He comes in January, but somebody's been confirmed and he doesn't get to name the new person. Am I reading this correctly that could happen?
Yes, sir, you are. That would be the choice of the incoming governor.
Well, and I agree with that. I want to make sure that that's what we're doing with the language in the bill.
Yes, sir. When there is a vacancy and at that point, that person is appointed, they would field the rest of the term, and there is a possibility that they could not be reappointed or reconfirmed by this body. So that is correct.
Okay, so when a new governor comes in
They
and
would
starts
have the
a new
opportunity.
term, that person has the right to retain or replace?
Yes, sir.
Okay, all right, that's what I want to make sure about. Thank you, Mr. Chairman.
Thank you. Thank you, Senator Blunt. Seeing no further questions, Senator, we're ready for your motion. Move for passage by the morning roll call. We've adopted committee substitute, Mr. Clerk. Okay. Passage by use of the morning roll call has been requested. Anyone object to the procedure? Wish to be recorded as voting no. President. McMahon. Barrett. Anyone else? Anyone else? That's it. Senator Hill, for what purpose?
Unanimous consent, I'd like to be added as co-author.
Tate.
Unanimous consent to be added as co-author.
Anyone else? McDaniel?
It's not a go on.
Branning?
Nope.
Chisholm, co-author. Branning and Chisholm, co-authors. Anyone else? Anyone else? Seeing no objection, Senator Branning. Senator McDaniel, do you want to be voted present on the last bill? The last bill?
No, sir, my request is slightly different. After you're done with this, I'll have a request on a motion for reconsideration.
Got it. Okay. All right. So, anyone else? All right. That's it. The bill has passed. Now, Senator McDaniel is recognized.
Thank you, Mr. President. I'd like to enter a motion to reconsider from yesterday's calendar, Senate Bill 2794.
2794, Mr. Clerk.
Yes, sir. Thank you.
To the chairman. Chairman Fillingham.
Introduction out of order at the proper time.
Please proceed, Senator. We're moving on.
Thank you, Mr. President. The South Gallery, if the rest of the Senate will help me welcome our City of Collins Fire Chief, Mr. John Pope, in the South Gallery. Thanks for being with us.
Hey, John. Welcome. Okay. Mr. Chairman, we're on 96. Senator Whaley. Thank you, Mr. President. This time I would like to call up Senate Bill 2504, called up and have the title read. Mr. Clerk, please read the title.
Senate Bill number 2504, Department of Wildlife, Fisheries and Parks, set term of Executive Director and create Division of Parks and Recreation.
Make the usual motion. Senator makes the usual motion. All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Please proceed, Senator Whaley. And I would like to please accept the committee substitute. You're recognized to explain the committee substitute or whom you shall choose. And we also have an amendment on this bill as well that I'd like to recognize Senator Sparks. We'll do the committee substitute first, Senator Whaley, and then we'll do the amendment to the committee substitute as soon as that's over. Okay. If you explain the committee substitute, Senator Whaley, you're recognized. Thank you, Mr. President. Ladies and gentlemen, this is the state park bill this time. I am for sure of it. And basically, as I gave the explanation earlier, it would create a separate executive director of parks within the Department of Wildlife, Fisheries and Parks. They would be subject to the same terms of the advise and consent that we set forth in the prior bill with the other executive director. So you would have that same opportunity every 4 years to look at your parks and make sure that they are going in the right direction, to make sure that you are happy with the direction that we are going. And that is a basic definition, and I'll yield for any questions. Thank you, Senator. Senator Horn, you're recognized for what purpose?
Question.
You for a question, Senator. Yes, sir. Senator Horn's recognized.
Thank you, Mr. President. Thank you, Chairman Whaley. So back to my original question, this executive director will still serve under the Commissioner of Wildlife, Fisheries and Parks. They will report to the Commissioner or Executive Director of Wildlife, Fisheries and Parks. Am I correct?
No, sir, you are not. They would be dual acting heads. The one executive director or commissioner, as you're liking to call him, would be over biology and law enforcement. The other executive director or commissioner would be over parks. That would be their main focal point.
So why wouldn't we split? So who runs Wildlife, Fisheries and Parks? Two people?
Well, no. You have the commission who oversees the parks, the executive director which oversees the management. The executive director...
The management of what?
One executive director would handle law enforcement and biology. The other executive director would be the Director of Parks Division.
So there would not be one guy who is or gal, who is in charge of wildlife, fisheries, and parks.
You're correct. There would be two.
The commission is in charge of wildlife, fisheries, and parks, but the execution of the duties and responsibilities of wildlife, fisheries, and parks was split between two people.
That's correct. Yes, sir.
Okay. So why wouldn't you just separate parks and recreation completely out?
Why would we not? The focal point of this is to try to bring a focus and attention to our parks, and what better way to do that than to set them to a side and create a division where that is the main focus of their office.
Okay. And so two people would report to the commission.
Two people would report to the commission, but they would be under their respective fields, not the others.
Is there any contemplation, we know the parks are struggling with resources and revenue. Is there any contemplation with this change that fees would go up for use of the parks? Because a lot of folks struggle with, paying fees and whatnot. And I wouldn't want to see us price the parks out of use by some of our citizens.
Absolutely not. That is not being touched at all in this bill. And as I said, we're looking at bringing visitors into these parks, bringing the parks up. So we definitely wouldn't want to price ourselves out of competition. So no, sir, that has not even been thought of. No,
Thank you, Mr. Chairman. Thank you, Mr. President.
Thank you.
Thank you. Thank you. Seeing no further questions, we're ready on your motion on the amendment, on the substitute, committee substitute. Senator Whaley.
Move for passage by the morning roll call.
We just
I'm sorry. We've got the amendment.
I know, we got to pass yours first, so yours would be a motion to adopt this committee.
Move for adopting of the committee substitute.
All in favor signify by saying aye. Opposed, no. The ayes have it. Now we're on the amendment. Senator Sparks, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. There should be an amendment on the board for 2504. This is the same clarifying language that addresses the appointment, and it refers to the submission of the appointment to the Senate for advice and consent. I would yield any questions.
Seeing no questions, we're ready on your motion, Senator.
Move that we adopt the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We're back on the bill. Senator Whaley.
I ask for passage by the use of the morning roll call.
Morning roll call has been requested. Anyone object to the procedure? Wish to be recorded as voting no. Present. McMahon. Is that present, sir? Present. Hobson. Present. Barrett. Present. Anyone else? Anyone else? Seeing none, the bill passes. Thank you. On 97, Mr. Clerk, I'm sorry, Senator Hill.
Unanimous consent, I'd like to be added as co-author to that bill as well.
Unanimous consent for co-author that bill. Tate, Hill, Branning, Chisholm. Anyone else? Anyone else? Seeing none, permission granted. Seeing no objection. Back on 97, Senator Whaley.
Thank you, Mr. President. I'd like to go to item number 97, called up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2506, bow hunting, establish a 3-day season and last weekend of September for legal bucks.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
I'd like to adopt the committee substitute, please.
You're recognized to explain the committee substitute. You're recognized to explain the committee substitute, Senator.
Thank you, Mr. President. Ladies and gentlemen, the state of Mississippi is considered to be last in many areas, but one where we are not last is wildlife. The outdoors is a main focal point of the state of Mississippi, and we're here today and we're presenting to you an opportunity to make it even better, to give our archery hunters in the state of Mississippi the chance to harvest a whitetail buck in velvet. And basically this would be a 3-day season sometime between the 10th and the 20th of September. The animal would have to be a legal buck as deemed by the commission, and there will be mandatory reporting of that animal. And that is a explanation of the bill, and I'll yield for any questions.
Questions on the bill? Senator Younger. For what purpose? Senator Younger passes. Anyone else? Anyone else? Senator England, for what purpose?
An amendment at the proper time.
Thank you. Please present your amendment to the Secretary. Anyone else? Okay, we're ready on your motion, Senator.
Move to adopt the committee sub.
All in favor signify by saying aye. Opposed, no. The ayes have it. Senator England, you're recognized on your amendment. It's on the screen, sir.
Thank you, Mr. President. This is a very simple amendment. What this does, if you'll look at line 33 of this bill, this would strike the words through February 15th and add in lieu thereof through the third Sunday of February.
Questions on the amendment? Questions on the amendment? Seeing none, we're ready on your motion.
Move to adopt the, whoa, yeah.
You want to speak on the amendment? Please, Senator, you're recognized to speak on the amendment.
Thank you, Mr. President. While I would be very happy to work with Senator England to try to come about this, I have a problem with understanding how you could find a velvet whitetail buck at the point of period of time in which Senator England is looking for. So I don't know that that would even be able to happen. So I would be opposed to the amendment.
Okay, you're opposed to the amendment, Senator Whaley. Anyone else? You get to speak one last time, Senator England, so if you so desire. Yes, you can. Please, sir, you're recognized to speak on the amendment.
Thank you, Mr. President. Yeah, this is not, I mean, this is in the code section, so this is open for discussion. I'm not sure that anyone in that part of Mississippi will be able to find a velvet buck even in the time that we've got allowed there. This is just a later part of the season. It's the southern part of the state. Right now, this allows from February 1st through 15th, so it's a 15-day extension. This may add up to 6 days for the season. It's not a big extension, but it is something that, and also if you look in this part of the code, it does allow for a delayed season to take place, which again recognizes the fact that in this part of the state, there are, the buck habits are much different. All deer habits are much different in the southern part of the state where the climate is just different. And this just extends potentially the season for this area. And I would ask you to please support the amendment.
Thank you, Senator England. You need to move, sir. Make your motion, please, sir.
My motion is to adopt the amendment.
All those in favor signify by saying aye. Opposed, no. No. Amendment fails. 98, Senator Whaley.
Move for passage by the morning roll call.
Passed by morning roll call, Senator Whaley. Anyone object to the procedure? Should be recorded as voting no. Present. Seeing none, bill passes. Thank you. 98, Senator Whaley. Senator Harkins, for what purpose you seek recognition?
Unanimous consent to be added as a co-author to that bill.
Anyone else? England, Williams, Younger, Tate, McCon, McClendon, R. Jackson, Fillingane, Moran, Ranning, Sparks. Anyone else? DeBar. Simmons. Barnett. Chisholm. Anyone else? Anyone else? Seeing none, seeing no objection, permission is granted. We're on 98, Senator Whaley. Senator Whaley, do you pass on 98, sir? Pass on 98 and 99. Chairman Bryan, we're on number 100.
Senator Whaley?
Senator Whaley, Senator Blunt.
Is this yours? Problem It's a problem. I ask that the title be read.
100, Mr. Clerk, please read the title.
Senate Bill number 2820, COVID-19 Hospital Expanded Capacity Program, require Department of Health to establish and administer.
I make the usual
Senator
motion.
makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Bryan.
This bill is the statutory enabling legislation which will allow certain funds to flow to hospitals for expansions and equipment, et cetera, related to COVID-19. The question of whether they get any money or not is an appropriations matter. This is just the enabling legislation. The bill passed the Appropriations Committee. And if there are no questions, I suggest use of the morning roll call.
I think we have to adopt the committee substitute, Senator, first.
I do?
Yes, sir.
That's a good idea. I move we adopt the committee substitute.
I'm learning. Senator Hill, for what purpose you seek
In the words of Senator Whaley, I'd like to start over. Yes.
Thank you, Mr. Chairman. About this expanded capacity expansion for COVID-19, I haven't read this whole bill. Have we waived the CON requirements for this in this bill?
Yes.
Okay, thank you.
Thank you, Senator. Any other questions? Okay, we're ready now, Senator Bryan.
I suggest use of the morning roll call.
We still have to adopt this committee
I
substitute.
move we adopt the committee sub.
There you go. You've only been here 40 years. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator Bryan, you're recognized.
I suggest use of the morning roll call.
Senators requested use of the morning roll call. Anyone object to the procedure? Wish to be recorded voting no? Present? Seeing none. Thank you, Senator Bryan. We're on 101, sir.
I ask that the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2421, Physician Grant Funding from Qualified Health Center Grant Program, extend date of funding.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator, you're recognized.
Mr. President, I'm proud to announce there is no committee substitute on this one, so maybe I'll do better. There is, under existing law, a provision for the State Department of Health to make grants to qualified health centers for the employment of physicians. Again, it's an appropriations issue, whether there's money there. This is the enabling legislation for an existing program. If there are no questions, I suggest use of the morning roll call.
Questions? Seeing none, use of the morning roll call has been requested. All in favor, does anyone object to the procedure? Wish to be, of course, voting no? Present? Seeing none, the bill passes. Thank you, Senator Bryan. We're on 102.
Mr. President, I would like to pass the next two items and let them retain their place.
Retain their place upon the calendar. Thank you, Senator Bryan. Senator Tate. Senator Tate passes. Chairman Younger. Chairman Younger. Okay, we're on 105, Senator.
Thank you, Mr. President. I'd like the 105 to be, and the title be read, please.
Mr. Clerk, please read the title.
Senate Bill number 2077, Mississippi Farms and Families Program, create.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
I'd like to yield to Senator Whaley to explain the bill. Thank you.
Senator Whaley, you're recognized to explain the bill.
Thank you, Mr. President. What we have before us, Senate Bill 2077, which would create the Mississippi Farms and Families Program. And basically what this does, this is a bill that would take one-to-one match money for people receiving SNAP benefits who purchase fresh fruits and vegetables from a farmer's market or from a participating grocery store. And the program would be up to $20. So if they were to purchase $5 worth of fresh fruits or vegetables, they would get a one-to-one match, so that $5 would become $10, and it only goes up to $20 per purchase, and that is a basic explanation of the bill, and I would yield for any questions.
Any questions on the bill? Senator Hill, for what purpose you seek recognition?
Question.
Please proceed.
Yes, ma'am.
How often can they purchase the $20? Is there a cap on it?
No, ma'am, there is no cap.
Thank you.
Yes, ma'am.
Senator Sojourner, for what purpose?
Questions,
We
Mr.
yield, Senator, for a question.
Yes, yes, sir.
Please proceed, Senator
ma'am.
Sojourner.
Thank you, Chairman Whaley. I apologize for not getting with you sooner. We just spoke quickly, but it came right up. I do have a couple of questions, because I got this handout that talks about farms and families, and anytime I see, and as you know, you and I both make our living as farmers, and anytime I see something come up, it gets my attention, especially when I realize that we're talking about farmers, but what we're really talking about is an expansion of the food stamp program. So a couple of questions. The total dollar amount on the cost of this program?
There is no money in this program at all. That would come at a later funding date. So as right now, there's no money at all in this.
Okay, so it says...
This is just a program.
Okay, but on the flyer, it says supporting policy to fund $700,000 annually in a SNAP incentive program.
Yes, ma'am. I know what the flyer says, but the bill itself, I promise you, has absolutely zero money in it at all.
Okay, and so the bill...
I know 700 is what they were asking for.
Okay, and so the bill did pass through agriculture and appropriations, correct?
Yes, ma'am.
So what you're saying is in appropriations, y'all did not add money to the bill?
Well,
Is
I
that-
don't serve on appropriations, and when this came through appropriations and I explained it, that there was never a mention of it at all.
Okay, and I think
That would
Senator
come at a later
Hobson
date.
is agreeing with that. So would we not implement the program unless there was appropriations, or where's the money coming from?
It would come through appropriations, but that would be decided at a later date.
Okay, got you, thank you.
Like I said, this is just the implementation of the program.
Okay, thank you for clarifying that. Couple of quick questions on the implementation. I know that I've got the handout here, but explain to me, it says that they would get the coupon on the conclusion of their purchase.
Yes, ma'am.
Is that correct?
So what would happen if you were at a farmer's market and you walked up and you were receiving SNAP benefits and you walked up to the checkout line, whatever you had purchased that was eligible, fresh fruits and vegetables are the only thing that is eligible through this program. However, the amount of the dollar, whatever the dollar amount you have purchased, it would double up to $20. And you would receive a token, and then you could go back and
Gotcha.
purchase more.
So the program isn't actually encouraging people who aren't already buying fruits and vegetables to make healthy choices. It's just providing more dollars for people who are already buying fruits and vegetables to purchase additional at a later purchase? Is that?
You could argue that, or you could argue that this is an opportunity to promote awareness to the people who are receiving SNAP benefits, who are not purchasing healthier foods, to go back to these farmers markets or to these grocery stores, and instead of buying a lesser product, a lesser costed product that is nowhere near as healthy, you and I know as well that fresh fruits and vegetables are much more expensive per scale than non-healthy foods. This would be a tool to where you could get people to go in and buy the healthier foods, and then there would be a ripple effect through the economic development, the growth coming from the additional sales of the farmers. And you know that when the farmer has more sales, he's reinvesting that in that farm. So there's a lot of different ways to look at this.
Sure, I get that. And I do know buying fruits and vegetables can be expensive, but a bag of potato chips is far more expensive these days. Would you not agree?
Bag of potato chips is what now?
Is more expensive than buying fresh fruits and vegetables at a farmer's market?
I would disagree with you.
All right, well, I'll share some cost with you. My final question. In the pamphlet that we got, it lists markets that would currently be available for the program. When I look in my area, there's one that's available. However, there are a lot of places that only sell fresh fruits and vegetables that aren't on the list. The one that's on the list happens to be a part of a larger group of supermarkets in the state. So my question is the bill aimed at helping those markets, or how do other markets take advantage of the program?
I would tell you that any SNAP incentive vendor, a retail location that currently accepts SNAP or EBT cards can become a SNAP incentive vendor location. They would have to offer the fresh fruits and vegetables to their customers, and there's just one more form that they would have to fill out with the Department of Agriculture, and they would be set up to this. So basically, if they're not doing this, they either don't want to or they don't know about it. And I'd really like to let them know about it, so.
Okay, so this is just for clarification, this is just establishing the program, but there's no appropriations available at the time. But the program, if implemented, does expand the availability of SNAP benefits. Is that correct?
Well, it would offer a more investment in them, but I don't know that you would really consider it an expansion of.
Okay, thank you.
Yes, ma'am.
Thank you, Senator Whaley.
Thank you. Senator McClendon, for what purpose you seek recognition?
Question, please.
Are you yield for a question, Senator Whaley?
Yes, sir.
Please proceed, Senator McClendon.
Thank you, Mr. President. Thank you, Chairman Whaley. Chairman Whaley, you're aware of the Hernando Farmers Market.
I am.
And you're aware also that most of those vendors are mom and pop vendors that sell fruits and vegetables there.
And also are Mississippi mom and pop vendors.
That is absolute truth. 95% of the ones at Hernando are Mississippi vendors, not Tennessee, not Arkansas, but Mississippi vendors. Not from DeSoto County only. Tate, Tunica, Marshall, Yallabusha, and onward. Benton. This not only is helping those that are down in their luck, this is also helping the economy of our mom and pop vendors. Is
Very
that
much
not
an
true?
economic driver, yes, sir.
I also would like to question something that I heard our agriculture commissioner say, that the Mississippi Farmers Market was the largest farmers market in the state of Mississippi, but I see on here it says coming soon. So I believe Hernando would probably be the largest at this time.
Well, Senator, I hadn't pulled a measuring tape out and checked them, but Hernando's very good size, so I will agree with you to a point. Yes, sir.
And let me ask this question again. Now, they can't buy pita chips, they can't buy sweet tea, they can't buy birdhouses, they can't buy cookies, they can't buy
fresh fruits and vegetables.
Thank you so much, sir.
Yes, sir.
Thank you, Senator McClendon. Senator Williams, you're recognized for what purpose, sir?
Question, Mr. President.
You for a question, Senator Whaley?
Yes, sir.
Mr. Chairman, thank you, Mr. President. Thank you, Mr. Chairman. I'm just confused on the money, if you could help me a little bit.
Yes, sir.
If, with this program, if it were enacted and funded and the dollars were there, I can go in and buy $20 worth of cupcakes and potato chips, or I can buy $20 worth of fruits and vegetables.
Yes,
and if I choose to buy the $20 worth of fruits and vegetables instead of the cupcakes, I can get $20 more worth of fruits and vegetables.
That's
so I can
exactly
get $40 worth of fruits and vegetables, or $20 worth of junk food, if you will.
That's exactly right.
So I've got to make that choice to take $20 and not, or maybe I've been buying junk food. I've got to buy fresh food, but my incentive is I'll get double that back. Is that how that works?
That is 100% correct. Yes, sir.
So it's either or, not both and.
I'm sorry?
It's either or. It's either healthy or not healthy, not with the amount of money that I have there to spend.
In regards to the match, 100% correct. Yes, sir.
Okay. I was just, thank you, sir. Thank you, Mr. Chairman. Thank you, Mr. President.
Thank you, Senator Williams. Senator Barnett, for what purpose you seek recognition?
Question, Mr. President.
You, Senator Whaley?
Yes, sir.
Senator Barnett, you're recognized for a question.
Thank you, Mr. President. Thank you, Chairman Whaley. Chairman Whaley, is it the intent of what you're doing, trying to help those individuals who may only receive $10 or $15 worth of SNAP benefits to help maximize that, where they may be able to have more food in their homes?
Senator, I would tell you that is definitely one of the reasons for this. I don't think you could nail it down to there being just one reason. You know, we've talked about the many different reasons: economic development, the ripple effect of what it'll do to your community involvement, eating healthier, matching funds, helping those less fortunate. I think you could use all of those as explanations. Yes, sir.
Thank you, Senator.
Thank you, Senator. Senator Chasnow, for what purpose, ma'am?
For a question,
You
please.
for a question, Senator?
Yes, sir.
Senator Chasnow, you're recognized.
Thank you. Senator Whaley, are you familiar with the term food desert?
Food desert?
Yes, sir.
I'm not.
We had a bill several years ago to try to help people who live in certain parts of the state where it's hard to get fresh produce and wholesome things that children should be eating, as opposed to the refined carbohydrates in sugary snacks and soft drinks and things like that. And since I represent part of the Delta, I'm very interested in a bill that might encourage a region of the state to eat more healthy foods, to make healthy foods more available. Do you think that some of these small retail places where people buy food and beverage might be more inclined to carry apples, oranges, bananas, fruits, grapes, things that are available for children as after-school snacks, if they thought they were going to be able to have a better retail benefit from that?
I believe that would be a very sound business decision on their part. Yes, ma'am.
So this will encourage businesses to help people eat better, but it'll also take the parts of the state where there are food deserts and actually encourage the sale of wholesome foods for children, which, by the way, I'm aware of the problem we have in the Mississippi Delta of diabetes and obesity being very serious problems because often proper food choices are not available. So you think this bill might help with improving the nutritional needs of that area of the state?
I believe it has all of the necessary tools available that would be able to make that work. Yes.
So you think it's beneficial for children in our state?
100%. Yes, ma'am.
Thank you.
Senator Moran, for what purpose?
Question, please.
Are you here for a question, Senator?
Of course.
Senator Moran, you're recognized.
Okay, serious question. I'm for the bill. I'm gonna vote for the bill. I'm trying to wrap my mind around this. So if they go to that local fruit stand and they purchase $10, so it would be a deal where they would have to use that card in order to get another $10 credit. Is that correct?
If they receive EBT or SNAP benefits, when they go up and they purchase, you're using the amount of $10. If they were to purchase $10 worth of qualifying products, there would be an additional match, a one-to-one match. $10 would become $20.
That the state in turn, I guess what I'm getting at, I don't want the poor farmer, the roadside vegetable stand to be on the hook for the second $10. So it automatically goes onto the card from the state.
If they receive the EBT or SNAP benefits, they would be recompensated.
Good deal. All right, thank you.
Thank you, Senator Younger. You're recognized for what purpose?
Friendly question, please,
Do you
Mr.
yield,
President.
Senator Whaley?
I'm
okay,
scared,
Senator
but
Younger,
yes.
you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. What's the #1 killer among women, Senator Whaley?
I believe it's heart disease.
It's heart disease. Who's asking us, who's asking us to do this bill?
This is American Heart Association sponsored.
Correct. And if we invest in the public eating right, won't this help Medicaid and all our other health expense later on down the road?
I think that if everyone ate healthier, there would probably be a lot less illnesses. Yes, sir. I think you could probably say that.
Thank you.
Thank you, Senator Younger. Anyone else? Anyone else? We're ready, Senator Whaley.
Move for passage by the morning roll call.
Use of morning roll call has been requested. Anyone object to the procedure? Speaker voting no. Present. Seeing none, the bill passes. Thank you, Senator Butler. For what purpose? Senator Butler.
Mr. President, I would like to be added as co-author, Mr. President.
Co-authors, here we go. Senator Hill.
Still to the vote.
Whoop. I'm sorry, are we still on the vote?
No.
2 noes. I did not get the noes. I apologize. That's McDaniel and Sojourner. Senator Hill is a no. Anyone else a no? Tate? Tate is a no. I'm sorry. Chisholm is a no. Anyone else? Anyone else? Okay. Parker? All right, here we go on co-authors then. We got no's. Any presents? Okay, we're strictly on co-authors. Simmons and Simmons, Thomas, McClendon, please, ma'am. Norwood, Horn, Chazanall, Boyd, Hickman, Blunt, Moran, Boyd, I got Parker, Seymour, anyone, Barnett, anyone at Jackson, anyone else? Anyone else? Seeing none, bill passes. We go to 106, Chairman DeBar. 106 and 107 retain their place on the calendar. Chairman Polk. We're on 108.
Mr. President, I'd like to pass 108 and ask it retain its place on the calendar.
Retain its place on the calendar. 108. 109, Senator.
Call up number 109, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2793, Legal Service Contract, Clarify Exemption from Public Procurement Review Board. Mr. President, make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed.
I plead to recognize Senator Blackwell to explain.
Senator Blackwell, you recognize.
Thank you, Mr. President, Mr. Chairman. This is another bill, part of the peer bill package. It addresses issues that arise when agencies seek approval of non-legal services by including them in a contract for legal services. So lines 172 through 174 defines those legal services. And then lines 447 through 451 clarifies the Attorney General must disapprove any legal service contracts that include services that do not fit in the definition of legal services. That's an explanation of the bill. I'll be happy to yield for questions.
Thank you. Any questions on the bill? Questions? Seeing none.
Move for passage by the use of the morning roll
One
call.
moment, I see one now. Senator Horn. For what purpose, Senator?
Question.
Will you yield, Senator, for a question?
I'll yield.
Please
Thank you,
proceed,
Mr.
Senator.
President. Thank you, Mr. President. Thank you, Senator. I want to make sure I understand what we're doing here. We are establishing a means whereby hidden legal contracts within other contracts will be clarified.
Yes, sir. You know, PEER goes through and we audit various agencies, and through the course of that audit, we've noticed that tends to be sometimes a lumping in of just easier, we'll just stick it in this contract, we don't have to get approval. So
we're eliminating that.
Yes, sir.
Thank you, Mr. Chairman. Thank you, Mr. President.
Thank you, Senator Horn. Senator Hill, for what purpose?
Just a clarification, because I'm still trying to figure out what this is doing. It's exempting legal services, contracts.
It's not exempting legal, it's things such like they'll take, do a contract for legal services and then stick something like a call center service in that contract, which then doesn't get reviewed, and it's supposed to be reviewed.
So this is more of a transparency measure?
Yes, ma'am.
Okay, thank you.
Other questions? Seeing none, we're ready for your motion, Senator.
Request passage by the use of the morning roll call.
Use of morning roll call has been requested. Anyone object to the procedure? Wish to be, of course, voting no. Present. Seeing none. Senator Polk, you're recognized. We're on 110.
Thank you, Mr. President. Call up number 110, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2806, Public Purchase Bidding, Prohibit Reverse Auctions for any design or construction labor or services. Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Polk.
Thank you, Mr. President. I'd like to consider the committee sub in lieu of the original bill and be allowed to explain.
You're recognized to explain the committee's substitute.
Thank you, Mr. President. This bill clarifies some issues that apparently has arisen since we passed a bill similar last year,
What this bill does is exempt certain construction from reverse auction. And it turns out that the way the bill was worded, that many people think that they still have to do reverse auction on any remodels or renovation. And that was not the intent of the legislation last year. It was the intent to also ensure that major renovation and remodel would be included. So this bill, that's what it does. It includes to make sure the wording is there to ensure that everyone knows that remodel renovation is considered construction. If there are no questions, I'd like to adopt the committee sub.
Senator Harkins, for what purpose you seek recognition?
Question.
For you, for a question, Senator Polk?
I do.
Senator Harkins, you're recognized.
Thank you, Mr. Chairman. Thank you, Mr. President. So what line is the change on in this section? I know you and I have had a
96.
conversation. Line 96? Public facilities included. Okay. And do you think this will solve the problem about the renovation being excluded under the definition of construction? Because I think what's happened is like you mentioned, there is basically an assumption that construction is defined as only new construction, and it's not remodeling, it's not renovations of existing space. And so we're fairly confident this is going to take care of that.
I was surprised it even came up as an issue. But
Okay.
yes, I think this solves the problem.
Okay. Thank you, Mr. Chairman.
Senator Harkins, thank you. Okay, other questions? Questions? Seeing none, we're on the committee substitute. Senator Polk.
Move this, adopt this committee substitute.
Senators move for adoption. All in favor signify by saying aye. Opposed, no. The ayes have it. We're on the bill, Senator.
I'd like to use morning roll call for final passage.
Morning roll call has been requested. Anyone object to procedure? Wish to be recorded as voting no. Present? Seeing none, bill passes. Thank you, Senator. We go to Chairman Simmons, D. You're recognized. We're on 111.
Thank you, Mr. President. Ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2898, certain municipalities allowed to establish overdue water sewer payment programs, extend, repeal, or on authority for.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator.
Mr. President, ask that we adopt the committee sub in lieu of the original bill.
You're recognized to explain the committee substitute.
Thank you, Mr. President. Senators, this bill is supported by Executive Director Sally Doty, and all it does is extend the repealer on this bill until 2023. That's all the bill does. If there are no questions, Mr. President, I ask that we adopt the committee sub.
Questions on the bill? Seeing none, motion made to adopt the committee substitute. All in favor signify by saying aye. Opposed, no.
Mr. President, if there are no questions, I ask that we pass the committee sub by use of the morning roll call.
Use of morning roll call been requested. Anyone object to the procedure? Wish to be, of course, voting no. Present? Seeing none, the bill passes. Chairman Wiggins, 112. Chairman Wiggins.
Thank you, Mr. President. Ask that number 112, we skip over that and that retain its place on the calendar, and we go to item 113, call that up, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2461, Landlord-Tenant Law, revised provisions of to create procedures and protection for evictions.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Wiggins.
Thank you. I call the committee substitute up in lieu of the original bill.
You're recognized to explain the committee suicide.
Thank you.
Committee substitute.
Members of the Senate, in short, back during the summer, Federal Judge Mills ruled unconstitutional our state laws dealing with eviction of tenants. Bottom line is, he ruled that they were violated a number of constitutional provisions, and honestly been on the book for quite some time and probably actually needed to be adjusted. So the bill before you, what that does is addresses those constitutional provisions. And I'm happy to go through that on questions, but suffice it to say that throughout the bill, what has been done is written into statute the issues that Judge Mills was concerned with. And in his opinion, he called on the legislature to make the changes. And so that's what we're doing with this bill. And we, of course, need a landlord-tenant law in the state of Mississippi to govern that, because right now, I guess, should his order go into effect, let me say this, he kept his order in abeyance for the legislature to actually do what we're doing now. And in his opinion, he mentioned that, in short, the previous laws went further than any other state in allowing a landlord upon eviction to take a tenant's property. And what we are doing with this bill is fixing those issues and putting into the bill constitutional provisions to protect tenants and to protect their property. And part of the landlord-tenant law in this bill is to, with proper notice, tell them what they are facing, what court they have to be in, and it spells out what has to be in the summons, spells out how long they have before they can be evicted. It spells out what can happen or not happen with their property. In short, when a person held over as a violation for not paying rent, landlords could go and take their property. Judge Mills ruled that that was an illegal, unconstitutional taking under our constitutional laws, and so we're fixing that. Throughout the bill before you, it describes what summons, as I said, must go out, how many days that they have under the law, under the bill before you. If there's a holdover, then they have to go to court, have to be served with the proper notice. That's called due process. And then they have 7 days to get out. If they're not out, then there's a whole other process that's spelled out before you can be ordered to move out, and then your property cannot be seized, or your property can be seized. You have 72 hours to get out, so you can't do it immediately. And your property, the tenant has reasonable access to get the property during that time. And so what we're trying to do with the bill is to allow those constitutional provisions to be put into the landlord-tenant law. And this is what I call the basic revision of our law. I will tell you, on the calendar is also what we call a comprehensive bill that may be coming before you. So in short, that's what the bill does, and I'm happy to answer any questions.
Questions on the bill? Senator Hill, you're recognized for what purpose?
Thank you. I'll be brief, and I appreciate the work that y'all have put in a lot of time on this. I guess my question would be, one of the biggest complaints that I've gotten since I've been in office is landlords having problems getting tenants evicted, and y'all have got all those calls, and we've had certain courts that were worse than others, and we took a stab at it a few years ago to try to make that better. But I guess my question is this going to start up the calls again? About of landlords, saying that the court's not cooperating and that they're people are tearing up their property because they can't get them out in a proper time. So I'm just curious, is your opinion, because you've dealt with this and I've dealt with this, I'm just saying, are we going to start getting slapped around again by these landlords because they can't get their people out of their...
Let me tell you, on the calendar is what I call the comprehensive bill that is addressing those things to update all of our landlord-tenant laws, and that is the hope in doing that. I do think that this bill before you will also do that, because as Judge Mills said in his opinion, bottom line is, as Judge Mills said in his opinion, it led a lot to the interpretation. It didn't give the specific procedures. And actually, in the case that led to it being ruled unconstitutional, I will just say a landlord went
Too far.
too far.
Yeah.
Which, to be honest, has been a problem because the law did not guide the landlords to that. That's why we get calls, and you're right, we did try to do that. So it is my hope, and based on council and us working on this, that yes, this will eliminate those
Any
calls.
gray area?
The gray, and
Okay.
if
All
you
right.
look throughout it, yes, it's specific because the gray area came in what notice they were being given and what would happen if, because your property is your property and you can't take that without due process. And so what the bill is trying to do is to fix those gray areas so that they know what they're dealing with.
Thank you. Appreciate it.
Thank you, Senator Hill. Other questions? Other questions? Senator Turner, for what purpose?
Question.
Will you yield Senator Wiggins?
I do.
Senator Turner, you're recognized for a question.
Thank you, Mr. President. Thank you, Mr. Chairman. I have a question about service of process
Yes.
on the tenant. What is proper service of process?
Give me 1 second, please.
Sure.
Okay, if you start in section 11, commence the civil action, you have to do a sworn affidavit and complaint, state facts requiring the removal, identify the address, declares the notice has been given to terminate the tenancy, and identifies any items the property is located at the premises. Let me say this, that part of the reason in the case was that the Justice Court did not properly provide the summons. Okay, and that's also what Judge Mills mentioned, and I think has also been kind of Senator Hill's point, is the procedure that it happens in our justice courts differs from justice court to justice court. And so going on, that's the summons, I'm sorry, the complaint, and then if you go over, let's see.
I can ask that.
If you go starting at lines 347, that tells you what the tenants are given and what the remedies that the landlord can take on that. And so they're given that notice.
Is the
Okay. Okay, thank you.
And let me ask my question this way. Would the process server be authorized to leave the notice on the door of the apartment or the leasehold?
What the law does is, and I'll answer it this way, it provides for a number of ways, and if the landlord and the tenant have agreed to communicate via text or email, then it allows for that. And my recollection is that the current law doesn't allow that because the law has been in place since before those things came about. And as you know, many people deal with text and email versus actually writing a letter, which used to be the case. So yes, those are allowed, but they have to be personally served, and you have the Mississippi Rules of Civil Procedure that it requires, which if you look at line 84 and 85, the rules of court, and so under the rules of civil procedure, you have Rule 4 and Rule 5, you have to serve them properly, personal service and so forth. So you have to comply with the rules of court, and this makes that specific.
So I guess what I'm understanding is it would not, the process server would not be authorized just to leave the notice on the door at the apartment. I've heard of instances like this. That's why I'm asking, is it actually clear that that's not an authorized form of service?
So line 106 and 107 says service of summons shall be pursuant to Mississippi Rules of Court. Under the Mississippi Rules of Court, you cannot do that. There's certain things that you have. Personal service is number one. Then you have what's called secondary service, where you leave it with a person who's there and they have to sign an affidavit. And then you have to do publication that's 30 days. So that's just off the top of my head. So they can't do it that way. It has to be through the rules of court.
Thank you very much.
Thank you.
Senator Harkins, for what purpose you seek recognition?
Question.
Will you yield for a question, Senator Wiggins? Senator
No.
Harkins, oh, come on.
Sure, yes.
All right, then Senator Harkins, you're recognized.
Thank you. As a non-lawyer, I heard you say something about service. Did I hear you say that they have thrown out where you can notify between a landlord-tenant notification no longer allows for email or text message? Did I misunderstand?
It allows for it if they agree to it, and you can agree to it through your lease.
Okay, so
So
that
the
still
law-
preserves that. That hadn't been
Yes.
thrown out. Okay.
That's right.
All right. Okay, thank you for your work.
But,
Appreciate it.
and thank you for that. The issue is being summoned when there's a breach. And the problem comes in is if you breach it, you can't be sent a text or an email. You have to be served with the summons according to the rules of court, like I answered Senator Senator Turner Ford.
Okay.
But and that's partially what got into the problem is if it's a breach and you say, hey, you're gone, that doesn't qualify as due process. So it has to be summons pursuant to the rules of court.
Rules of court, not via the lease.
If there's a breach, correct.
For an eviction,
Correct.
Okay. You can still email them notice that they've breached.
Yes, that's correct.
And serve notice. And if they are no longer, if they no longer respond to mail that has been certified mail to the address on the lease, it is assumed as delivered if they haven't provided notice that they've changed address, correct? So if their lease, they have a notice of address to serve notice, and they don't respond or they don't pick up their mail anymore at that address, and they haven't served notice to the landlord that they've changed addresses, that's still considered that you've served them notice.
Well, let me answer it this way, because I may be confused. And I'll put on my lawyer hat.
Not on summons. I'm just talking about notices within the lease, that you breached the lease.
And there's two different things, and let me say that. Summons is different from just notice. Like giving notice, however you agree to it in your lease, that is fine. And actually that could be done outside of the statute. But when the landlord gets ready to evict it, we're talking about eviction.
Okay.
And then they have to do a summons through the rules of court.
Gotcha.
And you cannot just send an email saying, guess what, you got 3 days to be out. You have to go through the process of court. That's due process.
Thank you, Senator.
All right, let's see. Any other questions? Okay, we're ready now, Senator.
Move passage on the morning roll call, Mr. President.
We got to adopt the committee substitute, sir.
Move to adopt the committee substitute.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Now we're ready on the bill, Senator.
Move adoption of on the morning roll call.
Use the morning roll call has been requested. Anyone object to the procedure? Should be recorded as voting no. Present. Seeing none. Okay, Senator, we're on 114 on the calendar. Senator
Go to
Horn.
114, call that up, ask the title be read.
Senator Horn, for what purpose?
Thank you, Mr. President. I request unanimous consent to be added as a co-author of Senate Bill 2626.
I think we were on 2461. You wanted, it's the bill that's coming up now.
The previous bill.
Okay, it was 2461, I believe, Senator. Take a look.
Oh, I'm sorry, Mr. President. You're absolutely right.
Okay, all right. Just want to make sure we're on the right path. All right, now we're back to you, Senator Wiggins. I'm sorry, Senator Hickman. Also, Senator Hickman also. Seeing no objection, granted. Anyone else? Anyone else? Seeing none. All right, Senator Wiggins, we're back with you.
Item 114, call that up, ask the title be read.
Mr. Clerk, please read the title.
Senate Bill number 2626, Comprehensive Landlord and Tenant Act.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator.
Call the committee sub in lieu of the original bill and ask to explain it.
Senator Wiggins is recognized to explain the committee substitute.
Thank you. Yeah, I saw that. So first of all, let me say the committee substitute that's before you has a reverse repealer in it. And what this what this bill does, as I said, our laws have been outdated. Senator Johnson has worked a hard time on trying to do what's called make a comprehensive change to all of our laws relating to landlord-tenant. They actually need to be updated, and so that you understand, as has been explained to me with counsel, there is a residential act and there is a commercial act. And what the bill before you is doing is actually putting all the residential, and there was confusion generally when you're practicing, and that's what led in part to the unconstitutionality. So what this bill is doing the same thing that we have done, that we did on the previous bill, but also addressing some of the commercial side of it. There is work that needs to be done, and the commercial side of it, there are landlords and also tenant who have some, want to address the issues on it. That's why we put a reverse repealer in it, and it would be my motion that we pass this as well. The intent is to not have two bills on this. The intent is that we have one bill that we can get, and we'll be working with the House to have the best bill for landlords and tenants. So that's where we are on the bill. And if no questions, move passage on the morning roll call.
Thank you, Senator. Senator Simmons, D. What purpose, sir?
Question, Mr. President.
Question, Senator Wiggins.
Yes.
Please
I yield.
recognize Senator Simmons for a question.
Thank you, Mr. President. Thank you, Chairman Wiggins, for bringing the bill forward. And I certainly commend you and Chairman Johnson for all his work on this bill. As you know, I have some concerns about this bill, unlike the last bill you brought up. In Section 4, the time period in line 276 through 278,
Yes.
when there's a judgment of possession, it's 24 hours.
You can't evict, so the window is 24 hours and 10 days between those two time periods.
Yeah.
And back to Senator Hill's earlier points, we've dealt with where they were given 3 days. I think that was the previous law, and so under both bills, you're dealing with 10 days.
Yeah, and I guess my concern is 24 hours after judgment may be too soon, and I just want to make sure we can look at that as the bill goes through the process, where a tenant may be actually in the premises with their children and all of their belongings.
No, thank you for pointing that out, that it's 7 days, but only in an emergency, and this is line 274, for an emergency or compelling circumstance did that time limit apply. So you, no less than 7 days, obviously,
Okay.
which the old law used to be 3 days.
I understand. And I just, if we could just continue to work on that, that's just one area that
Yes.
I saw. And I just mentioned one other area, even though, as you know, I have a lot of areas in, a lot of sections in this bill that I'm a little concerned about, unlike the last bill you just brought forward. But in Section 13, which deals with the jurisdictional limits,
Yes,
based off the language of this bill, as you know, the jurisdictional limits for justice court is $3,500.
correct.
And
Most of your evictions get filed in a justice court.
That's right. And this section speaks to not having a limit on the judgments in Section 13. And I guess my concern,
Yeah, line 627 to 629 says no court can grant it in excess of the jurisdictional limits. If you look at line 627 to 629, it says no court may grant damages in excess of the statutory jurisdictional limits of the court. So they would not be able to do it above the 3,500.
So if you file it in justice court, then you cannot exceed the 3,500.
Correct, based on that language, yes.
Okay. And if you need to file for damages above 3,500, then you will go to the next court.
That's correct, like any other
Okay,
case.
okay.
Yes.
All right. And I think I have, there was a section that deals with attorney fees. And I think that section, I'm looking for it. Section 26?
27.
Is it 26 or 27?
27.
Okay.
And note it, looking at that, there's a couple statutes. One's called an unlawful entry and detainer that are on the books that allow for double damages for holding over. That's what's called unlawful entry and detainer. There's actually procedures under justice court and county court.
Mm-hmm.
And so this language is, as I was mentioning, is trying to update that, because I'll even say the unlawful entry and detainer has been around for over 50 years.
And I'm not talking about situations where the tenant actually destroys or causes costs and or expenses to the property. I think they should have to pay that. But in those situations where a tenant uses the court and has a right to defend himself or herself, and if it's a situation where they've already had an inability to pay, or they've shown that they actually had an inability to pay, we wouldn't want them going to justice court and then being ordered by the justice court judge to have to pay just because they lost in justice court. And so that's how I read section 27, which is the prevailing party attorney fees could be paid. In section 27. And so I'm just asking if we can continue to look at that?
The particular language, which if you look at 845 says that's where the rental agreement does not provide for attorney's fees. And I should say this, that the lease that is entered into is going to dictate, other than, like we mentioned on the other bill, the summons and the due process. So that's what that language is saying, is that where it's not provided in the lease, then this takes hold. And you know that the leases are contract, and they're based in contract, and they're negotiated and all that stuff. So the lease would dictate, and if not the lease, then you would have that.
Well, I thank you for your commitment to continue to work with me as this bill goes through the process. As Chairman Johnson knows, Chairman Wiggins, Professor Hensley, who has been very involved in the litigation in the Judge Mills decision, she's been trying to be involved as well in the process, and would like to see the best landlord-tenant law in Mississippi. So thank you so much for your leadership.
Yes, thank you.
Thank you, Senator Simmons. Senator Turner.
Question, Mr. President.
You for a question, Senator.
I do.
Senator Turner, you're recognized for a question.
Thank you, Mr. President. Thank you, Mr. Chairman. My concern is with section 51, which is the section that would allow the landlord to terminate utility service.
Yes.
What type of notice is the landlord required to provide the tenant before stopping those services?
Understand this, as was held in the case that I mentioned, they have to provide them proper notice, written notice, or if they've agreed to the notice in their lease, then they have to provide that before they do it. So they can't just go and do it, turn off the utilities or whatever. And so that's what has to be done.
Is it, because this particular section refers to the landlord's the landlord's remedies without an eviction. So my question is, what type of notice does the landlord have to provide And I understand it's a reverse repeal, but that is a concern that I have going forward.
So your question is the notice that they have to give before exercising those remedies?
Right, and I'm thinking about an incident that occurred in North Mississippi. It seemed like at the inception of COVID, people were having problems paying their rent, and the utilities were being provided by the landlord, and instead of them going through formal eviction proceedings, utility services were disconnected. And so my question is, in that type of instance, if the landlord is providing utilities, what type of notice does he or she have to provide to the tenant?
Okay. Yeah. That, again, the lease dictates, so first of all, they would have to follow that, okay? And most leases, in fact, all leases should have those provisions within them about what they do. If they don't, then you can go to here, and they have to have the summons and things like that. I would say this, I don't know why a landlord wouldn't go to court and make that the case, because they open themselves up generally if they just turn off the power. That being said, if you look at the section you're talking about, if you look at line 1700, 1704, can secure possession by an agreement, comply with section 40 of the act to secure temporary possession, and then provide them notice under the other provisions of the act. And it says, the landlord shall comply with all notice requirements under this chapter before stopping a utility service. So the notices that I mentioned in the previous bill are in this bill, and so they have to comply with those before they can turn off a utility service.
Thank you, Mr. Chairman.
Any other questions? Any other questions? Seeing none, we're ready for your motion, Senator.
My motion is passage on the morning roll call, Mr. President.
Adopt the committee substitute, please.
I'm sorry, we adopt the committee sub.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. All right, now we're on the bill, Senator.
Passage on the morning roll call, Mr. President.
Passage on the morning roll call has been requested. Anyone object to the procedure? Which to be recorded as voting no. Present. Present Turner. Present Simmons, D. Anyone else? Barnett? Anyone else? Jackson? Anyone else? Yes. Seeing none, the bill passes. Senator, we're on 115.
Mr. President, I ask that items 115 to 117, that we skip those and they keep their place on the calendar, and we go to item 118, call that up, and ask the title be read.
Mr. Clerk, please read the title, 115, 16, and 17.
Senate Bill number 2509, outdoor advertising signs, remove maximum limits on height and square footage.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Move that we call up the committee substitute and let the Honorable Vice Chair explain the bill.
Thank you. Senator Branning, you're recognized to explain the bill.
Thank you, Mr. President. Senate Bill 2509 is really an attempt to clarify our law regarding the height of signs that are located on state highways. In 2008, there was an attempt, or there actually was a bill passed that put a 40-foot restriction on height, but there was some language that was a little inconsistent about whether the existing signs were grandfathered in. So what this bill is attempting to do is make it clear that any signs in existence prior to 2008 would be grandfathered in without the restriction. And you'll see that the change in law on line 26 of the bill. And it now would read, the height of any sign structures erected on or after April 15, 2008, or any replacements thereof, shall not exceed 40 feet above the level of the road grade. And that is an explanation over the bill. Happy to yield for questions.
Any questions on the bill? Seeing none, we're ready to proceed, Senator.
Move final passage on the morning roll call.
We got to adopt the committee substitute first, please, ma'am.
Move for adoption of the committee substitute.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Now we're ready, Senator.
Final passage on the morning roll call.
Thank you. Anyone object to the procedure? We should be, of course, voting no. Present. Thank you. Thank you, Senator Wiggins. Chairman Fillingane.
Thank you, Mr. President. I'd like to go to item 119, call it up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2237, Senate suspension, prohibit for crimes involving the exploitation of children.
Made the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Fillingham.
Thank you, Mr. President. I'll go to the committee substitute in lieu of the original bill and ask that you recognize Senator Sparks to
Recognized to
explain.
explain the substitute, Senator Sparks.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2237, we have a committee sub. We will also have a strike-all amendment. Would you like me to explain the committee sub first and then address the strike-all amendment? The committee sub addresses child exploitation and the fact that some sentences were being given and then suspended. This would actually make the 5-year mandatory sentence not be reduced or suspended, and that person would not be eligible for parole or probation for that 5-year mandatory period. And that is the committee sub. Would ask to adopt the committee sub at this time unless there's questions.
Questions on the substitute? Motion's made. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator, you recognize.
Yes, Mr. President, we have an amendment which is on the board. The strike-all is the exact same language that I just presented to you, but it brings forward Code Section 97.531, which has definitions as it relates to these crimes. We wanted to make sure that we had that proper with this, and it also adds in Section 3 a reverse repealer. That is an explanation of the strike-all amendment, and I would yield any questions.
Questions on the bill? Senator Barnett, you recognize. Senator Barrett, I'm sorry.
Thank you, Mr. President. Senator Sparks, thank you for all your work on this. Does this bill affect any other crime other than that of sex exploitation?
It does not affect any other crime than what is listed in 97.535, which is referencing 97.533, which is the sexual exploitation of a child.
Thank you.
Senator Hill, for a purpose you seek recognition.
Just a brief question.
Go ahead, Senator Sparks.
I yield.
I appreciate the spirit of this bill and what it's doing. My question is that they got to serve the mandatory 5 and they can't get parole or probation. I believe somewhere in our statute it says that that house arrest or I guess having an ankle bracelet on is considered incarceration by MDOC. Is that accurate for this particular crime? Could they be considered incarcerated and just be wearing an ankle bracelet, or they got to be inside a correctional institute?
I don't think that would qualify because this is considered a sex crime or considered a crime, potentially a crime of violence.
Mm-hmm.
But I will certainly, of course, we have a reverse repealer and we can certainly double check.
Let's look at that and just make sure that we're not putting an ankle bracelet on these sexual exploitation crimes.
Understand. Be glad
Thank you.
to. Thank you.
Thank you, Senator Hill. Other questions? Seeing none, we're ready.
I'd move that we adopt the strike-all amendment, or is it for passage?
This is for amendment, Senator. The motion is to adopt the amendment. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Now we're ready, Senator.
I would move for passage on the morning roll call, Mr.
This
President.
morning roll call has been requested. Anyone object to the procedure? Wish to be recorded as voting no. President Hickman, President. Anyone else? Anyone else? Thank you. 120, I'm sorry, McClendon, Senator McClendon.
Thank you, Mr. President. By unanimous consent, I'd like to be added as co-author to this bill, please.
McClendon, Parker, Kaufman, Hill, Tate, Barrett, Younger, McMahon, Branning, McCon, Chisholm, Whaley, Seymour, Moran, Sparks. Anyone else? Anyone else? Blackwell, I'm sorry. Blackwell. Anyone else? Seeing none, Seeing no objection, permission is granted. I'm sorry, England? England. Anyone else? That anybody? Okay. All right, 120, recognize you.
Thank you, Mr. President. I'd like to go to item 120, call it up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2244, juvenile offenders provide alternative sentencing and parole options.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Fillingham.
I move that we go to the committee substitute in lieu of the original bill and ask that you recognize Senator Thompson to explain.
Senator Thompson, you're recognized to explain the committee substitute.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2244 is the juvenile sentencing structure that would comply with the mandates of the U.S. Supreme Court decision in Miller versus Alabama. In Miller and subsequent cases, the Supreme Court found that mandatory sentences of life without parole, without the possibility of parole for juvenile offenders is unconstitutional as a violation of their Eighth Amendment's prohibition against cruel and unusual punishment. What this bill would do, which Senate Bill 2240, what the committee sub would do, is set up a hearing requirement that after being found guilty, that the court would conduct a hearing to evaluate the Miller factors as to whether or not the juvenile who's committed of the crime, or convicted of the crime rather, satisfies any of the Miller factors such that he or she may not be sentenced to life without the possibility of parole. This is very similar to the bill that we passed out of here, I believe the last 2 years, and they've died in the House as a result. All of our juvenile capital sentencing cases are sent up to appeal and come back to the trial court in order to comply with the Miller requirements. This would avoid that and let the trial court to take care of it on the first go-round. I'm happy to answer any questions. If not, move for passage on the morning roll call.
Senator Younger, for what purpose you seek recognition?
A real quick question, please.
Do you, Senator Thompson?
I do.
Please
Thank you,
proceed.
Mr. President. Thank you, Mr. Chairman, or Vice Chairman. If a juvenile, say, went out and killed 5 people on a rampage, and we know that he did it, and he's on camera for doing it, would this law still take effect for him or her?
Thank you for your question, Senator. That's a good point. This is after the conviction, so this would have nothing to do with the conviction of itself. The state still bears their burden to convict the individual. After conviction, if that crime that the juvenile is sentenced of is subject to life without the possibility of parole, if that's his sentencing, which is the second phase of the trial, then it triggers the Miller factors. The court would hold a separate sentencing hearing for the juvenile, and its juvenile is convicted of first degree, second degree, or capital murder, that when the possibility of the life without parole is on the table, the section sets out the term of years to be imposed when the judge determines that life imprisonment with the eligibility of parole is the proper sentence. So it all applies to the sentencing phase of the trial, not the actual conviction phase.
Okay, other questions? Senator Simmons, D. For what purpose you seek recognition?
Question, Mr. President.
Please proceed.
Thank you, Mr. President. Senator, would the jury or the judge determine the sentence?
This would be the judge would be the one, in the event of a jury trial, the jury would convict or acquit the defendant, and it would be up to the judge to conduct the Miller sentencing hearing.
That's right. And in the case of juveniles, and I raised this question in committee, do we want to be cautious and make sure that the same jury that determined the guilt phase is also the jury that will determine whether or not a minor in Mississippi should get a life sentence without the possibility of parole, as opposed to just a judge?
You and I have talked about this before, Senator Simmons. I can appreciate the concern. I think that the judge, after having sat through the trial, he's only dealing with the sentencing. He's not dealing with the conviction. I think the judge is more than capable of conducting a hearing, evaluating and applying the Miller factors, and determining whether or not that juvenile is eligible for, should be sentenced to life without the possibility of parole. And the backstop to that, Senator, is there's still an appeal process. That defendant, if he disagrees with this conviction and or the sentencing, still is eligible, he can appeal that to the appellate court. So whether or not it's the judge or the jury who's conducting the sentencing hearing, that appellate process is still there. So I do think that there's a backstop. I appreciate your point and your concern, but I do think there is a backstop there to any kind of abuse of discretion by the judge in conducting this Miller hearing and applying these factors in sentencing that juvenile.
And I really appreciate your response, Senator Thompson, but I want to be real clear. I am certainly not talking about the capabilities or the ability of our judges, and I certainly appreciate the appeal process. But would you agree with me, the reason why we are here is because of the U.S. Supreme Court ruling in Miller. And so they have determined that juveniles should be treated differently regarding life without the possibility of parole than adults. And so my concern is if we have a jury that goes through the entire trial process and can make a determination on guilt or innocence, then wouldn't it be really easy and also safer for us in the state of Mississippi that that jury determines that that juvenile should get life without parole, as opposed to a judge on the coast doing something or considering the Miller factors differently than a judge in the Delta? It's just when you have 12 people who have to agree to something, it is different than just one person. And that's my only concern, only as it relates to juveniles, not adults.
Correct. And you and I have talked about this before. We're probably dealing with a small number of cases to start off with. But to your first point, yes, Miller was the genesis of this line of cases. But our own Supreme Court in 2013 expanded Miller to our juveniles. So this has been adopted already in case law. The Miller factors and sentencing guidelines has already been adopted in our case law, in Mississippi case law. As far as I think my concern with the process of having the jury who's already sat through the trial and has already convicted the defendant, the process of having the jury come in on the sentencing phase to conduct the Miller hearing, there's no guidelines right now. There's no procedures that we have for a jury to do that. And that's where I think that can become a little bit convoluted. And I think that from the defendant's standpoint, it may be beneficial for that defendant to have a judge who's just going to apply facts to law, apply these Miller factors, and come up with the sentencing, as opposed to trying to get 12 people who are probably already on each other's last nerve. You and I have both polled jurors before. They're probably already on each other's last nerve. It could be very difficult to have those 12 people agree on how those factors should be applied. So I think from a procedural perspective, having the judge conduct that post-conviction sentencing hearing would be much more efficient.
And I agree with you. I think guidelines for that Miller sentencing procedure should be set forth by the legislature. I think that we should do that. And I agree with you. We don't have that. And that's the reason why I just asked one last question. Would it be a friendly amendment to put a reverse repealer in the bill so that we can look further on what should happen after conviction for juveniles?
Yes, sir, Mr. Senator. Yes, sir, Senator, that would be a friendly amendment.
All right, thank you. I have an amendment at the appropriate time, Mr. President.
Please prepare your amendment, Senator Simmons. Senator Seymour, for what purpose you seek recognition?
Question, Mr. President.
You, Senator?
Yes, sir.
Please proceed, Senator Seymour.
Senator, will this in any way, if there is a capital murder conviction, will it deter in any way the death sentence?
There is no death sentence available for minors. This is only for minors.
Only for minors? Okay.
Yes, sir.
Thank you, Senator Seymour. Senator Parker, for what purpose you seek recognition?
Question, Mr.
You,
President.
Senator Thompson?
Yes, sir, I do.
Let's go.
Thank you, Mr. President. Thank you, Senator. I remember talking about this, I think, last year, and, again, I always preface this with, I'm not an attorney, but I did pull up the case on this, and are you aware that the Supreme Court decision on this was a 5-4 vote or opinion that was given down?
That's all they need.
Yeah. Well, so to that point, the 4 justices who at that time voted in dissent on this were Chief Justice Roberts, Scalia, Thomas, and Alito. And Chief Justice Roberts gave this dissent in the filing. He filed a dissenting opinion, a reason that the court's role to apply the law, not to answer questions about morality and social policy. The majority did not sufficiently characterize the punishment as unusual. Therefore, the punishment did not violate the 8th Amendment. Justices Anthony, Scalia, Thomas, and Alito joined in the dissent. So I guess my question on this is that it's our purview here to set our policy. There are certain things that we do conform our policy to meet the federal standard zone, but it seems on this that perhaps if a similar case went to the Supreme Court today, perhaps a different justice or a different opinion might be entered on that. And I just bring that to the attention of the body because I am all in favor of conforming our statute to meet federal statutes when they apply correctly, but I have concern on the decision on this and what we're doing here today.
Thank you, Senator Parker. Senator Branning, for what purpose?
Wait, I haven't answered this.
1 second, please. It's okay. Senator Branning, for what purpose?
Question, please.
Were you for a question, Senator Thompson?
Yes.
Please proceed.
Was there a bill that was brought forward last year on this matter?
Yes, I believe the past 2 years.
What was the disposition of the bill in this chamber last year?
I believe it passed out of here handedly.
We did pass it through this chamber last year.
Yes, sir.
How did it differ from what's before us today?
I don't think it did. I don't believe it did differ from what's before us today.
The same bill? Okay, thank you very much.
Thank you.
Thank you, Senator Branning. Senator Hill, for what purpose? Senator Hill passes. Senator Turner, for what purpose?
Question.
Were you for a question, Senator Thompson?
Yes.
Please proceed, Senator Turner.
Thank you, Mr. President. And thank you, Senator. I'm looking at lines 32 and 33, which refer to a juvenile offender who is convicted of first-degree or second-degree murder or capital murder may be sentenced to life imprisonment or life imprisonment without eligibility for parole. And my question is, does that language create a false choice that there's a difference between life imprisonment or life imprisonment without parole?
Well, that's what the Miller decision was, and the progeny of Miller was that for a juvenile offender, to sentence that offender to life without the possibility of parole is a violation of his or her Eighth Amendment rights. So I don't know that it creates if the idea is that if the juvenile is convicted of a crime that the sentence would be life without the possibility of parole, that's a violation of his Eighth Amendment rights under Miller and under the State versus Jones, the Mississippi case that adopted Miller. then you have to go to the Miller sentencing hearing in order to evaluate whether or not that individual would have parole available. Am I answering your question?
You are, but if there's going to be a reverse repeal, I may be able to ask it later. Thank you.
I may be able to explain it better later.
Thank you.
Thank you, Senator. Senator Wiggins, for what purpose you seek recognition? Senator Wiggins. You seek recognition, sir? Pass. Thank you very much. Senator Thompson, we're ready now.
We have a motion is to adopt the committee sub.
All those in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We recognize Senator Simmons for the amendment.
Thank you, Mr. President. Members of the Senate, this is just to make sure that we will follow the law and do the right thing regarding juveniles in the state of Mississippi and answer all the questions that were raised today and even more questions that we may have regarding juveniles in the state of Mississippi and the U.S. Supreme Court ruling, as well as the Mississippi Supreme Court's ruling. And so it's supported by the chairman, is also supported by Senator Thompson, and I ask you to adopt the amendment.
Questions on the amendment? Seeing none, we're ready for your motion, Senator Simmons.
I move adoption of the amendment, Mr. President.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Please proceed. We're ready on the bill.
Move for final passage on the morning roll call.
Senators move for a final passage on the morning roll call. Anyone object to procedure? We should be recorded as voting no. Tate, Barrett, Seymour, Hill, Williams, McClendon, England, Parker, Kaufman, McMahon, Whaley, Younger, McCon. Anyone else? Branning, McDaniel, Sojourner, Chisholm. Anyone else? Chris Johnson. Anyone else? Anyone else? One moment, Mr. Chairman.
And the next one.
18 noes. Senator, you're recognized. We're on 121 on the calendar.
Thank you, Mr. President. I'd like to go to item 121, call up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2246, warrants, authorized issuance for sex offenses against children upon oral testimony.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Fillingane.
Thank you, Mr. President. I have an amendment I need to make to the bill.
Okay, we need to pass the bill first, Senator.
And the purpose of the amendment, if I'm recognized.
Right, you recognize.
The purpose of the amendment is just to clarify, this bill is, was presented in the committee that authorizes a judge to issue a search warrant for sex crimes against children involving computers. And we wanted to make very sure, based on the questioning in the committee and the concerns that were raised, that we were only applying this to sex crimes involving a child with a computer. And so we have this amendment, even though it may not have been necessary, we just wanted to be absolutely sure that that's the only thing that this bill would be applied to. So you can see the amendment, that's what it does. I would move adoption of the amendment if there are questions on the amendment.
Questions? Seeing none, we're ready. Motion to adopt the amendment. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Senator, we're back on the bill.
Thank you, Mr. President. So this bill was requested by the Attorney General's office. And again, I'll be very brief. I know that hours late. The legislation authorizes a judge to issue a search warrant for sex crimes against a child involving a computer based upon the sworn testimony communicated by telephone or other appropriate electronic means. The reason for this and the reason we're asking for this piece of legislation on behalf of the Attorney General's office is there are just a handful of investigators, most of whom are located right here in the city of Jackson, that work in the AG's office, and they cover the entire state for these particular crimes against children involving computer. So under the current rules, they have to, if they've got a case in the Delta or on the Mississippi Gulf Coast or wherever, they have to travel, 2, 3, 4 hours to get to the judge in person, face to face, and do the same thing that they can actually do over the phone or electronically, given, the technology of today. So this would save, hours and hours of manpower and time that could be used better investigating these cases instead of traveling the roads of the state, getting in front of a judge face to face. Last year, there were 1,491 cyber tips, and that was in 2020, and in 2021, there were 2,783 of these tips that have to be investigated. So the workload is enormous. There are just a handful of people that do this, and so the AG's office believes will really speed up the process of getting the crimes actually investigated, as opposed to just traveling the highways and byways of Mississippi to track down a judge. That's what the bill does. I'll be happy to answer any questions.
Questions on the bill? Seeing none, ready for your motion, Senator.
Move adoption based on the morning roll call.
Morning roll call has been requested. Anyone object to procedure? We should be, of course, voting no. Present. Seeing none, the bill passes. 122.
I'd like to go to that item called up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2545, detached catalytic converter, prescribe criminal penalties to sale unless certain conditions are met.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it.
I would ask that you recognize Senator Thompson to explain his bill.
Senator Thompson, you're recognized to explain the bill.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2545 is an effort to address catalytic converter theft in the state of Mississippi. I know from firsthand experience that this is a significant problem in my area of the state. Since introducing this bill, I've heard from several members of this body about the problem that exists in their parts of the state. And this bill is an effort to try to address that by capping the market for catalytic converters, making it harder for thieves to sell those catalytic converters to registered scrap dealers. And I have an amendment on the bill at the proper time, Mr. President.
Questions? Seeing none, we're ready on the amendment, please, sir. Is it on the
amendment
screen?
It's on the screen. The amendment would only delete the word sell in line 12 of the bill, so that the bill is focused on those who are buying or transferring the catalytic converters, not the sellers who, in the case of an illicit sale, would be the thieves.
Questions on the amendment? Senator Whaley, for what purpose, sir?
My question's on the bill.
Okay, one moment, please. On the amendment, any questions on the amendment? Okay, we're ready for your motion, Senator.
Move to adopt the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. We're on the bill. Senator Whaley, you're recognized.
Thank you, Mr. President. Senator, I heard you mention that you were going to make it harder for people to sell them. Who would be able to sell them? Where would they be able to sell them?
Sure. So in the first section of the bill,
Yes, right there.
So in the first section of the bill, do you get my bill? I had the one that I marked up, but it's okay. So in the first section of the bill, it sets forth so this would apply to the scrap dealers, correct? So turning over to pages, to lines 37 and onward, the seller of the catalytic converter would have to provide the scrap dealer with the name of the person who removed it from the vehicle, the name of the person for whom the removal was completed, make and model of the vehicle, the VIN, the ID number. If there is a part number or other identifying number on the catalytic converter that was removed, they would have to provide that. A copy of the driver's license of the seller of the catalytic converter, and a copy of the certificate of title from the vehicle which it was removed from. So the idea being there that a thief who's removed a catalytic converter from a vehicle would not have that information to be able to provide it to the scrap dealer.
Well, I understand that, but what about the shop worker who has that catalytic converter who is selling it? Is he going to have to go through every single step that you just named off as well?
I'm sorry, the shop worker who's buying it?
Well, the shop worker who is selling the catalytic converter, when, say, I know your bill is aimed at the theft, but there are a lot of catalytic converters that are replaced every day from being clogged up.
Sure.
And this is a legitimate problem that we have with shops, so are these just going to be, I guess, paperweights, or what's going to be the case with these?
No, he would be able to sell those catalytic converters, provided that he could provide that information to the scrap dealer who's buying the catalytic converter.
Okay.
And I think that to expand your question to a hypothetical, if I go in to get my catalytic converter and muffler replaced at a local shop, when they take on that job, they could get that information. They'll already have most of it. They'll already have the VIN, they'll already have the name of the vehicle owner and other things, but they could get a copy of the title and things like that, so that when they go to scrap that catalytic converter that's being removed, they'll be able to satisfy the requirements of this legislation.
Okay, so who would the scrapyard or the buyer, who would they turn this information into?
Secretary of State.
To the Secretary of State?
They maintain the information for and turn it to the Secretary of State, similar to or identical to, if you turn to sections 2 and 3 of the bill. So section 2 that starts on line 88, that is the current Scrap Metal Theft Act, and the amendments are on lines 117 through 124 to add detached catalytic converters to the definition of metal property as defined in that act, as well as lines 408 to 411. It makes the Scrap Metal Theft Act applicable to detached catalytic converters. Also, Section 3 adds the detached catalytic converters to the scrap metal dealer laws, and that provides that obligates the scrap metal dealers to provide that information or to retain that information and report to the Secretary of State.
How often would that reporting be required?
Whatever it is currently, we're not changing the reporting requirements in that section of the law. We're only adding catalytic converters to the reporting requirements.
Well, Senator, with all due respect, I haven't seen that. I don't know, so that's the reason why I'm asking you. Would it be a quarterly, or, I mean, that's kind of where I'm getting at.
On how often the scrap metal dealers have to report to the Secretary of State?
Yes, sir.
It's the same as whatever's under current law. All we're doing is adding catalytic converters to the scrap metal, definition of scrap metal.
What's to stop a thief from going to an out-of-state buyer?
Nothing. That's the problem we have right now in Mississippi.
So
Alabama passed this law back in the summer, and they've seen an influx of Alabama tags showing up at Mississippi scrap dealers and selling stolen catalytic converters.
So what if you had a buyer that came in from the state of, let's say, Kentucky? Will there be anything to illegalize him from buying these catalytic converters?
Yes, the Scrap Metal Dealer Act, he would have to be registered with the Mississippi Secretary of State in order to purchase those catalytic converters.
All right, well, I think that's almost all the questions I've got, but I do have one more. I heard you say that this is a big issue in your part of the state. What does it sound like on a vehicle when you have a converter that's taken off?
I defer to Senator England for sound effects.
I understand. Thank you.
Thank you, Senator Whaley. Other questions? Other questions? We're ready, Senator, on the bill.
Move for passage on the morning roll call.
Anyone object to the procedure? Reporters voting no. Whaley. McDaniel. Sojourner. Williams. Anyone else? Turner. Seymour. Anyone else? Anyone else? Seeing none, we're on bill passes 123, Mr. Chairman.
Thank you, Mr. President. Let's go to item 123, called up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2601, Mississippi Pink Alert Act 2022, create.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed, Senator Fillingham.
Thank you, Mr. President. I move that we go to the committee substitute in lieu of the original bill and ask to recognize Senator McMahon to handle his bill.
Senator McMahon, you're recognized to explain the committee substitute.
Thank you, Mr. President. 2 years ago, a friend of mine brought this to my attention, like Mary Roberts up here in the corner. Wave, Mary. She brought this. Her family dealt with a situation where they had a minor, a junior, a juvenile that came up missing. And so they tried to file a missing report, and there were some problems doing that. So what we're trying to do is I've worked with law enforcement. I've taken her idea. I've worked with law enforcement, and I've worked with the commissioner, and we're trying to create another segment in the law. So you're all familiar with Amber Alerts. You're familiar with Silver Alerts. This will be a Pink Alert. And that was what the intent of the bill was. Now, it was amended in committee, and it opened it up beyond the intent of the bill. So I am going to have an amendment that I'm going to offer here to try to get the spirit of the bill back. Y'all have the amendment?
Yes. Put the amendment up, please, sir. Thank you.
So the bill does exactly what it says it does, Senators. But what I would like to do is amend line 32 by deleting persons and putting the spirit of the bill back in there, which is female children who are the age of 8 years to 17 years. And then on line 42 by deleting person and adding female child who is age 8 years to 17 years of age. That's what the Pink Alert will do.
Senator Simmons, for what purpose you seek recognition?
Question on the amendment, Mr. President.
Will you yield, Senator McMahon?
I do.
Senator Simmons is recognized.
Thank you, Mr. President. So Senator McMahon, could a 7-year-old be sex trafficked?
They could.
So based off this amendment, the Pink Alert would not be issued if a 7-year-old girl in the Delta was suspected of being a victim of sex trafficking based off this amendment.
The Amber Alert would be activated in that case.
Now, right now we're talking about the Pink Alert.
I realize that.
So my question is,
there's already something to deal with that. If a minor comes up missing, they would issue an Amber Alert. This is for specifically if they think there's sex trafficking involved in it.
okay, so I ask my question again. If a 7-year-old girl in the Delta was suspected of being a victim of sex trafficking based off your amendment, a Pink Alert will not be issued, correct?
That would be correct.
And
I would work with you. I've offered to work with you on this, and I dropped the age from 13 to 17 to 8 to 17 to work with you. If you want to go lower than that, we will. The opposition I have is to leave it open-ended into the adult range. It's the intent of the law is for juvenile and for minor children, Senator.
And Senator McMahon, out of all due respect, in committee, this was considered, and the committee determined that we should not make a distinction based off age, and we should not make a distinction based off sex, because boys could be sex trafficked as well.
And I discussed that in committee, and I'm presenting this to the body to allow the body to work, if this is what the will of the body. But we did look at a blue alert as well, but that was confusing. It was almost like it was a police. We looked at a baby blue alert, but that sounds like almost like, people might not take it serious. If you want to offer something at some point, but the intent of this bill, the Pink Alert, and a lot of meetings went on behind the scenes about this, is to deal with juvenile and minor girls, the Pink Alert. Now, there is a segment already in the law that allows for endangered children. So they could still activate it on that as well. But the Pink Alert, like I said, people know, if you hear on the radio or you get an Amber Alert on your phone, people know it immediately. Hey, a child's missing, and they start looking. Same thing, Silver Alert. If it's Silver Alert's issue, in your mind, you just automatically trigger, hey, I need to be looking for this elderly person. This Pink Alert is for minor children.
And And
Wendy.
I really appreciate your work on the bill. I just stand in support of the committee that if we're going to pass policy in the state of Mississippi regarding something as serious as sex trafficking, we don't need to discriminate based off age or sex. Thank you.
Thank you, Senator Simmons. Senator Barnett. Speak on the amendment, one moment, please. Senator Hobson.
Question, Mr. President.
Were you for a question, sir?
For me or?
For you,
Yes, sir.
Senator McMahon. Yes. Thank you, Mr. President. Thank you, Senator. We've got Amber Alert to cover any children that are abducted and taken away. Wouldn't that cover these children too?
Normally, it would, but this is for a very specific category where you believe it's an older child who's not an adult, but an older child, and you think they're being sex trafficked or they're involved in some sexual, they're involved in a situation that there may be some sexual activity involved, and so they're looking for this young person. An older child could just merely call in and say, "Hey, here's where I am. I'm fine," and then they would take the pink alert down.
I don't disagree with your intent to protect children from sex trafficking, but I think the Amber Alert would already cover that if it's a child that's been abducted or missing. Do you think it might confuse the public more? There's one place to go. We know it's Amber Alert, as opposed to, wait, no, is this Amber Alert or what's that other one called, the Pink Alert? I think the idea is to get the response out, and if any child is taken, whether it's sex trafficking or some other nefarious means, wouldn't it make more sense to just have one alert and get the police on it right away rather than creating more bureaucracy, more issues to have to deal with instead of just reporting it by a well-known hotline to call?
It's really not creating any more bureaucracy. The exact same people that engage an Amber Alert or a Silver Alert or the Endangered Child Alert will engage this as well. It's just another tool in the toolbox, Senator.
I don't disagree with your sympathy and compassion for the issue, but I feel like it may be confusing the issue more, and I hope you'll respect the line of questioning in that regard, because it may create more confusion. But thank you, Senator.
Absolutely.
Thank you, Senator Hobson. Other questions? All right, Senator, we need to go back to the committee substitute and adopt it, please, first.
Adopt the committee sub.
All in favor signify by saying aye. Opposed, no. The ayes have it. Now we're on the amendment, and Senator, you are recognized for speaking on the amendment. It's 5 minutes, yeah.
I have 5 minutes.
You have 5 minutes.
Thank you, Mr. President. Thank you, Mr. Chairman. I was fortunate to be part of the committee when this bill came through. And there was an agreement in the committee as to how we would see this move forward. And I would think that if there was something different, then those members of that committee would have been notified, at least talked to before these amendments would come to the floor, out of respect. Because I think in committee we did this out of respect for our fellow senator. So that's the one problem that I have with it. The second problem that I have with it is, what do we do when we have all of these alerts and it starts to get confusing to all of us when we talk about Amber Alerts, and now we're talking about a Pink Alert, and we're talking about all these different kind of alerts. If we're truly concerned about our children and them being sex trafficking, then I think all of our children should fit under one category. And that category should be for the love of our children, not a pink, not a blue, not a black, not a white, but have one uniform system that will protect all of our children under all circumstances. When I think about this, I think about the little 2-year-old boy that was kidnapped from one place and raped in another place. Now do we come back and establish another law to protect him when we already have one that's protecting our children in Mississippi? Why make a distinction between our young boys and our young girls? I don't think there's a senator in this place that does not love one more than the other, who does not think that one is more important than the other. I think that the system that we have in place today is effective. If we're going to do anything to enhance this, then maybe we need to work on what we have versus trying to make distinctions. So I'm asking you, my fellow colleagues, to vote no on this amendment. Thank you, Mr. President.
Senator Branning, for what purpose you seek recognition?
Question for Senator McMahon, please.
Senator McMahon, will you yield for a question?
I do.
Senator Branning is recognized.
Mr. Chairman, I appreciate any efforts to protect children in the state of Mississippi. My question is, you know, I'm a mother of 3 boys.
Yes, ma'am.
Their ages are 10, 16, and 18. In your amendment, are there any protections for my boys?
In the amendment, no, but you could activate an Amber Alert if you thought your boys were missing. This is just another tool in the toolbox that gets the public engaged when you hear, you know, if you hear on the radio, hey, an elderly person's missing, you don't necessarily start, you're like, yeah, they're missing. But when you hear Silver Alert, you know, immediately in your mind goes to a different gear. Oh, I need to really be, you know, this is important. I need to be looking for this. And that's what this does. And
I appreciate that, but I guess my question is, why would there not be enhanced protection for my little boys when certainly I support the enhanced protection for little girls as well?
I appreciate that, Senator. We were trying to come up with a color for little boys. You know, it didn't necessarily, we couldn't come up with the right color on that since the intent was to deal with women. But look, I'm happy with whatever the will of this body is. I'm fine with it either way.
Thank you for your work. I appreciate it.
What I'm interested in is engaging, in getting the people of Mississippi engaged on a pink alert, like, hey, something's not right. It's an older child. In most of the cases that law enforcement deal with, it's older teenage ladies that come up missing. And so that's what the intent of the bill is. And I ask you to use, this is good common sense. This is common sense, guys. You have an Amber Alert, missing child. Silver Alert, missing adult. Pink Alert, missing more than a missing female. And then Endangered Child Alert would capture all of those, just like the Amber. I ask you to support the amendment.
Senator Parker, for what purpose you seek recognition?
Question, Mr. President.
For whom, sir? For which senator?
For Senator McMahon.
Wait, will you yield, Senator McMahon?
I do.
Please proceed, Senator
I
Parker.
think my question goes to the amendment and it goes to the bill a little bit, and I appreciate what you're doing here too. And I know this process is designed so that we think about this and we come up with the best idea. And I think several things have been suggested here already that have me thinking anyway. I know in my mind to Senator Barnett's kind of point a moment ago that Amber does make me think children. And Silver does make me think older adults. So just my thinking on the process is if our intent is to increase some priority for children in a unique circumstance, did you give any consideration to maybe something of the effect of an Amber trafficking alert or an Amber priority alert or something like that, where we use the existing and then we tried to build on that? Was that in part of any of the discussions at all?
We looked at it. I met with the commissioner several different times. We felt like this was the best way to move forward with it. If the amendment fails, we're still going to have the bill to move forward. And I did discuss this with several of the senators that were in the committee. I did discuss it with them before I presented this evening.
Right. And as it moves forward, I think there have been some interesting questions, and you know, I'm with you, and I'm with your constituent up here 100 times over. But what I want to be sure of is that, you know, I know in this body sometimes we do create some confusion that defeats the purpose of what we're trying to do. I just want to be sure that we're very careful that we try our best not to do that. But thanks for answering my question.
Sure. Yeah. Happy to.
Senator Hickman, for what purpose you seek recognition?
Question, Mr.
You
President.
for a question, Senator?
Yes, sir. Yes,
Please
sir.
proceed, Senator Hickman.
Senator, as you know, I'm one of the ones who had some difficulties with this bill being directed at, you know, one sex. So a question, we talk about an Amber Alert. How do we get, was not the Amber Alert named after a child that had gone missing?
I believe it was named after a child.
And would you know if Amber would probably be a male or a female?
I would guess that would be a female.
But when we say Amber Alert, we don't just think about female children,
That's
we
true.
think about children generally.
That's true.
And so could not this pink alert just be our alert when we think about a child being sex trafficked?
Sure.
And so the specificity of the bill, this wouldn't confuse Amber Alert because the Amber Alert is just a missing child.
Right.
But this alert is for a specific, and they're you know, because we brought up the question, well, what's the difference between this and Amber Alert? But there are specific instances when this could be pushed, and it's specifically when we think a child is being sex trafficked. Is that correct?
Would you ask me that again?
Is this alert specifically for when we think, or instance where it's probable that this child that we're looking for is being sex trafficked?
Yes.
Okay. And when looking at that, so a pink alert could deal generally with sex trafficking, and I don't think that would confuse or subjugate the point that you brought this bill up for.
Ask me that one more time, sir.
Would this affect the purpose at which you brought this bill up for if we just had children?
Well, the purpose of the bill is, in the people that I worked with and on it, was to highlight young women between the ages of 13 and 17. But to work with Senator Simmons and some others, you know, I lowered that age to 8. I'm willing to entertain a different age, but it's whatever the will of the body wants to do on this.
And one final question, would it surprise you to know that some statistics say the fastest growing group of child trafficking victims would be males?
If you say so.
Thank you.
Thank you.
Senator Hill, for what purpose you seek recognition?
Just a question.
Would you yield, Senator? Please proceed,
Sure.
Senator Hill.
Senator Mann, I appreciate your concern and what you're doing, and I would like to help you with this. And so I guess my question is, since we're kind of at an impasse here, would you be willing to withdraw your amendment and allow me to put a reverse repealer in this and let us kind of put our heads together and see if we can kind of satisfy the concerns of the body? Because I don't want this to die, but I would be willing to work with you to try to help you work through this, because I feel like that there may potentially be a need for this.
That's fine with me, Senator, if you'd like to put a reverse repealer in it. Yeah, I'll work with you to withdraw my amendment, and here's an amendment for a reverse repealer.
Okay, I think we could maybe work together on it, and I want to help you do that.
I want it to be something that's practical and
Because you
good
know I
common
hung with
sense
you.
for everybody.
I hung with you, and I'm going to try to help you on it.
Absolutely. I care about the health of the children in the state just like everybody else does.
Okay, are we withdrawing this amendment?
I withdraw my amendment.
Okay, Senator Hill, you recognized for a second amendment, please, ma'am.
I'd like to add a reverse repealer to this so that we can continue looking at this and see if there's some agreement that we could reach.
Questions on the amendment, second amendment? Questions on the amendment? Seeing none, we're ready for your motion, Senator.
My motion will be adopt the amendment.
One moment, please. Senator Hobson, do you have what purpose you seek recognition?
Point of order, Mr. President.
Please proceed.
Is the amendment on the bill or on the, where are we in this process? With the
Senator,
amendment, the committee
The
sub
amendment
has
will be
been.
on the committee
The
sub.
amendment to the committee sub has been withdrawn. Do we need to adopt the committee sub and then amendment to the final bill, or are we amending the committee sub? Is that the
Committee
proposal?
sub's already been adopted.
It's my understanding the committee substitute had been adopted,
All
is that
right,
correct?
so
So
amendment
this
to
is
committee
just an
sub.
amendment to the committee sub, a
That's
reverse
correct.
repealer.
Thank you, Mr. President.
Thank you. Okay, we're ready, Senator Hill, on your motion.
Motion is to adopt the amendment, the
All in
reverse
favor?
repealer on the committee sub.
All in favor signify by saying aye. Opposed, no. All right, the ayes have it. We're on the final passage. Senator McMahon.
I move for passage on the morning roll call.
Anyone object to the procedure? Pardon me? You object to the procedure?
Yes, Mr. President.
Okay, call the roll, Mr. Clerk.
Barnett, Barrett, Blackman, Blackwell, Blunt, Boyd, Branny, Bryan, Butler to 36, Butler to 38, Carter, Kaufman, Chazanall, Chisholm, DeBar, Delano, England, Fillingane, Frazier, Harkins, Hickman, Hill, Hobson, Horn, Jackson, Johnson, Jordan, Kirby, McCon, McDaniel, McClendon, McMahon.
Aye.
Michelle. Moran. Norwood. Parker. Parks. Polk. Seymour. Simmons of the 12th. Simmons of the 13th. Sojourner. Sparks. Suber. Tate. Thomas. Thompson. Turner Ford. Whaley. Wiggins. Williams. Younger. Barnett. Did he say aye?
Did you say aye?
Barnett? Aye.
Barrett. Blackman.
Hey, man, appreciate what you said.
Blackwell.
President Blackwell.
Blunt. Boyd. Brenning. Butler 36. Butler 38. Chisholm. DeBar. England. Frazier. Hickman. Hobson. Horn. Jackson. McCon. McDaniel. McClendon. Norwood. Parks. Simmons of the 12th. Simmons of the 13th. Sojourner. Sparks. Thomas. Thompson. Turner Ford. Whaley. Wiggins. Voting yes or yay. Barnett, Barrett. Blunt, Boyd, Branning, Bryan, Butler to 38. Carter. Kaufman, Chadzenall, DeBar, Delano, England, Fillingham, Harkins, Hickman, Hill, Hobson, Jackson, Johnson, Jordan, Kirby, McCon, McClendon, McMahon, Michelle, Moran, Norwood, Parker, Polk, Seymour, Simmons of the 12th, Simmons of the 13th, Sparks, Suber, Tate, Thomas, Thompson, Turner Ford, Whaley, Wiggins, Williams, Younger. Voting present, Blackwell and Butler of the 36.
Senator Younger, is your button on, sir? Thank you.
43.
They get it on up there.
43 yeas, the bill passes. Thank you, Senator. Senator Fillingham, you're recognized, 124.
I would like to thank Mary Roberts, Carol Upton, Valerie Bradley, and Tanner Newman for their work and guidance as we wrote this bill together and brought it forward. Thank you all for your work and support. Thank you.
Thank you, Senator. Senator Fillingham, we're on 124, sir.
I'd like to skip item 124 and have it retain its place on the calendar and go to item 125.
Mr. Clerk, please read the title.
Senate Bill number 2261, Buddy's Law, ordering psychiatric evaluations for children adjudicated delinquent for abuse of a domesticated dog or cat.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Please proceed.
Move that we go to the committee substitute in lieu of the original bill and that you recognize Senator Hill to explain her
Senator
bill.
Hill, you're recognized to explain the committee substitute.
Thank you, Mr. Chairman. Thank you, Mr. President. The committee substitute basically only does one thing, It requires any child adjudicated delinquent under the youth court section for abuse of a dog or cat to receive a psychiatric evaluation and any treatment if indicated and prescribed by the court. Doesn't change anything else in the animal statutes. It just puts this language for a youthful offender into that statute and brings forth the youth court statutes and also references it in the youth court statutes. It was brought to our attention after the dog that was burned up in Tate County and was taken care of and rehabilitated by Mississippi State, that many people that took care of the dog and handled the case felt like we needed something in the statute to make sure that youthful offenders got the evaluation and treatment that they needed to find the root problem of why they turned to abusing animals before they turned to abusing people. And that's basically what this committee substitute does.
Thank you, Senator. Okay, any questions? Seeing none, we're ready, Senator.
All right, I'd like to adopt the committee sub.
All in favor signify by saying aye. Aye. Opposed, no. The ayes have it. Please proceed, Senator.
I'd like to move to pass on the morning roll call.
Use the morning roll call if been requested. Anyone object to the procedure? Must be recorded as voting no. Present. Seeing none, the bill passes. 126, Senator Fillingane, you're recognized.
I'd like to get that item called up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2563, Mississippi Appeal Press Act of 2022 enact.
Make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye.
Aye.
Opposed, no. Please proceed.
Move that we go to the committee substitute in lieu of the original bill and that you recognize Senator Sparks to handle the bill.
Senator Sparks, you're recognized to explain the committee substitute.
Thank you, Mr. President. Thank you, Mr. Chairman. Senate Bill 2563 is known as the Mississippi Appeal Press Law of 2022. As many of you know, we have a major problem with fentanyl and other type substances in this state and across the country that are causing many deaths, particularly in young people. Much of this is happening because pills are being created and pressed into the formation of a recognizable drug that is unknown that's been laced with fentanyl. So this bill addresses that unless you're authorized by the State Board of Pharmacy, so that covers everyone that's in the pharmaceutical business, or other lawful authority such as the DEA, that it would be unlawful for a person to knowingly and intentionally possess, create, sell, barter, transfer, manufacture, distribute a pill press, punch, dye, plate, tableting machine, encapsulating machine, or other similar pharmaceutical producing equipment. And you have the second part, knowing, intending, and having a reasonable cause to believe that it will be used to manufacture a controlled substance or a counterfeit controlled substance. So it's not only possessing something, it is possessing it with the intent would be a crime. Subsection B would be a felony. It would be not more than 5 years, a $5,000 fine, or both. Subsection 3 addresses that this type of material, if you have it for another reason, for instance, maybe you are in the health food store business and you press vitamins, no problem. We would ask that you register this with the Mississippi Bureau of Narcotics. This is no charge for this. It is something that I met with the Bureau of Narcotics, the Department of Public Safety, and they believe that this will help them combat the fentanyl issue. Again, you don't have to register it if you're already registered with the Board of Pharmacy or other lawful authority. And the Department of Public Safety will promulgate rules regarding this registration, transfer, and destruction of such equipment and any renewal of such registrations and any inspection if necessary. That is an explanation of the committee substitute, and I would yield any questions, Mr. President.
Thank you, Senator. Any questions on the bill? The substitute, I'm sorry. Seeing none, we're ready on your motion. Senator Sparks.
Adoption of the committee sub.
All in favor signify by saying aye.
Aye.
Opposed, no. The ayes have it. Ready, Senator?
Passage on the morning roll call.
Use of the morning roll call has been requested. Anyone object to the procedure? Which be recorded as voting no. Present. McDaniel.
Sojourner.
Present. Sojourner. Anyone else? Bill passes. We go to 127, and that would be Chairman Barnett. Senator McClendon.
Thank you, Mr. President. By unanimous consent, I'd like to be put as co-author on this bill, please.
On 126? On which bill, sir? 2563?
126.
2563. Anyone else? Anyone else? Permission, seeing no objection, permission is granted. Chairman Barnett.
Thank you, Mr. President. I asked you to call up item 127 on today's calendar and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2437, work initiative, authorize the establishment of.
Senator, make the usual motion.
Senator makes the usual motion. All in favor and signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator.
Thank you, Mr. President. I asked you to be allowed to take up the committee sub in lieu of the original bill.
Permission is granted. You're recognized to explain the committee substitute.
Thank you, Mr. President. This bill, ladies and gentlemen, is similar to what we passed out last year with the Rankin County Sheriff, and that was putting those individuals who are incarcerated and actually giving them an opportunity to work while they're incarcerated, so that when they are released, then they have an opportunity to have a job and also have money saved that will help them out, as well as these people are also able to pay their fines and fees that they owe before they get out. And so what we're working on doing is establishing the same pilot program out at CMCL for those individuals who have 2 years or less left on their sentence through the MDOC. And we all know that at some point these people are going to get out. And I feel like it's incumbent upon us to make sure that when they get out is that they stay out. And one way I think that we can do that is providing them with some type of jobs and job skills with everyone that has less than 2 years left. This will be a pilot program again. Everyone who is selected can only be selected by Commissioner Kane or whoever the commissioner of MDOC is at the time. These individuals will be required to save 50% of their pay. 25% of their pay will go towards fines, fees, child support, or whatever it may be. 10% of this will be administrative for getting them to and from work, and 15% of their monies they will be able to use at the canteen. Basically, MDOC or the state of Mississippi doesn't receive any of this money, but we will give these people an opportunity to go to work when they get out. And what our attempt is here is, you know, for a long time in Mississippi, our Department of Corrections have been on the backs of the taxpayers in Mississippi. What we're trying to do here is put these same individuals back on the tax rolls in Mississippi. So I just ask for passage on the committee sub if there's no questions. Move to adopt the committee sub if there's no questions.
Senator Butler, for what purpose you seek recognition?
Question, Mr. President.
Senator Barnett for a question. Senator Butler, you're recognized.
Thank you, Mr. President. Thank you, Mr. Chairman. Just got one question for you. So this was, you know, we had that little hearing the other day with the chair from Rankin County about the program that you are talking about right now. What you're trying to do now is extend it to state inmates.
Yes, we want to start this at CMCF because, like I said, these individuals will be getting out in less than 2 years or less.
All right, thank you, Mr. Chairman.
Yes, sir.
Thank you. Any other questions? Any other questions? We're on the committee substitute. You're recognized for your motion, Senator.
I move that we adopt the committee sub.
All in favor signify by saying aye. Opposed, no. The ayes have it. We're on the bill, Senator. You're recognized.
Thank you, Mr. President. I also have an amendment at the appropriate time.
It is the appropriate time. We were just fixing to adopt it. So if you got an amendment, please submit it, sir.
And all the amendment is just we're just putting a reverse repealer in this bill so that you all will see it again and make sure that we all are okay with it. That's all this is.
Questions on the amendment to the bill? Your motion, Senator, to adopt the amendment?
If there's...
To adopt the amendment. Need the motion to adopt.
Motion to adopt the amendment.
All in favor signify by saying aye. Opposed, no. The ayes have it. We're on the final passage, Senator.
Thank you, Mr. President. I ask for a final passage based upon the morning roll call.
Anyone object to the procedure? We should be, of course, voting no. Present. Seeing none, the bill passes. Chairman Hill. We're on 128.
Like to call the bill up and have the title read.
Mr. Clerk, please read the title.
Senate Bill number 2913, counties, delete the duty of the clerk of the Board of Supervisors to report to the grand jury.
Make the usual motion.
All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Hill.
I'd like to ask Senator Wiggins to explain the bill.
Senator Wiggins, you are recognized to explain the bill.
Thank you, Madam Chair. This bill comes to us from the Chancery Clerks Association. Real simple. It deletes the requirement that they will go to jail if they don't appear before the grand jury. So if you want them to go to jail, vote against it. No, that's all it does. It's an antiquated law. They've asked that we pass that because actually they haven't done it in a long time, nor the question is even why should it be done. So,
questions on the bill? Questions on the bill? Seeing none, we're ready for your motion, Senator.
move passage on the morning roll call.
Anyone object to procedure? Wish to be recorded as voting no? Present? Seeing none, Senator Jordan, you're recognized. Bill passes. On Senator Jordan, you're recognized 129.
Senator Carter.
Up, Senator Carter, yes, sir.
Thanks, Mr. President. I'm asking to...
One moment, Senator Jordan. Senator Carter, you're recognized.
Unanimous consent from me and Senator Delano to be co-authors on that last bill.
Unanimous consent to the two. Anyone else? Jackson, England, Delano, Carter, Younger, McCon, Moran, Tate. Anyone else? Anyone else? Hill. Seeing none, seeing no objection, is granted. Thank you, Senator Carter. Senator Jordan, you're recognized 129.
Thank you, Mr. President. At the heel of the calendar, I'm asked that Senate Bill 2283 be called.
Correct. Please read the bill.
Read.
Senate Bill number 2283, Uniform Controlled Substances Act, revised schedules.
I make the usual motion.
Senator makes the usual motion. All in favor signify by saying aye. Opposed, no. The ayes have it. Please proceed, Senator Jordan.
Thank you. Thank you, Mr. President. This is routine. We do this each year, go through Schedule 1, 2, 3, 4, and 5. So what this does, all the drugs that are approved by the federal government for Mississippi and the health department to use those drugs, they have to be approved according to federal law. And that's all this bill does. Some drugs are placed in Schedule 1 in Section 4129-113 because these drugs generally have no legitimate medical use and have great potential to cause harm. So those drugs that cause harm are placed in Schedule 1. So Schedule 2, moving down, controlled substances are placed in Schedule 2, Section 41-29-115 when they have a currently accepted medical use, but a high potential of abuse that may lead to severe psychological or physical dependence. So those drugs that have a psychological and physical dependence, then they're placed in Schedule 2. They are medically used, can be used. For Section 3, or Schedule 3, there are no changes, not being amended this year. So we don't have anything under Schedule 3 this year. Schedule 4 and 5, Section 4129-119, 4129-121 are drugs that have a currently accepted medical use and a low potential for abuse. Those drugs on Section 4 and 5 have less chance for being abused. So some of them are used, those drugs The scientific names, if you care for them, is Rexan, which is used to treat insomnia, individuals who have difficulty with sleeping, and Mazolan, which is used for short-term anesthesia, putting people to sleep who's got to have surgery. Being part of the Schedule 4, simocobamate, which is used to treat seizures, and lamomedatan, which is used to treat acute migraines, are being placed on Schedule 5. So that does it in the summary of the new drugs that we will be using and it must be done according to federal scheduling status. So I will entertain any question you may have. If not, then I move that it be adopted by the morning roll call.
Senator Blunt, for what purpose you seek recognition?
Question, Mr. President.
You give Senator Jordan for a question?
Yes, sir, carry on.
Yeah, go ahead.
Thank you, Mr. President. Mr. Chairman, I just have one question. If we were to have this bill read, how many of these drugs would Mr. Lindsay need to recover from the reading of this bill?
How many would who need?
No, I'm just saying, I'm trying to read this bill, and it's just about too much for me, but I appreciate the bill that you brought forward, and I appreciate your good work, Mr. Chairman. Thank you.
Thank you.
Thank you, Senator Blunt.
I move to adopt by the morning roll call.
Senator England, for what purpose?
Quick question, Mr. President.
Yes, please proceed.
Senator Jordan, did you do all the research on this and make sure we're moving these drugs where we need them to go?
Your question is what now?
I just wanted to let you know I support the bill, Senator Jordan. Matter of fact, I'm going to consider adding myself as a co-author. Thank you.
Thank you. All right, we're ready for.
What we're trying to do is to conform to federal law. Each year that it changes and we get new drugs. So we have to reschedule those and let you know those that are dangerous, which have street names. And if you read the bill, you'll see a lot of street names there that I don't care to go through, because when you get to the chemical name of them, those are the ones that we have to watch for.
Okay, Senator Jordan. Thank you, Senator England.
So that's why we have to go through this each year.
Motion to use the morning roll call. Does anyone object to the procedure? Wish to be recorded as voting no? Present. Seeing none, the bill passes. Thank you, Senator Jordan. Senator Bryan, for what purpose?
Mr. President, I'd like to enter a motion to reconsider.
Please proceed.
I'd like to enter a motion to reconsider on item 2604, item 69 on yesterday's calendar, and then I would like to move that we do reconsider for the purpose of my offering a non-controversial amendment which has been agreed to by the chair.
Yeah, just one second. Have you got 2604, Mr. Clerk? All in favor signify by saying aye.
Aye.
Opposed, no. Okay, Senator, you're recognized.
Mr. President, this body earlier passed legislation authorizing 3 cities, Okolona, Holly Springs, New Albany, and Amory also, to offer broadband in the rural areas which don't have broadband now. The amendment I have is just the same bill, but it brings forward additional code sections so that we don't run afoul of the House rules about amending by reference. And if there are no questions, I move adoption of the amendment.
Mr. Clerk, would you please read the title? You read the title, Mr. Clerk, please, so everyone knows where we are.
Committee substitute Senate Bill number 2604, an act to create the Mississippi Broadband Expansion Act to define terms used in the act to create the Mississippi Broadband Expansion Commission for the purpose of reviewing applications for funding broadband infrastructure projects and making recommendations to the legislature of the project to be funded using federal and state funds, to provide for the members of the commission and to its powers and duties, to provide that the commission shall consider certain factors in making its recommendations, to require the commission to establish and publish on its website its criteria for competitively scoring applications, to to require an applicant to provide certain information at a minimum on the application, to require the commission to make preliminary recommendations, to require the commission to accept comments and objections concerning each preliminary recommendation, to require the commission to make its final recommendations to the legislature after considering all comments and objections and investigating them as needed and for related purposes.
Thank you. Senator Carter, you're recognized to speak on the amendment.
After the beating I took on the last bill, I'm just going to go ahead and go with Senator Bryan on this one.
Thank you, Senator. Thank you, Senator Carter. Senator Bryan, we're ready for your motion. We have a question. Senator Parker. Sorry, I didn't see your light. Senator Parker.
Just a parliamentary inquiry.
Please.
So we have held the bill on motion to reconsider. We brought the bill up on a motion to reconsider. Have we made a motion to reconsider the vote by which the bill passed, or do we need to make that motion before we proceed?
I entered a motion to reconsider, and I move that we do reconsider, and we voted to reconsider. That happened when I first came up here.
I don't recall that. I'm glad to go with that, but I don't recall that procedurally. That would be my inquiry.
I think we did, sir. Checking with the clerk, he said we did. All right, any other questions? Any other questions? Okay, Senator, now we're ready for your motion.
I move adoption of the amendment.
All in favor signify by saying aye.
Aye.
Opposed, no.
I suggest use of the morning roll call.
Use of the morning roll call has been requested. Anyone object to the procedure? Should record as voting no. Present. Seeing none. Thank you, Senator. Anyone else? All right, we'll go to announcements. Announcements. Any announcements? Senator Blunt. Senator Blunt, you're recognized for announcement.
Thank you, Mr. President. I would like to hold item number 64 on today's calendar, Senate Bill 2358, on a motion to reconsider.
2358, Mr. Clerk. Senator Wiggins, you're recognized for announcement.
Enter motion to reconsider on today's calendar, item number 60, Senate Bill 2231.
2231, Mr. Clerk. Senator England. Senator England, you're recognized for announcement.
Thank you, Mr. President. I ask for unanimous consent to be added as a co-author to item number 71 on today's calendar, that's Senate Bill number 2543.
2543. Anyone else? Anyone else? 2543. Seeing none is granted. Senator Parker, you're recognized.
Thank you, Mr. President. I'd like to have unanimous consent to be added as a co-author on item number 73, Senate Bill 2810, item number 105, Senate Bill 2077, and item number 125, Senate Bill 2261 on today's calendar.
2810, 20077, 2261, Mr. Clerk. Thank you, Senator. Senator Brang, you're recognized for announcement.
Thank you, Mr. President. I'd like unanimous consent to be added as a co-author to number 121, Senate Bill 2246. Thank you.
2246. Thank you, Senator Brang. Seeing no objection is granted. Senator Jackson.
Thank you, Mr. President. By unanimous consent, I'd like to be added as co-author to items 125, 2261, item 126, 2563, and item 129, 2283. 129, 2283. Thank you.
126 and 129, Mr. Clerk. We appreciate the Senate's hard work today on over 90 bills. Hopeful that we'll finish the Senate's work tomorrow and not have to be in on Friday. Senator Polk, you're recognized. I'm sorry, Senator Whaley.
Thank you, Mr. President. I'd like to hold Senate Bill 96, item number 96, Senate Bill 2504 on a motion to reconsider.
96 to the chairman. Thank you. Senator Polk.
I have an announcement, Mr. President.
Please proceed.
Junior page pictures will be made in the morning at 9:30 here in the chamber, and that will include the Senators Barnett, DeBar, England, and Thomas in their pages.
Thank you, Senator. Thank you, Senator. Okay, we're ready for your motion. Senator Polk.
Thank you, Mr. President. I move the Senate stand adjourned until 10 a.m. tomorrow.
Heard the motion. All in favor signify by saying aye. Opposed, no. Ayes have it. We stand adjourned until 10 a.m.
Yes, sir.